Lesson 7, the law with respect to crime and procedure. Crime and war, procedure. So we have the two laws under this chapter. One is a BNS, another one is what? BNSS. What is BNS? Bharatiya Nyaya Sanhita. What is BNSS? Bharatiya Nagarika Suraksha Sanhita. BNS replaced which act? IPC. BNSS replaced which act? CRPC. Criminal Procedure Code. Correct, right? Yes. So now tell me, BNS is a substantive law or procedural law? BNS is what law? Substantive law. BNSS is what law? Procedural law. But both deals with what crimes? Crimes. Deals with what? Crimes. Civil wrong or criminal? Criminal wrongs. Tell me which wrong is a wrong against the public? Criminal wrong is a wrong against the what? Public. Which one is a violation of rights of individual? Civil wrong. Which one is a violation of rights of the public? Criminal wrong. Where the remedy is compensation? Civil wrong. Where the remedy is punishment? Criminal. Clear with this? So let's discuss, let's revise the law with respect to what? Crime and procedure. Crime and what? Procedure. What is the first one? Jurisdiction of what? BNS. First of all, what is jurisdiction? The extent. What is jurisdiction? The geographical area or the subject to which what is applicable? Law is applicable. It is called as what? Jurisdiction. Tell me what is jurisdiction? The geographical area. What area? Are the subject matter to which the law is applicable is called as what? Jurisdiction. Called as what? Jurisdiction. So BNS has the intra-territorial jurisdiction as well as the extraterritorial jurisdiction. Correct, right? So when it comes to geographical extent, what extent? Geographical extent, it has the applicability within India as well as for few offences. It also has an applicability even beyond India. That is outside India. So jurisdiction of BNS. First of all, tell me what is jurisdiction? Geographical area or the subject to which what is applicable? Law is applicable. What is applicable? Law is applicable. So BNS has what type of jurisdiction? Intra-territorial jurisdiction as well as extraterritorial jurisdiction. They may ask this question in the examination. Define jurisdiction and also provide the intra-territorial as well as the extraterritorial jurisdiction of what? BNS. What is the intra-territorial jurisdiction of BNS, sir? BNS is applicable. What is applicable? BNS is applicable any offense. What offense? Committed within the what? Territory of India. What of India? Is the territory of India is defined in the Schedule 1 of the, not Schedule 1, Article 1 of the Constitution of India. What of India? So BNS is applicable for every offences which are committed within the what? Territory of India as defined as per the what? Article 1 of the Constitution. It is also called as what jurisdiction? Intra-territorial jurisdiction. What jurisdiction? Intra-territorial jurisdiction. Very good. Is there any exemptions from intra-territorial jurisdiction? Yes. What are they? First one, president or governors. No criminal proceedings can be initiated against the president or a governor during the term of their what? Office. So, but once they vacate their office, can there be a criminal prosecution? Yes. But during the time they hold that position of president or a governor, there cannot be what prosecution? Criminal prosecution. It means there is an exemption from what? From the jurisdiction of the BNS. Jurisdiction of what? BNS. To whom? President and governor. Second one, foreign sovereigns. What sovereigns? The one who represents the country. For example, President of USA is not subjected to the laws of which country? India. There is a sovereign immunity. What immunity? Sovereign immunity. A sovereign of a one country is not bound by the laws of which country? Other country. Correct, right? The foreign sovereigns. What sovereigns? Are exempt from what proceedings? Criminal proceedings. Below what proceedings? Criminal proceedings. Where? In India. The ambassadors, diplomats of the foreign countries. What countries? The ambassadors and also the diplomats of the foreign countries have the immunity under the what? BNS. Under the what? Who have the official status in India. What in India? Official status in India. The diplomats are the foreign ambassadors who are in India. So diplomats who are in India, they are exempted from what jurisdiction? Intra-territorial jurisdiction of the BNS. Clear with this? So who are the parties or who are the persons who are exempted from the intra-territorial jurisdiction of BNS? President and governors, foreign sovereigns, diplomats and ambassadors. Diplomats and what? Next one, we have extraterritorial jurisdiction. Means even if an offense is committed outside India, still BNS is applicable and the person can be punished in India. So that is called as what jurisdiction? Extra jurisdiction, extraterritorial jurisdiction. Laws made by a country that apply to the territories outside of their own country is called as what? Extraterritorial jurisdiction. The provisions of BNS shall apply even to an offense, even to what? Which is committed by any citizen of India. What of India? In any place without and beyond India. If you're a citizen of India, you go to foreign and commit an offense over there, comes back to India. Punishable, not punishable? Punishable. Tell me in India, bigamy is allowed or not allowed? There are few countries where bigamy is allowed. You go to foreign country, get married to one more wife, comes back to India. Punishable? Punishable. Punishable. Because you are a what? Citizen of India. What of India? If a citizen of India commits any offense, where? Without and beyond India. Bolo? Without and what? Beyond India. Punishable, not punishable? Punishable. Next one, any person on any ship or an aircraft registered in where? India, wherever it may be. If you are in the aircraft or if you are in the ship which is registered in India and having the flag of India, and are you punishable under BNS or not punishable? Punishable. इसको बोलते हैं admiralty jurisdiction. What jurisdiction? Admiralty jurisdiction. Any ship having the flag of India is deemed to be what territory? Indian territory. What territory? Irrespective of wherever it might be. It may be in the waters of US, territorial waters of US, but still, if any offense happens within the ship, it is considered as what? Punishable, not punishable? Punishable. Under what? PNS. Under what? The third one, any person in what place? Any place. Any person in what place? Any place without and beyond India. Below, without and what? Beyond India. That is outside India. An offense targeting a what? Computer resource located in India. इसको क्या बोलता है? What it is called as? Extraterritorial jurisdiction. First of all, repeat with me. What is jurisdiction? Geographical area or the subject to which what is applicable? Law is applicable. It is called as what? Jurisdiction. PNS as what type of jurisdiction? Intra-territorial jurisdiction as well as extraterritorial jurisdiction. What is intra-territorial jurisdiction? Any part within India. Any person commits any offense within the what? Territory of India. Territory of what? Is BNS applicable or not applicable? Applicable. Correct, right? What is extraterritorial jurisdiction? Any citizen of India without and beyond India. Punishable or not punishable? Punishable. Next one, any person on a ship or an aircraft registered in India. Any person without and beyond India but targeting a computer resources located in India. BNS is applicable or not applicable? That is called as what jurisdiction? Extraterritorial jurisdiction. Can you write in the examination? If they ask question about what? Extraterritorial jurisdiction. Well, what jurisdiction? Extraterritorial jurisdiction. Clear with this? BNS has both what jurisdiction? Intra-territorial jurisdiction as well as extraterritorial jurisdiction. Next comes stages of crime. What of crime? So a crime involves the following stages. What stages? Following stages. Tell me what is the first stage? Criminal intention. What intention? Second one, preparations. Third one, attempt. Fourth one, accomplishment. Fourth one is what? One more time. What is the first one? Criminal intention. Second one, third one, fourth one, accomplishment. Criminal intention. What intention? What is intentionally? What do you mean by doing something intentionally? Conscious exercise. What exercise? Conscious exercise of the mental faculties is called as what? Doing it intentionally. Doing it what? So doing any act with one's will or a desire or a voluntariness is called as what? Criminal intention. Follow what intention? Criminal intention. It is the first stage of commission of crime. We got one more point here. It is the first stage of what? Commission of crime. What do you mean by criminal intention? Doing any act with what? One's will, desire, or voluntariness. Could say on your own. or a conscious exercise of mental faculty. You know that what you are doing it and you still desire to act. That is called as what? Criminal intention. What intention? So conscious exercise of mental faculties is called as what? Criminal intention. Tell me, does law punish a person for having a criminal intention? No, because it is very difficult for the prosecution to prove the criminal intention. What intention? Criminal intention. You might be having an intention to kill CSR. Is it punishable? Not punishable? Not punishable because it is difficult to prove. What is your intention? You may have a good intention. You may have what intention? Bad intention. Correct, right? Yes or no? But what is the first stage of crime? Criminal intention. What intention? Criminal intention. Once a person forms the criminal intention, then what comes into picture? Preparation. The second stage of a crime. What stage of a crime? The second stage of a crime is what? Preparation. Below what? Preparation. Below what? Preparation means what? Arranging the necessary means to commit an alleged crime is called as what? Preparation. Called as what? I repeat, what do you mean by preparations? Arranging the necessary measures. You want to kill somebody, you buy weapons and keep it with yourself. That is called as what? Preparation. Called as what? So arranging the necessary measures. Keep these keywords in your mind. See, whenever you write answers, you need to use these keywords while elaborating the answer, writing the answers in the examinations. Correct, right? See, for criminal intention, the keyword is conscious exercise of mental faculties. Conscious exercise of mental faculty, one's will or desire. Then comes preparation. What is preparation? Arranging the necessary measures. Preparation itself is punishable, not punishable, not punishable. For example, you bought a knife. You may tell the court saying that, sir, I bought a knife to chop onions. It is difficult to prove that you have done the preparations for committing a crime, right? So preparation is not punishable. What is not punishable? Preparation is punishable, not punishable, not punishable. But are there any exceptional cases? Are there any exceptional cases where preparation itself is punishable? Yes, they may ask this question in the examination. First one, preparation to commit a war or wage a war against the war government. Wage a war against the war government. Now, I want to revolt against the state government. What government? State government. I'm preparing to wage a war against the government. I'm forming an association of students. I'm training them to go or revolt against the what? Government. Or to wage a war against the government. Is it punishable? Not punishable. Punishable. What if itself is punishable? Preparation to wage a war against the what? State or the government. Punishable? Not punishable. Punishable. Next one. Preparation for what? Counterfeiting the coins or government stamps. Harshad Mehta scam. What scam? Harshad Mehta scam. Huh? Telugu scam. What scam? Telugu scam. Sorry, not Arshad Mehta scam. Telugu scam. So I am preparing to counterfeit the coins or government stamps. What stamps? What is counterfeit? Fake notes or fake stamp papers. What stamp papers? Fake stamp papers. Preparation itself is punishable, not punishable. Punishable. Third one, possessing the counterfeit coins, false weights or measurements. What weights or measurements? False weights or measurements, and the fourth documents. What documents? If I possess the counterfeit coins, means fake currency notes or coins, or a false weights or measurements, or a false documents, punishable, not punishable? Punishable. Next one, making preparation to commit what? Dakaiti. Tell me, what is Dakaiti? When five or more persons commits a what? Robbery is called as what? Dakaiti. Called as what? Five or more persons comes with a weapon and chop the person into pieces and steal all the jewelry his wife had or all the jewelry from his wife. Is it called as robbery? Yes. Called as what? But it is also called as Dakaiti. Called as what? Why it is called as Dakaiti? It is done by how many persons? Five or more persons. Follow how many persons? Five or more persons. What is preparation? Arranging the necessary measures to commit an alleged crime. It is called as what? Preparation. Preparation punishable, not punishable? Not punishable. Are there any exceptional cases where preparation itself is punishable? Yes. What is the first one? Waging a war against the government. Second one, Telugu scam, counterfeiting the what? Currency notes and stamp papers. What paper? Stamp papers. Next one. Seizing the counterfeit coins and currency notes or false weights and measurement or false document. And the last one, making a preparation to commit what? Dakaiti. Bolo what? Dakaiti. one, attempt. Third one is what? Attempt. And third one is what? Attempt. The most important one. Most important one. When a person, after arranging the what measures, necessary measures, if he directly move towards the commission of a what? Crime. Directly move towards committing a what? Crime. That is called as what? Attempt. It is also called as preliminary crime. What crime? Which is also called as preliminary crime attempt. Correct, right? It is the what stage? Third stage. A direct movement of a person with the intent to commit a crime is called as what? Attempt. Called as what? Attempt. So attempt can be classified into how many categories? Four categories. Bolo, how many categories? What is the first one? Where attempt and accomplished offense are dealt under the same section number because there is the same punishment. What punishment? Same section number, same punishment. What punishment? Same section number, same punishment. That is the one category of attempt to commit a crime. Correct, right? There are few offenses which are dealt under the what section number? Same section numbers, and there is a same punishment. What are they? Offenses against the what? State, such as waging or attempting to wage a war against the what? Government of India. Same thing comes in the preparation also. Next one, assaulting or attempting to assault who? President or a governor with the intent to compel or restrain the exercise of what power? Lawful power. Sedition charges. Sedition is also what? Dealt under what? Same attempt as well as the accomplished crime. Next one, public servant accepting or attempting to accept what? Gratification, that is bribes. Next one, using or attempting to use the what? Evidence, knowing it to be false. And last one is what? Dacoity. Dacoity is common in both the things. Preparation to wage a war against the government. Dacoity, same in case of preparation as well as the attempt. So three more extra points here is assaulting or attempting to assault whom? President or governor. Then sedition, then public servant accepting the gratification or using or attempting to use evidence going to be what? False. So these are the offenses for which the punishment is same for attempt as well as the accomplished offense. The first category of attempt. Second one, completed offense and attempt dealt where separately under different section numbers. For example, attempt to commit murder, section number what? 109. And murder is what? Section number 103. Section number what? 103. Are you guys clear with this? So completed offense and the offense are dealt what? Separately. For example, murder 103, attempt to murder 109. Next one, attempt to commit suicide. Well, attempt to commit what? Suicide is dealt separately because suicide is not punishable by law. When a person is already dead, how can you punish him? But attempt to commit suicide, attempt to commit what? Suicide, compel or restrain from applying or restraining the lawful power. What power? If you attempt to commit a suicide with the intent to prevent a person from exercising the lawful power, for example, district commissioner want to acquire the property for a lawful purpose in a lawful way, but farmers are protesting and they are threatening him with the attempt to commit what? Suicide. Punishable, not punishable? Punishable. Next one, if there is no specific punishment for attempt, if there is no what punishment? Specific punishment for an offense, then section number 62 provides that offender shall be punished. Who shall be punished? Shall be punished with an imprisonment for what? Up to half of the maximum term of imprisonment prescribed for the what? Completed offense. What offense? Completed offense. Fine as given in the what? Offense are both imprisonment and fine. Imprisonment and the what? Fine. Are you guys clear with this? Yes or no? What is the provision? If there is no specific punishment for an attempt, he is punishable with a half of the maximum imprisonment and also fine or both. Next one, last stage. What is the last stage in a crime? Commission of a crime or accomplishment. Correct? It is the what stage? Last stage of commission of a crime. If the accused succeeds, when he directly moves towards commission of an offense, it is called as attempt. If he succeeds, accomplished. If he does not succeed, punishable for attempt. So these are the four stages. How many stages? Four stages of what? Crime. What is the first stage? Criminal intention. Are you what intention? Second one, preparation. Third one, attempt. Fourth one, accomplish. One more time. One more time. First one, criminal intention. Second one, third one, Attempt. Fourth one, accomplished. Attempt can be classified into how many categories? What are the four categories? Attempt and accomplished offense into the what section? Same section, same punishment. Third one, second one, different sections, different punishment. Third one, attempt to commit suicide. And the last one, specific no punishment is not given for an attempt, then what is the punishment? Half of the maximum imprisonment or a fine or both. Clear with this? Yes or no? Tell me, is preparation punishable, not punishable? But are there any exceptions where preparation is punishable? Waging a war against the government, fakes, counterfeiting the currency notes and coins and stamp papers, possessing the false weights and measurements, and forged documents, and the last one is preparation to commit what? Dacoity. Clear with this? Yes or no? Next one. Types of punishment. Types of what? They may ask question based on this. Which offenses are punishable? So where preparation itself is punishable. Clear? Next one. Types of punishment. Types of what? Punishment. The punishment can be of following types. What types? Arey bolo, what types? Following types. What is the first one? Death punishment. What punishment? Death punishment is the harshest of the punishment. It's what is death punishment? Judicial killing. What killing? Judicial killing or taking the life of the accused is called as what? Death punishment. What punishment? What is death punishment? It is the harshest of the punishment. Judicial killing of a person is called as what? Death punishment. If it is, it's imposed only in what cases? Rarest of the rare cases. What cases? Rarest of the rare cases. For which offenses? Give us an example. For which offenses the capital punishment is given? Nothing but death punishment is given. Severe offenses like murder. What is the first one? Second one, dacoity and murder. War against whom? Government. Abetting mutiny against whom? Government. Next one, giving or fabricating a false evidence to get a death punishment to whom? Innocent person. What person? Innocent person. Next one, attempted murder by life convict. What convict? If a person who has been convicted for the lifetime and in prison, if he tried to commit a murder, then is he punishable with life, sorry, death imprisonment, death punishment? Yes. Next one, mob lynching. What lynching? Have you heard about mob lynching, where group of people try to kill a person and it's called as what? Mob lynching. Next one, terrorism. Next one is what? Terrorism. Next one is what? Terrorism. Next one, organized crime. What crime? What is organized crime? Group of people, these scams, these Ponzi schemes होता है ना, Ponzi schemes, this chit fund, anti chit fund. It's an organized crime. What crime? Organized crime. Are what crime? Organized crime. Are you guys clear with this? What is the first? Double. Correct. Correct. That is organized crime. What crime? Organized crime. Are you guys clear with the first type of punishment? What is the first type of punishment? Concentrate everybody. What is the first type of punishment? Death punishment. It is given in what cases? Rarest of the rare cases. It is the harshest punishment. What punishment? Harshest punishment. What do you mean by death punishment? Judicial killing. What killing? Of whom? Person, the convicted person for the crime. It is called as what? Death punishment. It is also called as capital punishment. What punishment? Capital punishment. Next one is life imprisonment. What imprisonment? Life imprisonment. What imprisonment? Life imprisonment. It can be what? Rigorous imprisonment till the what breath? Last breath. If a person is sentenced till his last breath for a rigorous imprisonment, means with a hard labor, it is called as what? Life imprisonment. What imprisonment? However, after 14 years of imprisonment, the court may commute the sentence period to what? It may commute and may release the person based on his behavior. Next one is imprisonment. Next one is what? Imprisonment can be of how many types? Two types. First of all, what is imprisonment? Where a person is confined in the jail, prison. Correct, right? So imprisonment can be of how many types? Two types. What are the two types of imprisonment? Rigorous imprisonment. Second one is what? Simple imprisonment. With hard labor, it is called as what imprisonment? Rigorous imprisonment. Without hard labor, it is called as what imprisonment? Simple imprisonment. Or what imprisonment? Next one, forfeiture of property. What are property? Forfeiture of property. When the court deprives the right of a person over the property without for the commission of a crime, it is called as what? Forfeiture of property. What are property? Forfeiture of property in case of economic crimes. For example, money laundering or Benami transaction. What transaction? Benami transaction. Below what transaction? There is a concept of punishment by way of what? Forfeiture of property. What are property? Forfeiture of property. If you are having any Benami transaction, what is Benami transaction? What is Benami transaction? Holding the property in a fictitious name or some other person's name. Correct? Right? Benami means nameless. In that situation, what court can do? Order for forfeiture of property. What are property? Forfeiture of property. Yes or no? Next one, fine. What is fine? Forfeiture of money by way of what? Penalty for the violation of provisions of the law. What of law? Provisions of law. See, penalty is imposed for non-compliance of procedural aspect. Whereas for the violation of provisions of the law or contraventions of provisions of law, there will be what? Fine. There will be what? Fine is also one of the form of what? Punishment. Punishment. Next one, community service. What service? Important. What service? It is newly introduced. Tell me, is it a rehabilitative justice or punishment justice? Rehabilitative justice, where the law tried to rehabilitate the person who has done the crime. For example, let's say a person has done a petty crime. If you send him to jail, he will mingle with the persons who are already done the severe crimes. But they will not come out with what? Criminal offenses, correct? Right? So just to make sure that the one who has done a severe, like small petty offenses, should be given an opportunity to rehabilitate, to change. We have a concept of called as what? Community service. Community service is famous in US. Famous in what? US. It is recently introduced in India under which law? BNS. Under which law? BNS. For minor offenses. Well, what offenses? Like murder. Like what? Murder. So minor offenses like murder, there can be what? Community service. Agree? Array, murder is not a minor offense. It is a what offense? Severe offense. If you commit murder, what is the punishment? Death imprisonment, death sentence. What sentence? Death sentence. For minor offenses, give me example for minor offenses. Theft, defamation, these are what offenses? Minor offenses. For minor offenses, there can be what? Community service. It is a balanced and rehabilitative criminal justice. It promotes the rehabilitation. It is widely used in what? USA. Below. USA. Used where? USA. Next one, community service for offences under the what? Bharatiya Nyaya Sanhita 2023. Because it's newly added, there are more chances that the question may come out of this concept. First of all, tell me, whenever the word community service comes, you should write the word rehabilitative justice. What justice? It's a balanced and rehabilitative criminal justice. It is widely used where? In USA, but now it is introduced where? Even in India, because the Trump has visited what? India. So we are bringing this rehabilitative justice. What justice? Rehabilitative justice. For the following offenses, there can be what service? Community service as a form of punishment. In the form of what? Punishment. What is the first one? Involvement of public servant. In what trade? Illegal trade. What trade? For those public servants, that can be what service? Community service. What service? Community service. Next one, non-appearance in reference to what? Proclamation. Remember, proclamation of claimed offender. What offender? Attachment of property. If a proclamation is made and if the person does not appear, for that person, there can be what service? Community service. What service? Array below what service? Community service. For what offender? Proclaimed offender. Next one. Attempt to commit suicide. Attempt to commit what? To influence what authority? Legal authority. If you try to commit a suicide, you influence legal authority. For that offense, there can be what service? Community service. What service? Community service. Next one. First conviction of petty theft involving the property valued below how much? 5,000 rupees, and the property must have been what? Recovered. What must have been recovered? Property must have been recovered. Next one, public misconduct. What misconduct? By which person? Drunken person. Which person? So because RCB1 yesterday, a person is dancing on the street. He is drunk and he is dancing on the street and creating a ruckus on the streets. shouting at everybody. He's continuously shouting, saying that RCB, RCB, RCB. Can that person be arrested? Yes or no? Yes. And he can be sent to what service? Community service. He can be asked, or he can be made to clean the roads or sweep the roads. Correct, right? That is a what service? Community service. What service? Community service. Next one is what? Defamation. Next one is what? So can you guys write the offenses for which there can be a punishment in the form of what? Community service. What service? Community service. What service? Tell me, what are the forms of punishment? What is the first one? Death punishment. What is the first one? Second one, life imprisonment. Third one, imprisonment. Fourth one, forfeiture of property. Fifth one, fine, fine. Sixth one, community service. Which one is a rehabilitative justice? Which one is given in the rarest of the rare cases? Death punishment. What punishment? Tell me, in case of murder, what is the punishment? Death punishment. Defamation. Misconduct by a drunken person. What service? Two couples have There are two couples who are drunk and they are standing in a signal and dancing. They're hugging each other and they are dancing for a romantic song. It's all romantic song. Tell me, are they punishable? Not punishable. Is it a misconduct? Array, if you want to dance, go dance in your home, not in the what? Signal on the road. Correct, right? Is it punishable? Not punishable. What is the punishment? Papa, if you send them to jail, you are separating the two souls, right? That is not the punishment. What is the punishment then? They can be sent to what service? Community service. What service? Both are dance teachers. They can be made to teach dance to the orphan aged peoples or to somebody like where to the to someone in the schools or colleges, or they can be made to work in colleges. Correct. That is what service? Community service. What service? Community service. Police station. They'll teach dance to the police officer. Very good. Non-appearance in response to what? Proclamation. In response to what? Proclamations. Are you guys clear with? Are you guys clear with what? Community service. That is what service? Community service. Clear? So till now, what are the concepts we have discussed? Everybody. First one, jurisdiction. What is the first one? What is jurisdiction? Geographical area or the subject to which the law is applicable. It's called as what? Jurisdiction. What are types of BNS as what type of jurisdiction? Intra-territorial jurisdiction, extra-territorial jurisdiction. What are the stages of crime? What is the first one? Criminal intention. Second one, preparation. Third one, attempt. Fourth one, accomplishment. What is the fourth one? Accomplishment. Yes or no? Then we discussed what? Types of punishment. Types of what? What is the first one? Death. Second one, life imprisonment. Third one, imprisonment. Fourth one, forfeiture of property. Fifth one, fine. Sixth one, what service? Community service. I got fundamental elements of crime. Important, important, important. What is the first one? Human being. What being? So there should be an existence of what being? Human being. The offense must be committed by what? Human being. What being? See, earlier, even animals were punished. In the ancient days, if an animal commits a crime, means if let's say animal does a wrong, it enters someone else's property, they used to punish animals also. But now, as per the BNS or as per the IPC, there is no provision to punish the animals. Only who is punished? Human beings are punished because human beings are the one who is having menstruation. What we have? Menstruation. Correct, right? So the first essential element of a crime is human being. What way? Human being. Animals cannot be punished. Only human being under the legal obligation. What obligation? I'm capable of being punished. Capable of being what? Punished. This word is important. Why? Because an unsound mind. Hey, what mind? Unsound mind. Is it possible to punish an unsound mind? No. He's not capable of being punished. So only a person who is under legal obligation and who is capable of being what? Punished can be properly subject to what law? Criminal law. What law? Criminal laws. Are you guys clear with this? What is the first stage or first element of a crime? Human being. What being? What being? There should be a human being who is under legal obligation and who is capable of being punished under what? BNS. Under what? BNS. Next one, mens rea. Most important, most important, most important, mens rea. What is mens rea? Everybody, what is mens rea? One more time, what is mens rea? Guilty mind. The basic principle of criminal liability is what? Actus non facit rea nis mensit rea. Constitute a crime, there has to be what mind? Guilty mind. What mind? But for tort, there are exceptions where even if there is no guilty mind, it is considered as a tort. For example, strict liability, absolute liability, vicarious liability. What liability? Vicarious liability. But in case of crime, in case of what? Crime. What is essential? Mens rea. No mens rea, no crime. Without mens rea, can there be a crime? No. What is mens rea? Guilty mind. What mind? Guilty mind. Arre, what mind? The act alone does not amount to guilt. The act must be accompanied by what mind? Guilty mind. What mind? The intention and the act must both concur to constitute the what? Crime. Mental element necessary to constitute what? Criminal liability. What element is necessary? Mental element. Arre, what element? A mental element. Is it necessary? Not necessary. Necessary to constitute the what? Crime. Arre, sir, no. Then we have types of mens rea. What are types of what rea? What are types of mens rea? Intention, negligence, recklessness. I'll give an example. You guys should tell me which one is what. Tell me. If a person can foresee the consequences of his action and he desire those consequences, it is called as what? Intention. Conscious exercise. What exercise? Conscious exercise of mental faculties. It is called as what? Intention. If a person does something intentionally, is it called as a crime? Punishable, not punishable? Next one, if a person can foresee the consequences but does not desire those consequences, it is called as what? Reckless. But he takes the voluntary risk. What risk? That is called as what? Recklessness. If a person cannot foresee the consequences nor desires those consequences, but he failed to take the due care which a law requires him to take, it's called as what? Negligent. These are the three forms of what rea? Mens rea. If you are intent to do something intentionally, recklessly, negligently. Punishable, not punishable? Punishable. Because it is considered as what rea? Mens rea. What rea? Tell me, for a punishment for a crime, is mens rea required or not required? Everybody, mens rea is required or not required? What is mens rea? What might? Let's start. What is the first one? Intention. What is intention? Purpose or design with which the act is done is called as what? Intention. A person can foresee the consequences of his action and voluntarily desires those what? Consequences. Criminal intention. What intention? It also includes what intention? Generic intention. See, the intention can be specific or it can be what? Generic. For example, I mix a poison to the food to kill Darshan. It is called as what? Specific intention. Now, what if I mix the food? I have an intention to kill Darshan, but someone else eats it and he dies. Am I punishable? Not punishable. Because when I mix the poison, I am aware that if someone else eat that food, he may also die. So intention include what intention? Specific intention as well as what intention? Generic intention. What intention? So if a person does something intentionally, punishable, not punishable? Punishable. इसको क्या बोलता है? Mens rea. What rea? In case of mens rea, can a person foresee the consequences? Does he desire those consequences? That is called as what? Doing act intentionally. Then comes negligence. Then comes what? What is negligence? It is the second form of what rea? Mens rea. What rea? Not taking the care where there is a duty to take care. It is called as what? Negligence. Called as what? He can neither foresee the consequences nor desire those consequences, but fails to take the due care. What care? Of what man? Reasonable man. What man? That is called as what? Negligence. Well, that is called as what? Then comes the recklessness. Then comes the what? Recklessness. What is recklessness? He neither desire the consequences but foresee the possibility and consciously takes the risk. For example, drink and drive. What drive? Drink and drive. Do you have intention to commit accident? No. But you know that if you drink and drive, you will commit what? Accident. It is also called as what? Mens rea. What rea? Next one, exemptions from mens rea. Tell me, without a mens rea, is a person punishable, not punishable? It is not a crime at all. Generally, without menstruation, can a person be punished or not punished? Cannot be punished. But are there any exceptions where menstruation is not required? They may ask this question in the examination. Following are the cases where what is not required? Menstruation is not required. What is the first one? Statutory imposition. In the law itself, it is mentioned that for the offense under this particular act, menstruation is not required. Is it punishable? Not punishable. Punishable even if there is no what mind? Guilty mind. What mind? That is in the interest of what safety? Public safety and social welfare. For example, hotel industries. They did not have the intention to kill people. A lizard fell in the sambar and people drank the sambar or had food and they are dead. Is it lizard? Huh? Punishable? Not punishable. Did he had the menstruation? Papa he has taken everything. He was not negligent. He was not reckless. He was not. He did not do it intentionally. But still, is it punishable? Not punishable. Because in case of public safety, there is no requirement of what ria? Menstruation. What ria? Second one, difficulty in proving what? Menstruation. And penalties are what fines? Petty fines. What fines? If it is a petty fines in that situation, what is not required? Menstruation is not required. Next one, interest of what safety? Public safety. What safety? What is not required? Menstruation is not required. See, you are doing something on the road. You didn't have the intention of killing somebody. Something happened and the person is injured. Punishable, not punishable? Punishable. Next one, offense without what? Knowledge. Without having a knowledge of law, if you commit an offense, are you punishable, not punishable? Punishable. Because ignorance of law is no excuse. Are what is not an excuse? So in these cases, what is not required? Mens rea is not required. And what is not required? Mens rea is not required. What is the first one? Statutory imposition. Difficulty in proving mens rea, petty fines. Third one, interest of public safety. Last one, offense without knowledge. Other than these cases, is mens rea required or not required? What is mens rea? What is mens rea? Next one, exception to mens rea. What to mens rea? Exception to menstruation. Or the low concentrate. Next one, corporate body and menstruation. What ria? Can a company have menstruation? Is company is an artificial person, natural person? Why it is called as artificial person? Created by what? Law. Why it is called as legal person? It is artificial person because it is created other than by way of natural birth. It is called as legal person. Why? Because it is created by law. Law is the father of company. Who is the father of company? Law is the father of company, and it is an artificial person. Why? Because it is created other than by way of what? Natural birth. What birth? Natural birth. Clear with this? Now tell me, can company have menstruation? Yes. The menstruation of the alter ego. Who is alter ego of company? Board of director. Who is the alter ego of the company? Board of directors. The menstruation of the alter ego is imputed on the what? Company, and the company can be punished for the what? Crimes. Punished for the what? Obviously, company cannot be imprisoned. But however, there can be what? Punishment in the form of what? Fine. Yes or no? So corporations can no more claim immunity saying that they can't have a menstruation because the menstruation of the alter ego, that is the board of director, is imputed on what? Company. And company punishable, not punishable? Punishable. Read everybody. Person includes what? Company or association or body of person, whether incorporated or not. Companies are covered under the provisions of what? B and S. Under what? B and S. Criminal intent of the person or the group of person that guide the business of the company can be imputed on the what? Company, and company can be held responsible. And who can be held responsible? Company can be held responsible. Then comes actus rea. What rea? What is actus rea? Guilty act. What act? Overt act or unlawful omission done in carrying out the plan with a guilty intention is called as what? Actus rea. It's the result of voluntary human conduct which law prohibits. Who prohibits? Law prohibits. It is called as what? Tria, actus tria. These are the elements of a crime. Elements of what? Crime. Everybody, what is the first one? Human. So what are the elements of mens rea? Human being, mens rea, actus rea. What are the forms of mens rea? Intention, negligence, recklessness. In which cases mens rea is not required? Statutory imposition of duty, that it's difficult to prove mens rea and petty fine. Second one, public interest or public safety. And last one, offense without any. Can company be punished for crimes? Can company have mens rea? The alter ego's mens rea is imputed on the companies. Are you guys clear with this? Next, we have offenses against the what? Specific offenses. What offenses? Specific offenses. Are you guys ready? Shall we start? Are yes or no? Let's start. Let's start. Let's start. Before I go to the offenses, now tell me, let us recall whatever we discussed in the starting. What is the first topic? Jurisdiction. What is the first topic? They may ask question based on jurisdiction. What is jurisdiction? Geographical extent or the subject to which what is applicable? Law is applicable. It is called as what? Jurisdiction. BNS has how many types of jurisdiction? Two types of jurisdiction. What are they? Intra-territorial jurisdiction, extraterritorial jurisdiction. Is president and governor come under the inter-territorial jurisdiction after the vacation of their office? Yes. Next one, the stages of crime. What is the first stage? Criminal intention. Second one, preparation. Third one, attempt. Fourth one, attempt can be classified into how many category? Four category. Same punishment, same section, different punishment, different section. Attempt to commit suicide, and the fourth one is what? Communities. No specific punishment. Half of the imprisonment. Types of punishment. What is the first one? Death, life imprisonment, imprisonment, forfeiture of property, fine, community service. Public nuisance, public misconduct by drunken person, community service. What service? This point you will never forget. You'll write this point in the exam. That is why I gave that example, even though it is bit, no, understood? ठीक है? हाँ. And also this Telegi scam. What scam? Preparation itself is punishable. Correct, right? Next one, guys. Offenses. Offenses we already discussed in detail. So here I'm not going to discuss the imprisonment period. What period? Because it is very difficult to remember all the imprisonment period for all the offenses, right? I'll discuss the specific offenses. I will give the acronym. You guys should tell me the full form of the acronym. I DM the PCM. You know, I DM the PCM. Tell me what is I? Intentionally. D, dishonestly. M, movable property. Then P, possession. C, without consent. M, moves the property. What of the property? Moves the property. It is called as what? Called as what? One more time. I, D, M, the PCM. What is I? Intentionally. D, dishonestly. M, movable property. P, possession. C, without consent. And M, moves the property. He commits a what? Commits a what? Correct, right? Whoever what? Intentionally to take dishonestly possession of what? Any movable property from the possession of which person? Other person. Without his consent and moves that property, he commits the what? Theft. He commits the what? Theft. Let's start theft, bachcho. Let's start theft. Whoever, bolo, are bolo, ever intending to take what? Dishonestly. Any what property? Movable property. Bolo what property? Bolo what property? Movable property. Out of possession of any person without that person consent, moves that property to take such thing. He commits a what? Theft. Commits a what? Tell me, is immovable property subject to theft? Is it possible to move immovable property? No. Only one property, movable property. Next one, opening the tap for the purpose of taking the expensive liquid theft. It is also called as what? Theft. Attempt to commit theft. Even if you just open the tap of it, it means you have moved it. Correct, right? Unleashing a dog with the intent to steal it. It's also called as what? Theft. If you cause a dog to move by throwing biscuits to it, it is also called as what? Theft. Racer, no. Next one. Removing an obstacle or causing an animal to move. It is all called as what? Theft. Called as what? Theft. Are you guys clear with this? Next one. Snatching. What is the next one? What is snatching? Theft is a snatching if in order to commit the theft, the offender, suddenly and quickly, bolo, forcibly seizes or secures or grabs or takes away from any person from his possession any what property? Movable property. SQF. What is that? SQF. Suddenly, quickly, forcibly, you take the possession of movable property. That is called as what? Snatching. Theft is called as snatching when you do it suddenly, quickly, forcibly. Clear? Next comes extortion. What is extortion? If PVS, whoever intentionally put a person into a fear and causes him to or induces him to do what? Deliver any property or valuable security or anything signed or sealed which is convertible into what? Valuable security. He commits a what? Extortion. What is the important ingredient of extortion? Fear. A person is put into fear by one person with the intent to induce him, with the intent to what? Induce him to deliver to any person, any what property? Valuable, any property or valuable security or anything signed and sealed which can be convertible into what? Valuable security. He commits what? Extortion. Commits what? I put you into fear. I'll show you a gun and I say you should transfer all your property to me. Or if your ex-boyfriend or ex-girlfriend make a threat to you saying that if you don't transfer 1 lakh rupees to me, I will come and talk to your parents or I will disclose all the private conversations we had. Is it an extortion? अरे सालों punishable, not punishable? Punishable. Clear with this? Can you write about extortion, everybody? Are you guys clear with the concept of theft? Extortion, where there is a fear. SQF, snatching. If PV Sindhu, if PV Sindhu, extortion. Very good, Neha. If it is IDM, the PCM, theft. Next one. Robbery. A theft or an extortion can be robbery in two scenarios. How many scenarios? Two scenarios. When a theft is a robbery, see, simple. If you put a person a fear of death or a hurt or wrongful restraint while committing or attempt to commit a theft or taking away anything obtained by theft, if you put the person into what? If you cause or attempt to cause what? Instant to any person a death or a hurt or wrongful restraint or a fear of instant death or instant hurt or instant wrongful restraint. It is called as what? Robbery. Called as what? Either you cause a death or a hurt or a wrongful restraint, or you put a person into fear of instant death, instant hurt, or instant wrongful restraint. That is called as what? Robbery. When extortion is a robbery, if the offender at the time of committing the what? Extortion, committing the what? In the presence of a person, he puts in fear and commits the extortion by putting that person in the fear of what? Instant death, instant hurt, instant wrongful restraint to that person or to what person? Some other person. What person? So if the offender at the time of committing the extortion in the presence of the person, what of the person? If he is in the presence of the person and if you put him into the instant fear of death or instant hurt or instant wrongful restraint, that person, he or some other person, he commits what? Robbery. Extortion is called as what? Robbery. Theft is a robbery. While committing the theft, attempt to commit that theft, to take away whatever obtained by theft, you call the death of a person, hurt to a person, wrongful restraint to a person. Extortion is a robbery when a person, at the time of committing an extortion, in the presence of the person, what of the person? Presence of the person, and you put that person or any other person into fear of what? Instant death or instant hurt or wrongful restraint. Clear? Death, hurt, or wrongful restraint. DHW. Daily homework. What homework? Daily homework. Or what homework? Daily homework. If PV Sindhu does daily homework, what homework? Daily homework. It is called as what? Robbery. Called as what? Robbery. Extortion becomes robbery. If I DM the PCM, I DM the PCM for daily homework, that becomes what? Robbery. Becomes what? Robbery. I DM the PCM for daily homework. Robbery. If PV Sindhu does the daily homework, it is called as what? Robbery. Extortion becomes what? Robbery. Theft becomes a robbery. Extortion becomes the what? Robbery. Are you guys clear with this? Are yes or no? Instant fear of death, instant fear of wrongful restraint, instant fear of hurt. Then it is called as what? If a person put in if the person in the presence of other person, it put him into the instant fear of death or hurt or a wrongful restraint, it is called as what? Robbery. Extortion becomes what? A robbery. Are you guys clear with this? Everybody, yes or no? Understood? समझ में आ गया? Next one. डकैती. What is डकैती? 5 or more persons. बोलो. Who jointly commits what? Or attempt to commit a robbery. It is called as what? Dakaiti. Punishable, not punishable. Dakaiti, punishable, not punishable. Punishable. Severe crime. What crime? Severe crime. Next one. Criminal misappropriation of property. What appropriation of property? Criminal misappropriation of property. Simple, say simple. What appropriation of property? Criminal misappropriation of property. See, simple, say simple. Whoever dishonestly make use of the property of some other person or convert for its own use or part away with the property. It is called as what? Criminal misappropriation. What appropriation? Criminal misappropriation. Whoever does anything with the intention of causing a wrongful gain to one person or wrongful loss to whom? Another person. It is called as what? Dishonest. What is criminal misappropriation? Illegal use of property or a friend of not friend, funds of another person for one's own use or other unauthorized purpose. It is called as what? Misappropriation. Called as what? Misappropriation. What misappropriation? Criminal misappropriation. Are yes or no? Next one, dishonest. Punishable, not punishable. Are punishable, not punishable. So, for example, I found this remote in the classroom. ನಮ್ಮ ಮನೇಲಿ remote ಇಲ್ಲ. I don't have remote in the home. I'll take this. Use it in my home. Is it a theft or criminal misappropriation of property? Criminal misappropriation of property. What if by mistake I put it in my bag? By mistake, I don't know. Without my knowledge, I kept it in my bag without intention to steal it. I go home, I discover it, and I find it interesting, find it useful, and I start using it. It is called as what? Criminal misappropriation. What is misappropriation? Criminal misappropriation of property. Are you guys clear with this, everybody? Yes or no? Next one, next one, next one. Criminal misappropriation of a property possessed by what person? Deceased person. What person? Person is dead. Take his jewelry. Punishable, not punishable? Punishable. Next one, criminal breach of trust. See, the difference between criminal misappropriation of property and criminal breach of trust is that in case of breach of trust, you entrust the possession of the property to whom? To the other person, and the person to whom you have entrusted the property or have given a right over the property, he misuses it or uses it against your instruction or against the terms of the contract or against the terms of the law. Then it is called as what? Called as the criminal breach of trust. What breach of trust? Criminal breach of trust. I trusted you, but I gave this to you not to use it for a particular purpose, but you use it without my consent. It is called as what? Breach of trust. What of trust? Breach of trust. आपने धोखा दे दिया. You cheated me, not cheated me. You broke my trust. Broke my what? Trust. Are you guys clear with this? Yes or no? Next one is what? Receiving a stolen property. What property? I have a shop. There's a thief who steals all jewelries and comes and gives it to me. I pay him some nominal amount of money. Am I also punishable? Am I also punishable for what? Receiving a stolen property. These are the offenses. These are the what? Offenses against the property. Against the what? Property. What is the first one? What is the first one? Theft. What is the acronym? I DM the PCM. Second one? Snatching. S2F. Third one? What is extortion? Extortion. If PV Sindhu. Next one? Robbery. What is robbery? I DM the PCF to do the daily homework. Next one? If PV Sindhu does the daily homework, it is also called as what? Robbery. Then Dakaiti. Next one is what? Dakaiti. 5 or more person. Next one? Criminal misappropriation of property, unlawful purposes or other than the authorized purposes. Next one? Criminal breach of what? Trust. We use it for the purpose other than authorized by the contract or by the law or by the expressed instruction. That is called as what? Criminal breach of trust. What breach of trust? Criminal breach of trust. Next one, cheating. Cheating, cheating, cheating. Whoever by deceiving any person, the deception is important. What is important? Deception is important. Fraudulently, dishonestly induces the person to what? Deliver any property to whom? Another person. What person? Another person. Or give a consent that any person retains the what? Property, or intentionally induces the person to do or omit to do anything that they wouldn't otherwise do or omit, causing harm to the person in body or a mind or reputation or a property, is said to what? Cheat. A boy made a promise to the girl to marry her. Because of that promise, he, that's it. Is it a cheating if the boy does not or did not have the intention to marry her? Arey, no, yes, it caused harm to our body, right? Mental, mind, right? That is called as what? Cheating. Whoever, by deceiving any person, deceiving whom? Any person, fraudulently or dishonestly. Fraudulently and what? Dishonestly induces the person to deliver any property to which person? Another person. Or to give a consent that any other person retains the what? Property, or intentionally induces the person to do or omit to do anything that they wouldn't otherwise do or omit, causing harm to the person in body or a mind or reputation or property, is said to cheat. Said to what? Cheat. Is committing a cheating. Correct, right? Yes or no? Either you will induce a person to deliver something to the other person, or to give a consent retains the property, or you intentionally induce the person to do or not to do something which the other person will not do if there is no deception, causing the harm to the person in body, mind, reputation, or property. Clear with this? Understood? Cheating. क्या होता है? Cheating. Next one. Cheating by personation. Cheating by what? One person deceives the other by pretending to be someone else. Somebody comes and says, I'm CSR, and takes your consent to take law classes. It is called as what? Cheating by personation. He is acting like whom? CSR. But he is not what? CSR. Ikki piece is CSR. Yes or no? There is only one piece. Correct, right? Next one. Knowingly substitutes one person for whom? Another person. What person? Another person. For example, let's say Chirant is getting married in his community. In his community, there is a custom that the boy is not supposed to see the face of the girl until unless he gets married. Now what happens? So he has seen the girl before the marriage. Before the what? Marriage. During the marriage, he's not supposed to see the girl's face. The girl face is covered with what? Parda or burqa. But what happened? Because the girl did not have the she was not willing to marry Chiran. Because she was not willing to marry Chiran, what happened? The girl substituted another girl. What girl? Another girl. She substituted her friend. Impact player, yeah. She substituted an impact player for her. And without realizing that, without what? Realizing that Chirant got married after the marriage. He discovered that surprise, surprise, shock laga. Now tell me, is that girl punishable, not punishable? Punishable. Because there's a cheating by what? Personation. Cheating by what? Personation. What is substitute? I listen. Substituting one person for what person? Another person. For example, you are supposed to write the exam. So instead of you, I go to write exam. Punishable, not punishable? Punishable. Cheating by what? Personation. Next one, representing themselves or someone else as a person other than who they are. Somebody comes and say, I'm a police officer. Somebody comes and say, I'm a company secretary. RSGA. It is called as what? Cheating by what? Personation. Three cases. What is the first case? Pretending to be someone whom they are not. Second one, substituting one person to another person. Last one, representing themselves as someone else other than who they really are. That is called as what? Cheating by personation. First of all, what is cheating? Whoever with the intent to deceive, dishonestly and fraudulently causes a person to deliver anything to the other person or to give a consent, retains the property or induce a person to do something or not to do something which the other person would not do if there is no deception, and that will cause a harm to the body, reputation or mind of that person. It is called as what? Cheating. Called as what? Cheating. Next one. Concentrate. Next one, fraudulent deeds and disposition of what? Property. Are below what of property? Disposition of property. Removal or concealment of a property. Prevent the distribution among whom? Creditors. If a person with the intent of preventing the asset being available to the creditors, if he removes the property or sells the property, is he punishable or not punishable? Punishable. This is applicable if he does it without any what? Consideration. Without any what? Consideration. Section number this particular provision is applicable only when a person removes the don't talk. If a person removes the property or sells the property without consideration or with less consideration with the intent to prevent the assent, not assenter, asset being available to whom? Creditor. Available to whom? That is called as what? Criminal concealment of property. Next one, dishonestly or fraudulently. Fraudulently what? Prevent the debt being available for what? Creditors. Debt being available for what? If anybody prevents any debt or demand due to himself to any other person from being made available according to the law for the payment of his what? Debt. Other debts. Means there is some money due from other person. Because I don't want to pay it to you, I'm not recovering it. Is it punishable or not punishable? Punishable. Last one, dishonest or fraudulent execution of deed of transfer containing what statement? False statement of consideration. In the sale deed or agreement, if you mention a false consideration, what consideration? You are selling at 1 crore, but in the agreement to avoid stamp duty, you have mentioned only 10 lakh. Punishable or not punishable? Punishable. First one, you are removing the asset at a lesser consideration to prevent the asset being available to creditors. Second one, you fail to exercise the right to recover the asset available to you to intend with the intent to prevent the payment of what? Creditors. And the third one, what's the third one? If there is a document with false consideration are false conditions in the agreement. Punishable or not punishable? Punishable. These are the offenses with respect to what? Property. With respect to what? And with respect to what? Next one. Offenses with respect to documents and property. Documents and what? Are documents and what? Property marks. Property marks. Offenses with respect to the documents and what? Documents and property mark. What is the first one? Forgery. Arey bolo, what is the first one? What is forgery? What is forgery? Whoever makes a false document. What document? Or false electronic record with the intent to cause damage or injury to whom? Public or any person or to support any claim or title. For example, a person dies and he doesn't have, he's a bachelor and he dies as a bachelor without having any legal heirs. Now, some girl, random girl comes up and says she is the wife of that person who is dead, and for that purpose, she creates a fake document. Is she punishable or not punishable? A person is, he is dead, being a bachelor. How can she do this? Is it a forgery? Did she create a false document? Why did she create a, see, creating false document is not a forgery or a part समझो, provision समझो. Just creating a false document is not a forgery. But when you use that false document to support a claim or to cause a damage, injury to whom? Public or to any other person. For example, you create a photo with somebody to damage his reputation. Papa, that person has been never been to any pubs or any of the places. He has not touched any of the girl. But what you do, you create a fake picture. What picture? Fake picture with that person, and using that, you post that picture in what? Social media, and that is causing damage to the reputation of whom? Person. Did you create a false document here? Did you create a false document? And that is causing harm to the what? Public or to any other person. Punishable or not punishable? Punishable. A forgery. What jury? Forgery. Or to support any what? Claim or a right or a title. Next one, cause someone to part with a what? Property, to sell the property or enter into any contract or to commit a what? Fraud. Commit a what? Fraud. Then you commit say forgery. Creation of false document, not forgery. When you create a false document and use it to cause a harm to the person or the public or to support any claims or a title or cause harm to the property or to sell the property or to commit a fraud. It is called as what? Forgery. And what jury? Forgery. Next one, offenses with respect to what mark? Property mark. What mark? Any mark which is used to denote that property belongs to particular person. It is called as what? Property mark. What mark? What is the property mark of CSR? CSR. What is the property mark of CSR? CSR. That denotes whom? CSR. But is CSR is a movable property? No. Right, right. So property marks are used to denote what? Movable property, stating that it belongs to a particular person. What person? Provision. Whoever marks any movable property with a false property mark or uses a receptacle, that is container, with a false mark, punishable or not punishable? Punishable with the imprisonment of how many year? 1 year, or with fine, or with what? Both. Correct, right? These are the specific offenses. Then we have defamation. Then we have what? Defamation. Before I go to defamation, let's recall how much we could recall whatever we discussed till now. Let's recap. Correct, right? Tell me. Jurisdiction. What is jurisdiction? Geographical area, the extent to which what is applicable? Law is applicable. How many types of jurisdiction? What are two types of jurisdiction? Intra-territorial, extraterritorial. Stages of crime. What is the first one? Criminal intention, preparation, attempt, accomplished. Correct, right? Types of punishment. Death, life imprisonment, fine, forfeiture of property, community service. What's this? Then elements of crime: human being, mens rea, actus rea. What are the forms of mens rea? Intention, negligence, recklessness. Then offenses with respect to the property. What is the first one? Theft, snatching, extortion, robbery, dacoity, then criminal misappropriation of property, criminal breach of trust, then cheating, cheating by personation, cheating by what? Personation, then forgery and false property mark. What mark? False property mark. Yes or no? Are you guys clear with this? Next one, next one, next one. Defamation. What is the next one? Concentrate everybody. Defamation, defamation. Whoever, by what? Words, signs, or visible representation makes or publishes any imputation. What is imputation? Accusations or statement about another person intending to harm the reputation of a person. Simple, say simple. You make an imputation about some other person with the intent to harm his reputation or having a reasonable are reasons to believe that it may cause a harm or reputation of the other person. See, for example, you don't have an intention to harm the reputation of a person, but you know that it may cause a harm to the reputation of a person, and you still do it. Punishable, not punishable. For example, you guys want to do fun. What do? You mark a picture of a boy with a girl and you post it in what? Social media. You don't have, he's just a friend of yours. You don't have intention to defame because he's a friend. You just have the intention to prank him. But you also know that it may cause a harm to the reputation of a person and you do it. Are you punishable, not punishable? For what? Defamation. Because you had a reason to believe that it may cause harm to his reputation. I saw no. First of all, how defamation can be done? It can be done by words or by signs or by visible representation, and to do imputation about the person intending to cause what? Harm to the reputation of that person, or you have a knowledge that it may cause harm to the reputation of a person, or reasons to believe that that imputation will cause the harm of the reputation. It is called as what? Defamation. Called as what? Exception to defamation, concentrate everybody. Exception to what? Defamation. Following imputations made in what faith? Good faith. Or what faith is not called as what? Defamation. Not called as what? What is the first one? Imputation is trust and made for what good? Public good. Imputation made in good faith. What faith? And also what? True. It should be true. And made in what faith? Good faith. Defamation or a defamation? Defamation or a defamation? One more time. Imputation, which is true and made for the public good. You know that a girl is having an affair with somebody, and you start telling this to every colleague of yours in the office. Is it a defamation or a defamation? It's a truth, right? Exactly. It's not for the what good? Public good. Yes or no? If it is truth and made for the public good, it is allowed. For example, this politician's crimes. Correct, right? Next one, imputation in good faith. What faith? Concentrate everybody. Imputation in what faith? Good faith. Any opinion regarding the what? Conduct or character of what servant? Public servant. What servant? If you make any imputations on the conduct of the public servant, which is true, not a defamation. Next one, for example, politician does something in the public, which is true. Can you publish it? Yes, not a defamation. Next one, any imputation in what faith? Again, good faith. Any opinion regarding the conduct of what person? Any person with respect to public question or what issue? Public issue. Like with respect to public issue, what's your opinion? For example, somebody come and say, I support Pahalgam attack against that, and if you criticize him saying that no, that is not correct, you are a man, insane man, that you are saying all these things, is it a defamation? No, not a what? Defamation. Not a what? Defamation. Next one, opinion about the case or the conduct of what? Individuals involved in a case. If you pass a censorship on the witness given by a person or the conduct of a person in a case, will not be considered as what? Defamation. Next one, opinion about a good faith opinion about the merits of the performance. That is, the book or play or artwork. If you comment on CSR book saying that it is a good book, it is useful, that is not a defamation, that is an appreciation. Correct, right? Are sir, no. Next one. Or if you say the movie of CSR is not good, that is called as what? Not a defamation. It is not a what? Defamation. It's an opinion. In what faith? Good faith. What faith? Good faith. Person with lawful authority over the another criticize that person conduct in what faith? Good faith within the scope of authority. For example, parents can criticize their kids, or the teacher can criticize the kids. That's right. Next one. Accusation against any person. If you make any accusation against a person in what faith? Good faith. To a public officer. What officer? Is it a defamation or a defamation? Not a defamation. Imputation on the character of another, if made in what faith? Good faith. For the protection of what? Interest of the person, making it or for the public good. I say, don't give a loan to Payal because she'll never repay it back. Because she already taken 1 lakh rupees from me and she has never returned it back. Is it a defamation? No, she has done this. Not a defamation. Correct, right? Next one, conveying the caution in what faith? Good faith. To one person against which person? Another person. These are not called as defamation. Not called as what? Defamations. Exception to defamation. Kinds of defamation. There are how many kinds of defamation? Libel and slander. Visible form, libel. Permanent form, libel. Permanent form, libel. Transient form, slander. Temporary form is called as what? Slander. General exception for the crime. In the following cases, an act of a person is not considered as a crime. Is it punishable? Not punishable. Not punishable. What is the first one? The following are not considered as what? Crime. And the person is punishable, not punishable. Not punishable. What are they? What is the first one? Act done by a person bound or by mistake of fact, believing himself to be what? Bound by the law. If a person is bound to do something as per the law, and if it does it, is it a crime? Punishable, not punishable? Not punishable. Second one, act of a judge. What of a judge? Acting what? Judicially. In what faith? Not a crime. Even if you send a person to jail, or person send a person for a death penalty, is it punishable? Not punishable. Not punishable. Next one, act done pursuant to a judgment or order of court. I was following the order of the court. Is it a crime? Is it a crime? No. Next one, act done by a person justified or by mistake of fact, believing himself what? Justified by law. If a person does believing that he is justified by law, is it a crime? No. Next one, accident doing what act? Lawful act. What act? Lawful act. While doing a lawful act, you commit an accident. You are driving properly with all precautions. Accident okay. Are you punishable for a crime? No, because there is no what here? Mens rea. What here? Mens rea. Next one, act likely to cause harm. Concentrate. Act likely to cause the harm, but done without what intent? Criminal intent. And to prevent which harm? The other harm. Which harm? For example, you are in a like from Rajinikanth robo and saves the girl, harm caused, but with the intent to prevent the other harm. It is not called as a what? Crime. Next one, act of a child under how many years of age? 7 years of age. Next one, any act of a child above 7 years, but below how many years? 12 years. Immature of understanding, not a crime. Next one, act of a person of what mind? Unsound mind. And what mind? Next one, act of a person not intended, a act of a person incapable of judgment. Incapable of what? Judgment, and he has been intoxicated against his will. Against his what? Will. Next one, act not intended and not known to be likely to cause a death or a grievous hurt done by what? Consent, because voluntary non-fit injury means one who voluntarily cannot be injured by any other person. Act not intended to cause a death done by consent. In what faith? Good faith. For whose benefit? Person's benefit. Act done in good faith for the benefit of what? Child. or a person of unsound mind or by consent of whom? Guardian. See, operations, treatment done with the consent. Next one, consent known to be given under the what? Fear or misconception. Then it is not called as a valid excuse. Correct, right? Only if it is a free consent, it is an excuse. Next one, exclusion of acts which are offenses independently of what cost? The harm cost. There are few offenses where even though there is no menstrual is punishable, right? Then these exceptions are not applicable. Next one, act done in what faith? Good faith for the benefit of person without his what? Consent. Accident victim to save him, you did something. Is it an offense? No. Next one, communication made in what faith? Good faith. Doctors inform the patient that he is having some disease. After hearing this, he is dead. Is the doctor punishable? Not punishable. Not punishable. Act which person is compelled by what? Compelled by what? Threat. For example, what if somebody, listen, someone enters the class with a knife, not knife, with a stick in his hand. Huh? A stick in his hand and comes and say, you should kill CSR, otherwise I will hit you with this stick. Because of this threat, you had a knife in your bag, protect yourself. That knife out and you killed CSR. Are you punishable? Not punishable. Why not punishable? Because of that threat. Correct, right? Because somebody made a threat to you and killed CSR by using a knife. Neha, he was just using a stick. You can kill the other person only, na? Why are you killing me? Why killing CSR is an easy option. You can do self-defense, right? And hardly is having a stick. No, but he said I will kill CSR. Understood? And stick is not a danger. So what if he comes with a gun? Keeps you at a gunpoint and then say you kill CSR, then only I will let you go. Because of that, you killed CSR. Are you punishable? Not punishable. Not punishable. Then who is punishable? One who made that threat is punishable. Next one. Act causing a what? Slight harm. What harm? Slight harm. Act causing the what? Slight harms. What harms? Slight harm. Petty offenses. Not considered as an offense. Like if you just touch a person or push a person by mistake, it is not considered as a crime. Okay? Next one. Right to what defense? Private defense. What defense? Whatever the act done in a private defense, is it an offense or not an offense? Not an offense. Not a what? Everybody, an act done in a private defense. Is it an offense or not an offense? Not an offense. Every person has a right to defend his own body as well as a property, as well as a what? Correct, right? Either his own body or body of any other person against any offense affecting the what? Human body or the property, whether movable or immovable, of himself or any other person against theft, robbery, mischief, or criminal trespass. You have a private defense. What defense? Private defense. What is the first one? Private defense is not available against the act of the following. Important. And they may ask in the examination, what is private defense? Against whom the private defense is not available. Who is the first person? Public servant acting in what faith? Good faith. Within their what capacity? Official capacity. What capacity? Even if their act not in strictly justified by law, as long as it does not cause a apprehension of what? Death or grievous harm. Only when you have an apprehension that the act of the public servant or a person who is acting with the public official capacity may cause a death or a grievous harm, then you can take a private defense. Against whom? Public servant. Second one, person follows the direction of what servant? Public servant. In what faith? Good faith. Unless you have an apprehension that that person acting in the direction of the public servant may cause a what? Death or a grievous harm. Next one, if there is a time to seek what? Help from the public authority. What authorities? Public authorities. In these three cases, what cases? If there is a time to seek what? Help. From whom? Public authority. First one is what? Private defense is not available against the actions of whom? Public servant or anyone acting under the authority of the public servant, or time if there is a time to seek the help of whom? Public authorities. What is not available? Private defense is not available. Correct, right? Private defense is available even against whom? Unsound mind person. What person? Unsound mind person. Correct, right? This topic is most important. A right to private defense of body extend to causing the what? Death. Means he can cause the death of a person to defend your body in the following cases. They may ask, write a short note or explain what against what offenses a right to private defense extends causing a what? Death. Extends to causing a what? Death. What is the first one? Assault. Below. In all these cases, assault that reasonably causes the fear of what? Death. Fear of what? Death. Somebody is hunting. Somebody is hunting. Remember, I gave this example. For example, let's imagine CSR is fighting with whom? CSR is fighting with a villain. Give an example of villain. Darshan is a villain. No? Villain, film actor, villain. Any film, Sai Kumar. Okay. CSR. CSR. Fighting with Adira. Okay. CSR fighting with whom? KGF, Adira. CSR is now badly injured. Badly what? Injured. Now he's lying on the floor. Lying on the what? Floor. He's badly injured. Not injured, badly injured. All his hands and legs are like twisted, and now he's lying motionless. Motionless. Suddenly his song, a background music start playing. So because of that background music, he recalls some memories. He gets some imagination in his head, and he gets some thoughts in his head. Suddenly he wakes up, and suddenly what? When the Adira was about to strike, like about to strike with his sword, wakes up, CSR wakes up, holds his hand, and he kills whom? Adira. Kills whom? Adira. Is CSR punishable? Not punishable. Not punishable because it is a what? Self defense. What defense? A private defense. What defense? A private defense. Any assault, a assault that reasonably causes the fear of death. What of death? The fear of death is not a against that. You have a private defense even to causing a death of the other person. Assault which reasonably causes the fear of death. Second one, assault that reasonably causes the fear of grievous harm. Next one, assault with the intention to commit a rape. Next one, assault intended to gratify the unnatural lust. Assault with the intent to kidnap or abduct. Next one, assault intended to wrongfully confine a person. Person throws or attempt to throw acid, causing reasonable fear of what harm? Grievous harm. All these cases, a private defense extend to even causing a what? Death of a person. What of a person? Death of a person. ಅರ್ಥ ಆಯ್ತು? What are those? Fear of death, fear of grievous harm, rape, unnatural lust, kidnap or abduction, wrongfully confined, throwing a acid. Throwing what? Acid. Correct, है ना? This law is very much essential. It's recently introduced, right? In these cases, a person as a private defense can kill the one person, other person. Right to private defense of property extend to causing the what? Death in the following cases. What cases? Following cases. In case of person committing what? Robbery. Committing what? You can cause the death of a person. Second one, house breaking after sunset before what? Sunrise. Mischief by fire or what? Explosives. and the theft, mischief, or a trespass with a serious threats. What threats? In all these cases, the private defense extend even causing a what? Death of a person. What of a person? Death of a person. With these, we have covered the PNS. Covered what? PNS. Bharatiya Nagar Nyaya Sanhita. Which year? 2023. Tell me, if act done in a private defense, what defense? Tell me an act done as a private defense. Is it a crime? Punishable, not punishable? Is the private defense available against the act of the public servant unless there is a fear of death or grievous hurt? Now tell me, is the private defense available if you have an opportunity to seek the help of the public authority? Available, not available? Not available. Correct, right? Theft is punishable, not punishable. I DM the PCA is what? Theft. If PV Sindhu, extortion. I DM the PCM to do the homework, daily homework. It's called as what? Robbery. Correct, right? I create a fake document to support a claim. It's called as what? Forgery. If with the intent to deceive, I make a person to give a consent, and that will cause a harm to his body, reputation, or property. That is called as what? Cheating. Called as what? Cheating. Called as what? Cheating. Imputation made. What made? Are below what made? That may cause a harm to the reputation of a person. That is called as what? Defamation. Called as what? Are you guys clear with PNS? Everybody? Yes or no? Anybody has any question about PNS? No question, no questions, no questions. So let's start with what? Bharatiya Nagarika Suraksha Sanhita. Which year? 2023. Make some noise, guys. Which chapter? Bharatiya Nagarika Suraksha Sanhita. 2023. Is it a procedural law or substantive law? It provides how to bring a person to justice, how a person is punished, how the complaint is filed, how the hearing happens, what is a cognizable offense, non-cognizable offense, warrant, bail, non-bailable offense, bailable offense, and summons. All these things we're gonna discuss under the word Bharatiya, Nagarika, Suraksha, Sanhita. Let's start. Definition. What is the first one? Cognizable offense. What offense? What is cognizable offense? Police officer can arrest with warrant or without warrant? Without warrant. What is non-cognizable offense? No authority to arrest without what? Cognizable offense, police can arrest without warrant. Non-cognizable offense, police cannot arrest one without a warrant. Next one is bailable offense. What offense? Any offense which is bailable in the first schedule. What schedule? First schedule to the Sanhita, or which is made bailable by any other law. It is called as what offense? Bailable offense. What offense? What is non-bailable offense? Non-bailable offense is an offense other than what offense? Bailable offense. Bail is not a matter of right in case of what offense? Non-bailable offense. What offense? Non-bailable offense. Murder is bailable, non-bailable. Atrocities against SC/ST is bailable, non-bailable, non-bailable. Killing wild animals, bailable or non-bailable, non-bailable offenses. Are you guys clear with this? Power of the court to pass sentence means imprisonment. So different judges has a different authority for passing the what? Sentence, imprisonment, correct, right? First one, High Court judge. What judge? High Court can pass what sentence? Any sentence authorized by law, including what punishment? Death punishment. Next one, session judge. Session judge. What judge? An additional session judge can pass any sentence, but a sentence of death requires a what? Confirmation of the High Court. Confirmation of what court? Next one, sentence which magistrate can pass. Who can pass? And we know that, right? We have judicial magistrate, executive magistrate, correct, right? So judicial magistrate, what magistrate? Chief judicial magistrate can pass any sentence except what? Death sentence, life imprisonment, and imprisonment or a term exceeding how many years? 7 years. Up to 7 years, can he pass imprisonment? Yes. He can impose any fine? Yes. Life imprisonment? No. Next one. Court of magistrate of which class? And what class? He can pass any imprisonment up to how many years? 3 years. Fine of up to how much? 50,000 rupees. How much? Can he impose death punishment? Imprisonment more than 3 years. Fine of more than 50,000. Next one. Magistrate of which class? Second class. Up to how many year? 1 year. How many year? Fine of how much? 10,000 rupees. How much? Are both are a what service? Community service. Community service anyone can give. Starting from the High Court. Starting from the what? High Court. Are you guys clear with this? Power to pass what? Sentence. Power to pass what? Sentence. Next one, sentence of imprisonment in case of default of fine. See, if a person fails to pay the fine imposed, the court may order the person to serve the additional imprisonment. What imprisonment? Additional imprisonment for failure to pay the what? Fine. इसको बोलते हैं default imprisonment. What imprisonment? Default imprisonment. Concentrate everybody. A fine imposed on an accused, and if it is not paid, he can be imprisoned for a term. In addition to the what? Substantive imprisonment awarded, provided the term shall not be what? Shall not be in excess of the powers of whom? Magistrate. Powers of whom? It cannot exceed one fourth of the what? Total imprisonment the magistrate can give for the what? Offense. It should not go beyond how much? One fourth. If the magistrate can pass up to 3 years of imprisonment, it cannot impose more than one fourth of 3 years for default fine. What fine? Default in payment of the fine. Are you guys clear with this? Next one. Next one. Sentences in case of convictions for several offenses. What offenses? Several offenses. Tell me, can a person be punished twice for the same offense? Can he be punished for different offenses? Can he be convicted for multiple offenses? Yes. If a person is convicted for multiple offenses, in that situation, the court may order that the sentence either it will run parallelly or one after the other. That who will order? Court will order. A person is convicted for kidnapping, murder. Court has given 3 years for kidnapping, 3 years for murder. Court may say both the imprisonment either runs parallelly, means he will be jailed for only how many years? 3 years. Or court may say one after the other. Clear with this? Let's start. The person is convicted of two or more offenses. The court can impose a punishment for each of the offense. Each of the what? Offenses. The court can order that imprisonment sentences for each of the offense be served one after the what? Other. In a sequence, the court specifies. Alternatively, the court can order that sentences run at the what time? Same time. That is concurrently. Punishment imposed must adhere to the limit specified under section number what? 9 of the BNS. What of the BNS? 9 of the BNS. Are you guys clear with this? Everybody, yes or no? Darshan, magistrate of first class can pass imprisonment up to how many years? How many years? 3 years. Second class, 1 year. Fine of how much? 10,000, 50,000. 10,000. Can a session judge pass death punishment? Yes. But that requires confirmation of whom? High Court. Can you answer if they ask question based on this in the examination? Yes or no? Next one. Next one. Next one. Next one. Inherent powers of whom? High Court. Which court? Arey bolo which court? Do High Court has the inherent powers? Yes. This is also gives the High Court a quasi-judicial functions where High Court can frame the rules for the purpose of abuse of justice and delivery of justice. Delivery of what? Justice. Like how we discuss civil court has inherent powers. In the same way, for the purpose of delivery of justice, which court has the inherent powers? High Court has the inherent powers. High Court can make such orders as may be necessary to give the effect to what? Any order of BNSS or to prevent the abuse of what process? Court process are to secure the ends of justice. The powers under section number 528 are partly what in nature? Partly what in nature? Administrative in nature and partly what? Judicially. Why? Because if the lower court exceeding their jurisdiction or acting irregularly can interfere, High Court can interfere. Or if the police have registered an FIR in a wrongful manner, who can quash the FIR? High Court. Under which section number? 528. 528 gives the power to the High Court to make an order to prevent the abuse of justice and to secure the ends of justice. It is partly administrative in nature and partly what in nature? Judicial in nature. What in nature? Judicial in nature. Court can always take note of any miscarriage of justice. What carriage of justice? Miscarriage of justice, and prevent the same by exercising the power under which section number? 528 of what? PNSS. Clear? Understood? Next, we have arrest of a person. What of a person? Everybody, what of a person? Arrest of a person. Tell me, can a person be arrested? Tell me in what cases? Let's say CSR. He has committed an offense. Or tell me in what and all cases a CSR can be arrested without warrant. First of all, what is arrest? Uh, Taking the person into what? Custody. By the word police officer taking the person into custody to detain him, to answer the criminal charge, and to prevent him from the commission of what? Criminal offense. It is called as what? Arrest of a person. Tell me, can a person be arrested without warrant? Only if it what offense? Miserable. What offense? I will give an example. You guys will tell me whether I can be arrested or not, cannot be arrested. Let's say there is a complaint. You are a police officer. What officer? Are what officer? You guys are police officer. A lady comes and gives a complaint against whom? CSR, saying that CSR has killed her husband. She comes and give a complaint. Tell me, can you arrest CSR with warrant or without warrant? Why without warrant? Because it's an offense which is punishable with more than how many years? 7 years. How many years? 7 years. Warrant is necessary. Even if it is cognizable offense, you should not arrest a person if it is punishable with less than how many years? 7 years. We can arrest a person in that situation only when there is a reasonable complaint, a reasonable suspicion, or credible information that the person has committed the offense, and that too to prevent the person from destroying the evidences or further from tampering with the evidences, or to prevent him from committing the what? Further offense. What offense? Further offense, or to make sure that he appears before the court whenever is required. If an offense is punishable up to how many years? 7 years. How many years? If an offense is punishable with more than 7 years, once a complaint is received, a reasonable suspicion exists, a reasonable complaint has been made, can the police officer arrest? Yes. If it is more than how many years? 7. Below 7 years or less, you have to record the reason for arrest. What for arrest? What for the arrest? Reasons for the arrest. Correct, right? And what if I commit an offense in the presence of police officer? Can you arrest the person without a warrant? Yes or no? What is the first situation? Everybody concentrate. When a person can be arrested without a warrant, make some noise, guys. Make some noise. Are you guys ready? When a person can be arrested without a warrant, what is the first one? Who commits in the presence of police officer a cognizable offense. What offense? Cognizable offense. Second one, against whom a reasonable complaint has been made. Bolo? Reasonable complaint has been made, credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense punishable with an imprisonment for a term which may extend up to how many years? 7 years or less. If the following conditions are satisfied, he has a reason to believe that such person has committed the said offense. The police officer satisfied that such arrest is what? Necessary to prevent the person from committing what offense? Further offense, or for proper investigation, prevent the person from disappearing with evidences, or to prevent the person from making inducement or threat to the what? Witnesses, or to ensure the presence of the person in the what? Correct, right? Now, what if a person is accused of an offense punishable with more than 7 years? and there is a credible information or reasonable suspicion, can a person be arrested with warrant or without warrant? Next one, a person who is a proclaimed offender. What offender? Are what offender? That is, if any person who is proclaimed as an offender by the court, we will discuss when a person can be proclaimed as an offender, then he can be arrested. Next one, any person found to be in possession of what? Stolen property. What property? Next one, anyone who obstructs whom? Police officer, execution of duty. Next one, who is suspected of deserter of what? Armed forces. Next one, committed an offense beyond India, but he can retain where? In India for the commission of offense outside India. Last one, any person who is being a what? Released convict. What convict? Commits a what? Breach of any rule. Breach of any what? Rules. Any requisition, whether written or oral, has been received from which person? Another police officer. What police officer? However, if a person is more than 60 years, how many years? 60 years, correct, right? Above 60 years, Sasti Purti Agide. If he is above 60 years, Papa, he should not be arrested. He should not be what? Arrested. If he is accused of an imprisoned offense, punishable with less than how many years? 3 years. Without whose permission? DSP permission. Whose permission? DSP permission. Who cannot be arrested? Person is above how many years? 60 years. If he is accused of an offense, punishable with less than how many years? 3 years. Without whose permission? TSP permission. These are the cases where arrest can be made without whose power? Whose approval? Where police can arrest without what? Warrant. Without any warrant. Warrant. Correct, right? Arrest without warrant. Arrest without what? Warrant. Next one. Certain measures to be followed for making an arrest for an offense punishable with how many years? 7 years. Or less than how many years? 7 years. If you have received a complaint against a person punishable with less than 7 years, you have to first give a notice to the person, appear before you and answer the question. If a person complies with the terms of the notice, appears and answer, you should not arrest him. But if you want to arrest him, even when he appears, you have to record the reasons for the arrest. What for the arrest? Reasons for the arrest. Clear with this? Next one. Procedure for what? Procedure for what? Arrest. Anyone who arrests a person should display their name in a what form? Visible and accurate manner. The police officer making the arrest must prepare a what? Memorandum of arrest. What of arrest? Attested by whom? One witness, a family member of the person arrested, a respectable person from the locality. Police officer must inform the arrested person. They have a right to inform a relative or a friend or any other person by name. Any person who is arrested and interrogated by the police has a right to meet a what? Advocate of their choice during the what? Interrogation. Have I discussed the concept of arrest of a person on refusal to give a name and residence? Yes or no? If a person commits a non-cognizable offense, what offense? Obviously, police cannot arrest him, but the police can take this name and address. If he refuses to provide the name or provides the wrong details, he can be arrested to ascertain the what? True name and address. Correct name and what? Address. Once the name are ascertained, he should be released. He should be what? Released. What if the true name could not be ascertained? Within how many years of time? 24 hours of arrest. Or if the person fails to execute the bond or a what bond? Bail bond. But if he is a foreign person, what person? There should be sureties who are resident of India. Correct, right? Or if he fails to provide sureties, what should be done? He should be forwarded to where? Nearest magistrate. What magistrate? Once you ascertain the name, he has to be released either by a bail bond or by a sureties. Or by what? Sureties. The last question in the examination. When a person can be arrested, who can be arrested? Person can be arrested for refusing to give a name and residence. Name and what? Residence. Name and what? Right. Resident. Next, we have arrest by a private person. What person? Tell me, can a private person arrest? It is the duty of the police officer to arrest. Generally, private person cannot arrest. Are there any exceptions? What is the exception? Anyone commit a non-bailable and cognizable offense in the private person's presence, or he is a what offender? Proclaimed offender. These are the two cases where who can arrest? Private person can arrest. What is the first one? Non-bailable and cognizable offense in the private person's presence, or he is a what offender? Proclaimed offender. Or after making the arrest, the private person without unnecessary delay, but within how many hours? 6 hours. Hand over the person to what officer? Police officer. Or take him to what station? Nearest police station. Arrest by what person? Private person. It's clear? Next one. Arrest by magistrate. See, if any person commits an offense in the presence of a magistrate within his jurisdiction, can arrest, magistrate can arrest, or he can order for the arrest. Order for the what? Arrest. Order for the what? Next one, arrest, how it is made. How the arrests are made by a person. Made by whom? The police officer, correct, right? First point, important, important, important. How the arrest should be made. What is the first point? Police officer. What officer? Or the person making an arrest can actually touch and confine the body of the what? Person to be arrested. He can touch and confine the person to be arrested. So is how we will arrest him. If the person resists the arrest or attempts to evade the arrest, the police officer or person making the arrest may use what force? Necessary force. What force? Necessary force. The effect the arrest. The arresting person has no right to cause the what? Death unless the person has to be arrested is accused of an offense punishable with what? Or life imprisonment. Next one. Handcuffs may be used for the arrest if the person is an habitual offender or has committed a serious crime. What crime? Murder, theft, robbery, rape. Or he has escaped a what? Custody before. What before? Custody before. A male police officer shall not touch the woman's body unless absolutely necessary. Women cannot be arrested after the sunset and before the sunrise unless there are exceptional circumstances. Correct, right? And the next one is the arresting officer. What officer? Must obtain the what permission? Written permission from the first class magistrate before the arrest of a woman after sunset and before the sunrise. Before the what? And these are the provisions with respect to how the arrest should be made. Arrest should be what? Made. We discussed arrest without warrant and formalities to be followed for arrest. Arrest of a person for refusing to give his name and residence. Next one, arrest by a private person, arrest by a magistrate. Arrest by whom? Magistrate. Clear with this? Next we have summons and warrant. Summons and what? Summons and what? Warrant. What is summons? Legal document issued by whom? Court. Calling upon the person to what? Attend before a judge or officer of a court. What of a court? Officer of a court. Correct, right? Issued by whom? Court. Calling the what? Person to attend before the judge or officer of the court. We already discussed how the summons is served in the CPC. Same thing we can write except service of summons on whom? Witness. Summons on whom? Witness. The summons is served by whom? Police officer or by an officer of the court or other any public servant. If the person cannot be found after due diligence, the duplicate copy of the same can be left with whom? Adult member of the family. Correct, right? Next one, substituted service of summons means if a person is avoiding the service of summons, then the summons can be affixed at where? At the home of the accused. Service on the government employees is deliver the summons to whom? Head of the department. Next one. If he resides outside the local jurisdiction, summons to the magistrate within the jurisdiction where the person to be what? Summons reside. Correct, right? Service of summons on witness. Regular methods, that is electronic communication, are by what post? Registered post. For witnesses, you can serve the summons even by what? Electronic communication medium. Even by WhatsApp also you can send the summons. Clear? These are the provisions with respect to service of summons in case of criminal offences under the PNSS. Under the what? PNSS. Important, have I discussed the concept of proclamation and attachment? Correct, right? Even after serving the summon, if a person does not appear, the court may give a proclamation saying that, giving how many months of time? Not less than how many days of time? 30 days of time to appear before the court. Correct, right? If the person accused of certain offences, that is heinous offences, what offences? Heinous offences, and if he fails to appear, court may pronounce him as what? Proclaimed offender. What offender? Or a what offender? Proclaimed offender. When can court issue this proclamation? Where a court has a reasons to believe person against whom the warrant has been issued by it has absconded or is concealing himself. Publish a written proclamation requiring him to appear at a what place? Specified place. What place? At a what time? Specified time. Not less than how many days? 30 days. 30 days from the date of publishing such proclamation. Person accused of certain heinous offences and such person fails to appear may pronounce him as what offender? Proclaimed offender. What offender? Heinous offences like murder, theft, robbery, all these things. Attachment. Court may, after the issue of proclamation, order the attachment of any property belonging to which person? Proclaimed persons. Attachment means what? Suspending the rights of the person for the properties. Correct, right? Proclaimed offender is about to dispose the whole or any property or remove the property out of jurisdiction of the court. In that situation, who can attach the property? Court can attach the property. Are who can attach the property? Court can attach the property. Then we have search warrant. What warrant? What warrant? Who can issue search warrant? Who issues search warrant? Magistrate. Authorizing the police officer to enter into any place to search any person who has been wrongfully confined or to find any document and to seize the document or the articles. Correct, right? That is called as what? And search warrant. Mark it important. Search warrant important, important, important. Concentrate everybody. Mark it important. What warrant? What warrant? Search warrant. What warrant? Search warrant. What is the first one? Search warrant issued by whom? To whom? Police officer to search a particular place or the places to seize the thing or things or to discover the person who have been what? Wrongfully confined. Search warrant may be issued in what circumstances? Following circumstances. What is the first one? Court has a reasons to believe person to whom the summons is served will not produce the what? Document, the thing required by summons. Document or a thing is not known to the what? Court in the possession of anybody. So court can authorize the police officer to enter and search the warrant. Last one, court considers that purpose of any inquiry or trial or other proceedings will be served by a what? General search or inspection. What search or inspection? General search or inspection. In that situation, can issue the warrant? Magistrate to whom? Police officer. To search what place? Any place. For what purpose? To seize the things or to discover the person who has been wrongfully confined. Wrongfully what? Objectionable articles which may be searched and seized. Mark it most important. The following are considered as what items? Objectionable items. If any person is having an objectionable item with him, who can issue such warrant? Magistrate and authorize the arrest of that person. What is the first objectionable item? Means what? Fake currency notes and coins. Next one, pieces of metal made in violation of what act? Coinage Act are brought into India in violation of what? Customs Act. Any currency notes brought into India in violation of the Customs Act. Next one, counterfeit currency notes and counterfeit stamps. Next one, forged documents. Next one, false seals, obscene object, pictures or object. And the last one is what? Instruments or materials used to make any mentioned above. any instruments which are used to make counterfeit coins, currency notes, false documents, or obscene object, we can confiscate. They are called as what items? Objectionable items. Magistrate can authorize the police officer to enter into any place to seize these objectionable items. What items? Objectionable item. They can ask this question in the examinations. Chicken. Next comes summary trial. What trial? Speedy disposal of the case is called as what? Summary trial. See, in case of summary trial can be done only for what offenses? Summary trial is applicable only for those offenses that are not punishable by what? Death or life imprisonment or imprisonment exceeding how many years? 3 years. So it is applicable only for an offense which is punishable up to how many years of imprisonment? 3 years of imprisonment. How many years of imprisonment? 3 years of imprisonment. Examples of offenses which are punishable or triable summarily. What is the first one? Theft, where the value of property is how much? Less than 20,000. Important. Summary trial is applicable for the following offenses. What is the first one? What is the first one? Value of property is less than how much? 20,000. Second one, receiving or retaining what property? Stolen property, where the value of the property does not exceed how much? 20,000. Receiving a stolen property. Theft, less than 20K, summary trial is applicable. Correct, right? Next one, receiving or retaining what property? Stolen property. What property? Next one, assisting the concealment or disposal of stolen property where the value of such property does not exceed so much? 20,000 rupees. How much? 20,000 rupees. Next one, house trespass. What trespass? What trespass? Yes. Somewhere trial available, not available. Available. Next one, insult with the intent to provoke a breach of peace. Insult कर रहा है, insult किया है, the intent to break the peace. Can it be tried summarily? Yes. Next one, criminal intimidation. What is intimidation? Here. Abatement of any of the above offenses or attempt to commit any of the above offenses. Abatement means what? Supporting. Attempt means what? It's a preliminary crime. Offenses under the Cattle Trespass Act. Which act? Cattle Trespass Act. Can they be tried summarily? Which offenses can be tried summarily? Offenses which are punishable less than how many years? 3 years. What if it is punishable with 3 years? Summary trial is available. More than 3 years? No. And the punishment passed shall not exceed how many months? 3 months. In under what trial? Summary trial. What trial? Summary trial. Below what trial? Summary trial. Clear with this, everybody? Next, we have compounding of offenses. What is compounding? What is compounding? Compromising of an offense where parties by an agreement agrees to what? Where one person agrees to drop the prosecution for a written promise by the other person to pay the what? Compensation. It is called as what? Compounding of offenses. What is compounding, everybody? Settlement of an offense. Hello, settlement of an offense committed by whom? A person is called as what? Compounding. Called as what? Which offenses are compoundable? Important. They may ask this question in the examination. What offenses are compoundable? What is the first one? Voluntarily causing a what? And wrongfully restraining or confining any what? Person. If you keep hold of a person, even temporary period. Next one, assault or use of what force? Criminal force. Assault, battery, creating an apprehension in the mind of a person to hit a person. Correct, right? Theft, compoundable, not compoundable. How it is compoundable? You have to return the theft. Correct, right? And stolen property. Next one, voluntarily causing a grievous hurt. What hurt? Grievous hurt. Next one, assault or a criminal force in attempting or wrongfully to confine a what? Person. Theft by a clerk or a servant of property in possession of what? Master. Criminal breach of trust. What breach of trust? These are compoundable, non-compoundable. Non-compoundable, non-compoundable, compoundable. Next one, bail. What is bail? What is the bail? Temporary release of a person from what custody? Legal custody. It is called as what? Bail. Bail can be of how many types? Three types. What are three types? Regular bail, interim bail, anticipatory bail. If a bail is given after the offense is committed, it is called as what bail? Regular bail. What is interim bail? Pendency of the bail application. It is called as what? Interim bail. What is anticipatory bail? Before the person is arrested. Which court can grant the anticipatory bail? Only High Court and Session Court. High Court and what court? Session Court. The person must make themselves available for what? Interrogation. By whom? Police. As and when required. As and when what? Next one, person shall not interfere with what? Investigation, and person should not leave India. Which person should not leave India? The one who has obtained what arrest? What bail? Interim anticipatory bail. What bail? What bail? Arre, what bail? Anticipatory bail. What is bail? Temporary release of the person from the legal punishment. Types of bail. What are three types? Regular bail, interim bail, anticipatory bail. Anticipatory. Tell me, is there any limitation applicable for criminal offences? Generally what? No, but there are exceptions for filing a complaint. Filing a what? Complaint. There is a limitation period. What period? Limitation period. What is the first one? If the offense is punishable with a fine only. What only? What is the limitation period? 6 months. How many months? If the punishable with imprisonment for a term not exceeding 1 year. 1 year. Not exceeding 3 years. 3 years. How many years? 3 years. Exclusion of time in certain cases. Same thing, whatever we discussed in the Limitation Act. Which act? Arre, which act? You are doing a one more prosecution in a different court, which is not having jurisdiction. You know, it's the time limit. You filed a complaint in a different court, and the court is not having jurisdiction, and it was done in a good faith. Are you supposed to exclude the time taken by the court? Yes. Next one, stay order. What order? Stay order. Or injunction against the institution of the war. Prosecution is in place. Can you exclude the time? Yes. Next one, prior notice is required. Notice period. Prior consent is required. Time taken to obtain the consent. Absent from India. Time during which he was absent from India. Offender is absconding. The period they are absent is excluded from the limitation period. What period? Limitation period. Chiran, what period? Limitation period. What period? Next one is continuing offense. What offenses? Continuing offenses. What are continuing offenses? Offenses which are continuing in nature. What in nature? What in nature? Continuing nature. For example, let's say a company deducting employee contribution towards PF, but they're not depositing the same to the EPF account. They're doing these things 1 year. It is a what offense? Continuing offense. It's keep on occurring every month. Correct? It is called a what offense? Continuing offense. When an offense is committed, what is committed? Offense is committed. Or what is committed? For a what period? Very long period. Long period. It is called as what offense? Continuing offense. Bolo what offense? Offense which is happening and continuing again and again, it is called as what offense? Continuing offenses. Example, illegal possession or use of what property? Stolen property, or fraudulent activities or environmental violation that continue, such as pollution or illegal dumping. What dumping? Illegal dumping. All these are called as what? Continuing offenses. What offenses? Continuing offenses. This is what? B and S. S. The B and S. ಭಾರತೀಯ ನಾಗರಿಕ. Listen, everybody. Okay, listen. Concentrate. I want everybody to concentrate. Concentrate. Once I finish every chapter, you should be in a position to answer my questions. If that is not happening, then it's not correct. Correct, right? That is the object with which I'm doing this revision marathon. Correct? It is not like I just say something and listen to it and I'll forget it. We need to remember the point to write in the examinations. Correct, right? Yes or no? This is a rapid revision. What revision? Rapid revision. Believe me, when I ask questions now, you will be in a position to answer 80% of my question. I know which topic you will not be in a position to answer honestly. मुझे पता चलता है. Correct, right? Listen. If a person commits an offense, non-cognizable offense, can he be arrested by the police officer? Can he be arrested? Cannot be arrested. Without warrant, can he be arrested? What if he refuses to provide his name and residence? Can he be arrested? For what purpose? To ascertain the name and residence. What if it could not be ascertained within 24 hours? Send him to a magistrate. Correct, right? Can a woman be arrested after sunset before sunrise? Can a male police officer touch a woman during the war? Arrest. Correct, right? Next one. Next one. Listen. Can a proclaimed offender be arrested without warrant? Yes or no? Deserter of army, person found to be in possession of stolen property. Tell me, under the summary trial, what is the maximum months of imprisonment can be given? 3 months. Which kind of offences or what type of offences can be tried summarily, which are punishable, not exceeding 3 years? How many years? Tell me, can a magistrate authorize the police officer to enter any place to seize the objectionable item? What items? Objectionable item. Now, for example, let's say a person is storing some pen drives. Having what? Pen drives. Can the police officer authorize, not police officer, can the magistrate authorize the police officer to go and seize those pen drives? Yes or no? Why pen drives? Array, having pen drive is not a punishable offense if the pen drive contains some obscene matters. What matters? Obscene matters. Now, what if Shashank wanted the next Telgi? Next Telgi. So, what he will do, he orders a machine which can make what? Fake currency notes and coins. And he kept it in his house. And who knows this? Chirath knows this. And he called and informed the police officer. Can the police officer directly enter the house of Vishak and seize it? No. You need to take the permission from whom? Magistrate. Warrant chahiye na warrant. Without warrant, how can he enter Shashank house? If he enters, he'll ask, where is the warrant? Search warrant is required. What is required? Search warrant. What is required? Search warrant. They show, right? So, what if he is lying? He's liar only. Next one. क्या बेटा? Uh-huh. Next. Tell me. Array, High Court, can it pass a death sentence? Magistrate of first class? How many years? 3 years. Second class? 2 years. How many years? 1 year. Fine of how much? 10,000. In case of default in the payment of fine, what is the maximum imprisonment? Huh? 1/4 of the total imprisonment the court can pass. Correct, right? What is cognizable offense? Police can arrest without warrant. What is non-cognizable offense? Police cannot arrest without the warrant. Yes or no? With this, we are done with what? BNS and BNSS. Let's quickly go to the question and the answers. I want everyone to concentrate. I want everyone to answer my questions. Listen, everybody. Concentrate. Distinguish between the crime and civil wrong. Extra question, just go through it. Criminal wrong, civil wrong, individual against the individuals, against the public, punishable, and what is the remedy? Features of crime. बोलो answers बोलो. Intention, preparation, attempt, accomplished, accomplished offencer. In such exceptional cases, mere preparation to commit an offense is punishable. Counterfeiting the waging a war against the government. Clear? Next one. Elements of crime. Human being, mentia, actors. What are the types of mentia? Intention, negligence, recklessness. Correct, right? Difference between motive and preparation. See, motive and intention. Motive and what? So, क्या होता है motive? Motive होता है the reasons for the offense. Intention मतलब क्या होता है? Conscious exercise of the mental faculties. Why did a husband kill the wife? The reason for the murder it is called as motive. Did he kill intentionally? It's called as intention. Correct, right? Difference is there. They may ask this question, may not ask this question. Menstria and actastria. And menstria and actastrias. Differences, just go through that. And corporate body and menstria. Corporate body, the alter ego. The menstria of the alter ego is imputed on the what? Company or corporation. Company or what? Corporation. Types of punishment or types of punishment. Death. Arey bolo, what is the first one? Death. Second one. Imprisonment for a feature of property. Five. Community service. Community service. A drunk person conducting the misconduct. Is it community service? A lot of not allowed. Can be imposed. Difference between fine and penalty. Theft, robbery, extortion, dacoity. I DM the PCM. Theft. This one, if PV Sindhu, huh? Extortion. If it is DS to do the daily homework, robbery. Dacoity, five or more person. Extortion, if PVS, DSW, if PV Sindhu. Next, criminal misappropriation of property. What appropriation of property? Criminal misappropriation of property. So there are so many questions which have organized topic wise. Can you solve these questions later? I should be solve it now itself. Huh? No, we'll solve it now itself. X and Y. Let's start. साथ में पढ़ाई करेंगे हो जाएगा. Fine. It will take hardly 10 minutes of time. I know you guys are sitting in the class. It's a long number of hours, but still, where there is a will, there is a war. Where you have exams in June. Exams in what? June. Correct, right? Let's start. Let's start. X and Y. Read. X and Y. An illiterate woman was on railway platform of Kanpur. She was on railway platform. She gave a ticket to check it. What the other person did, he substituted his ticket for her ticket. Is it a criminal misappropriation of property? Yes. It can also be a breach of trust. Breach of what? Trust. Next one, dishonest misappropriation of. It cannot be a breach of trust because she did not give it to him. She only So she only it can be breach of trust as well as criminal misappropriation of property. Next one, accused. A person was in possession of some property. Accused take the property. Is it punishable or punishable? Punishable. Criminal breach of trust. Can you guys read this question? Rajesh, extra, so realized amount of money in and securities. What securities? Somnath by the shades of XYZ reality. Is he doing what the other person instructed? No. It amounts to what? Criminal breach of trust. What breach of trust? Criminal breach of trust. It writes right about criminal breach of trust. Criminal breach of trust by public servant. This concept is no more than in your syllabus, but to be in a safer side, go to this one particular question. Okay, cheating discuss किया था मैंने cheating, deception, right. Cheating by personation. A prostitute communicated vulnerable disease to X, who had with her on the strength of her representation that she is free from what? Any disease. Is it a cheating? Yes, it causes the bodily harm to the person. Correct, right? Punishable, not punishable. Punishable. Cheating. Cheating by personation. Renuka receives a Facebook message and a friend request that appears to have been sent from a young girl, small boy. Rahul. The information sent by Rahul shows that he is a government officer working in the Sudhara and draws an attractive salary, and also that he is a bachelor and seeking a beautiful girl for a marriage. Attracted by the message of Rahul, Renuka meets with Rahul and they fall in love. Gradually, it led to the relations. Later, Rahul began to ask for money from Renuka for one or the another reason. In inquiry, it is discovered that Rahul is not a government employee and he has taken the education only after what? 10th standard. What standard? 10th standard. Is it a cheating by personation? Yes. Short note on the fraud, false documents. Correct, right? Forgery. You write about forgery, everybody. Yes or no? Rani, the accused, has been charged for the offense of the forgery on the ground that she submitted a false certificate declaring that she had an experience of working as a teacher in a school. She has mentioned truth only, but the school did not have a valid certification. Is she punishable here? No. That is not her issue, right? Property mark, defamation, and libel and slander difference. And I had given this question. This question was asked in the previous exam, last exam. Defamation. General exception to what? Crime. Seven exceptions. Private defense. What defense? Private defense. Clear? Private defense extends to causing a what? Death of a person. Can you answer? Yes or no? BNSS, bailable offense, non-bailable offense. You must solve this question bank along with the short notes. Hardly it will take 3 4 days of your time. That's it. You'll get an idea of what type of question may come in the topic because I have arranged the questions and answers topic wise. Next one, distinguish between what? Cognizable and non-cognizable offense. Powers of the court to pass sentence. Discussed or not discussed? Discussed. Next one, sentence of imprisonment in what? Default of fine. What is the maximum imprisonment? One fourth of the total period of imprisonment. Okay, there is a case study on this. Inherent powers of the High Court. It is partly administrative, partly judicial. When police officer may arrest without a warrant, discuss किया था ना, in the presence of the police officer, less than 7 years, more than 7 years, proclaimed offender, deserter of an army, possession of stolen property, all these things. Non-cognizable offense, can a police arrest without a warrant? No. Can a person be arrested for refusing to provide the name and residence? Yes. Arrest by a private person? How the arrest is made? Touch and confine the body of a person. Search and summons and search warrant. Types of service of summons. Proclamation for a person absconding. How many days of time? 30 days of time to appear and answer the charges. When search warrant may be issued? What situation search warrant may be issued? Possession of what items? Objectionable items. Or if he has court believes that he will not produce the documents Our court is not aware about the person having possession of the documents. Objectionable articles which may be searched and seized under what? This section important. Summary trial, important, most important. Summary trial. What trial? Summary trial. Maximum how many months of imprisonment in case of summary trial? 3 months. How many months? 3 months. Compounding of offences. Offences which can be compounded. Bail and type of bail. Continuing offence. Important. And this question number 6 I already covered in the Article 21 of Constitution of India. Bail is a matter of right. Bail is a right. Jail is an exception. Jail is a what? Exception. We have discussed all these things, right? You must solve this question bank questions also. Clear with this? Yes or no? With these, we are done with what? DNS and BNS. What are the essential elements of crime? One being STM and STM. Clear with this? Yes or no? So next we'll start with law with respect to evidence. Chapter number what? 8. Okay, let's start with lesson number 8. Law with respect to evidence. Law with respect to what? Evidence. Evidence. Correct, right? Lesson number 8. So we have the law called as Bharatiya Sakshya Adhiniyam. Below Bharatiya Sakshya Adhiniyam. Correct, right? This chapter is all about evidence. All about what? Evidence. Correct, right? In this chapter, we're going to discuss what is an evidence, types of evidence, what can be proved by providing an evidence. What can be proved by providing an evidence? Either a fact in issue or relevant facts. Then we'll discuss the types of evidence. Then we'll discuss about confessions, then admissions, then evidence which cannot be admitted in the court of law or evidence which cannot be given in the court of law, estoppels and also presumptions. Also what? Presumption, important chapter and they may ask practical question out of it. Which question? Practical question. Out of what? Law with respect to evidence. Law with respect to what? Evidence. Let's start. What is an evidence? What is an evidence? Evidence may be either what? Oral or documentary. Well, evidence may be either what? What is oral evidences? All the statement which the court allows are required to be made before it by a witness is called as what? Oral evidence. What evidence? Then we have documentary evidence. What is documentary evidence? All the document which the court requires are allowed to be produced for its inspection. It is called as what? Documentary evidence. And what do you mean by evidence? It can be either oral evidence or documentary evidence, which is adduced, means introduced either to prove what? Facts or relevant facts. What facts? Relevant facts. Correct, right? That is called as what? Evidence. What do you mean by evidence? Oral evidence or documentary evidence. What do you mean by oral evidence? All the statements which the court permits are required to be made before it by whom? Witnesses. Somebody has seen the murder. When he appears and make a statement about the murder he has seen, it is called as what evidence? Oral evidence. What evidence? When I produce the original copy of the contract, it is called as what? Documentary evidence. What evidence? Correct, right. And why do we provide evidences to prove what? Either fact in issue or the relevant fact. What fact? Fact in issue or what fact? Relevant fact. And we have documentary evidence. What is documentary evidences, everybody? Documents produced for the inspection of the court are called as what evidence? Documentary evidence. Next one, we have facts. What do you mean by fact? What do you mean by fact? Fact means anything or a state of thing or relation of a thing capable of being pursued by what senses? Human senses. It is called as what? Facts are any mental condition of which any person is conscious of. Is called as what? Fact. Are called as what? What is a fact? Anything or a state of thing or relation of a thing which capable of being pursued by what senses? Human senses. We have how many senses? Five senses. What are the five senses? See, touch, taste, hear, and smell. Anything which can be pursued by senses. anything or a state of thing or a relation of a thing which can be perceived by the senses. Perceived by what? Senses. Or any mental condition. What condition? Mental condition which any person is conscious of. What are? So I know that you have enmity against a particular person. It's also called as what? Fact. I'm conscious of your mental condition. I know that you are unsound mind. What mind? That is called as what? Hmm. Fact. Called as what? Fact. What is a fact? Anything or a state of thing or a relation of thing which can be perceived by what senses? Human senses. It is called as what? Fact. It also includes a mental condition which a person is of what? Conscious of. Yes or no? Tell me, as per section number 6, evidence can be given. What can be given? Evidence can be given either to prove the existence or non-existence of what? Factual issue. What an issue? Are the relevant facts, not any other facts. What facts? Not any other facts. Tell me, evidence can be given. What can be given? Either to prove what? Fact in issue or the relevant fact. Now, are you guys clear with what is a fact? What is a fact? Anything. What thing? Or state of a thing, a body lying in a particular state. It is a what? Fact, anything, state of thing, a relation of thing, which can be perceived by what senses? Human senses, or a mental condition which a person is conscious of is called as what? Fact, called as what? And we can give an evidence. What type of evidence? Oral evidence or documentary evidence? What evidence? To prove what? Fact in issue or relevant? Now let us discuss what is fact in issue. What in issue? Fact in issue is a fact, either by itself, either by what? Itself, or in connection with any other facts, the existence, non-existence, or nature, or extent, or liability, or disability, asserted or what? Denied. Asserted or what? Denied. It is called as what? Fact in issue. What in issue? Any fact. What fact? Either by itself, either by what? Itself. In connection with what facts? Other facts. The existence, non existence, nature, extent of any right, liability, or disability. Right or disability of what? Asserted or denied. Asserted or what? Denied. It is called as what? Fact in issue. What in issue? NARL tag. What tag? NARL tag. What is E? Existence. What is that? Non-existence. Third one, extent. Next one, nature. Extent. Of what? Right? Liability, disability is ascertained or denied. Then it is called as what? Fact in issue. What in issue? For example, if a person, the question is whether a person had menstruation. What, Ria? If this whether a person has menstruation or not, is it a fact in issue or relevant fact? Fact in issue. What in issue? What in issue? Fact in issue. Whether a person had menstruation or not. It is a what in issue? Fact in issue. Because if that is proved, that will impose a liability upon the person. If there is no menstruation, he will not be liable for the offenses. So any fact, either by itself or any other relevant facts, proves the existence, non-existence, extent, nature, the liability or disability is ascertained or denied. It is called as what? Fact issue. What is issue? The important fact. What fact? Important fact. Is called as what? In issue. Then we have a relevant fact. What fact? Are you guys clear with the fact in issue? What in issue? Did A kill Mr. B? Is it a fact in issue or relevant fact? Fact in issue. What in issue? Because if the answer is yes, he will be liable. If the answer is no, he will not be liable. Was there any valid contract? What contract? Is it a fact in issue or relevant fact? Fact in issue. Because if there is a relevant valid contract, that will give a right to a person. What to a person? So any fact, either by itself or any relevant fact, the existence, non-existence, nature, extent of any right, liability, or disability is ascertained or denied. It is called as what? Fact in issue. What in issue? What in issue? So we can provide evidence to prove either what? Fact in issue or what fact? Relevant fact. What type of evidence? There are two types of evidences. Oral evidence, documentary evidence. All the statement which required to be made by the court or which allows to be made by it by a witness is called as what evidence? Oral evidence. What evidence? What is documentary evidences? all the documents produced. What produced? For the inspection of the court is called as what evidence? Documentary evidence. Are you guys clear with the fact in issue, everybody? Next, let us discuss the relevant facts. Make some noise, guys. What facts? Relevant facts. What facts? Relevant facts. What do you mean by relevant facts, sir? A fact is relevant in the following situation. What situation? Following situation. They support which fact? Fact in issue. What in issue? What in issue? Fact in issue. First one, a fact becomes relevant in the following scenario. What is the first one? A fact connected with what? Fact in issue. What in issue? A fact which has a connection with the fact in issue or a relevant fact to form the part of the what? Same transaction. What transaction? Whether they have occurred at the same time or a different time or a different place. Simple says simple. If there is a connection between the relevant fact and the fact in issue, what in issue? Relevant fact and what in issue? Fact in issue to form part of what transaction? Same transaction, whether they occurred at what time? Same time, or a different time, or a place. They are called as what? Fact in issue. What in issue? For example, at the place where the murder happened, all the three persons were present. Shashank, Rakshit, not Rakshit, Shashank, Chirant, and Darshan, all three were present. Is it a fact in issue or relevant fact? Relevant fact. Well, the fact that they were present will not prove any liability. They may be present just to watch some cinema or to do something else. Yes, their presence will not make them liable for something, but that can be a relevant fact. What fact? That gives an impression that they may have done the murder because they were present when what happened? Murder happened. What happened? A fact becomes relevant. What becomes relevant? Because it has a what? Connection. It has a what? With what? Fact in issue or any other relevant fact to form part of what transaction? Same transaction, whether it happened at the same time, same place, or any different time. What time? Different time. Next one. Next one. Any fact. What fact? Any fact. Which are the occasion? Which are what? Which proves the occasion or a cause or an effect, immediate or otherwise, of relevant facts. What facts? Are fact in issue which constitute the state of things. What of things? Under which they have happened or which offered an opportunity for the occurrence or transaction. All these are called as what fact? Relevant facts. What facts? What is the first one? Occasion, like when the murder happened or when the breach of contract happened. Next one, cause. What is the cause of death of a person and what is the effect of the action of a person or which constitutes the what? State of thing. What are things? Like how the things were arranged when the murder happened, what was the state in which the body was lying. All these are considered as what fact? Relevant fact. What fact? What fact? For example, let's say when the theft happened, a person was seen entering the house. Is it a relevant fact? That gives a what? Opportunity of their occurrence. Opportunity of their what? Occurrence. So any fact which is an occasion or a cause or an effect or constitutes the state of thing or offers an opportunity of their occurrence is called as what fact? Relevant fact. What fact? When a fact is relevant, what is the first situation? It is connected with the fact in issue to form the part of what transaction? Same transaction. इसको बोलते हैं risk state. क्या बोलते हैं इसको? Risk state. Correct, right? Second one, a fact which is a cause or an effect or occasion or constitute the what? State of thing or offers a reasonable opportunity for their what? Occurrence. Opportunity for their what? It is called as what? Called as a relevant fact. What fact? Relevant fact. Next one, facts which shows or constitutes the motive or preparation. Motive or what? Preparation. A person purchased the weapon 2 days before the murder happened. Is it a relevant fact? Yes. That shows the what? Preparation. And there is something called as motive. The reason. For example, there is an enmity between A and B, or they had a fight 1 day before the murder happens. Are they relevant fact or not a relevant fact? Relevant fact, because that proves the what? Motive and preparation. Motive and what? For the fact in issue or the relevant fact. It also includes any previous and subsequent conduct. Previous and what? Regular what conduct? Previous and subsequent conduct. Whatever happened before the murder and whatever happens after the murder. The accused is missing. Absconding. Is it a relevant fact? Yes or no? What is the first situation when a fact is considered as relevant fact? It is connected. It is what? Everybody below it is what? One more time. Connected, connected, connected. Follow? Connected, connected, connected. With the what? Fact and issue or relevant fact. The form part of what transaction? Is it a relevant fact? Second one, any fact which is a what? Cause or effect or occasion or which offers a reasonable opportunity for what? Occurrence of the transaction. Occurrence of what? Is it a fact? What fact? Relevant fact. What fact? Third one, any fact which constitutes the motive or preparation. Motive or what? Or previous or subsequent conduct. Previous or what? Subsequent conduct. Is it a fact or relevant fact? Below what factor? Relevant fact. Fourth one is most important. Any fact. What fact? Necessary to explain or introduce a fact in issue or relevant fact. A fact which is necessary to explain the fact in issue or a relevant fact is also called as what fact? Relevant fact. What fact? First one, the fact which helps to clarify or introduce the what fact or any relevant fact is also what fact? Relevant fact. For example, a person is missing. He is missing because he had an urgent business in the abroad. Is it a relevant fact? That explains why he is missing. Why he is what? Missing. Next one, fact support or contradict an inference drawn from the word. Fact in issue or a relevant fact. What fact? Relevant fact. Arey, what fact? For example, Darshan was present when the murder happened. But Darshan was present because he had a business in the bank. See, in the bank, murder happened. In the bank, Darshan was present and is accused of a murder. But now, is it a relevant fact? The fact that Darshan was present at the place where murder happened, is it a relevant fact? Because it has a connection with what in issue? Fact in issue. But however, now there is one more fact. Darshan visited the bank because he wanted to deposit the cash and he has deposited 1 lakh rupees cash to the bank. Is it a relevant fact? Yes or no? Because that will explain why he was there in that particular situation. So anything which support or contradict, there is an inference drawn. Because Darshan was present, we are drawing an inference that he may be the one who has done the murder. But now to contradict that, there is one more fact. What is the one more fact? He was present because he was what? He had a cash to deposit. Yes or no? Is it a relevant fact? Yes or no? So any fact which contradict or support the fact in issue or relevant fact, it's also what fact? Relevant fact. Next one, any fact that establishes the what? Identity of the person. What of the person? CCTV camera footage. It is considered as what? Relevant fact. Next one, any fact that establishes the what? Time. Establish the what? Time. Now Darshan is accused of murder of his wife. Murder of his what? Wife. But on the date of murder, he was attending a conference in Dubai. Conference in where? Dubai. Tell me, is it relevant fact? Because that shows that he may not be the one who has committed the what? Murder. Yes or no? Clear with this? Any fact that helps to determine the what? Time as well as the place. As well as the what? Place. Are the facts that establish the what? Relationship between the parties. What are the parties? Are they relevant fact or not a relevant fact? Relevant fact. What fact? There was a conversation between Darshan and his wife, and Chirant was present when the conversation happened. He has witnessed that Darshan has proposed to that girl, and she agreed to marry him, and they got secretly married. All these things were discussed in the presence of Chiran. Now, the fact that Chiran knows that Darshan is got married to that girl secretly, is it a relevant fact? Yes, that proves the what? Relationship. That proves the what? Relationship between Darshan and his wife. Yes or no? So all these are what facts? Relevant facts. What facts? First of all, tell me what is the first relevant fact? Any fact connected with what in issue? To form part of what transaction? Same transaction. Whether it happens at the what time? Same time or at different times or when whatever it is. Second one, a fact which is an occasion, cause or effect which offers a reasonable opportunity for occurrence of the relevant fact. What fact? Relevant fact. For example, let's say Chirant is accused of stealing money from someone. Stealing money from what? Someone. Correct, right? Someone. And there is an accusation that The money was stolen in the food street, VVपुram food street. What street? VVपुram food street. Now, the fact that the theft happened at VVपुram food street, is it a relevant fact? Because it's a crowded area that gives an opportunity for happening of that what? Theft. Yes or no? Is a what fact? Relevant fact. What fact? Relevant fact. I'll give one more example. One more example. One more example. Darshan informed Chiran that he is going abroad. Going what? Abroad. That no one will be there in his house. Only who knows this? Chiran knows this. He comes back after 2 days. When he came back, the cash is missing in the house of what? Darshan. Now tell me the fact that Chirant was aware about the fact that Darshan will not be there in the home for 2 days. Is it a relevant fact? Why is it relevant? It proves that because he is the one who was aware about the fact that Darshan will not be home for how many days? 2 days. That gives him an opportunity for what? Stealing the cash. Arey, yes. No. So any fact which is an occasion, which is a cause, which is an effect, or which is provides a reasonable opportunity for occurrence of the event. It is considered as what fact? Relevant fact. What fact? Any fact which is a motive or which is a preparation, which is a previous and subsequent conduct, is it a relevant fact? Yes, it is a relevant fact. Next one, next one, next one, next one, next one. The fact which are necessary to explain or introduce what fact? Fact and issue are relevant fact. Any fact which helps to clarify the fact, a relevant fact. Is it relevant? Yes. Second one, a fact that support or contradict any inference drawn from the word. Fact in issue or what in issue? Fact in issue or the relevant fact. What fact? Relevant fact. What fact? Relevant fact. Any fact that helps to establish the word. Identity of a person, establish the time, establish the word and establish the what time or determine the place or relationship between the parties is a what fact? Relevant fact. What fact? Next one. Things said. What said? Are done by a conspirator in reference to what design? Common design. What design? You know what is conspiracy? What is conspiracy? When two or more persons come together to do something, it is called as what? Conspiracy. Criminal conspiracy. What conspiracy? Criminal conspiracy. What conspiracy? Group of five girls plan to kill whom? CSR. Plans to kill whom? CSR. They come together, they discuss everything among them. One of the girl, what she had done, she has written a diary. In a diary, she has written all the essentials of all the discussions they had. She has written saying that today is a great day. All five of us had a discussion. We have planned that one of us will buy weapon, other person will not weapon. One person will buy the poison, other person will buy the sweet, and I will be mixing the poison, and someone else will go and give it to CSR, and CSR will die. After the death, we will take the body to the nearest forest and we will dispose the body or will bury the body. This is the plan, and this is the mission possible. Mission what? Possible. And this is what we are going to achieve. Karke, she has written the diary. Written the what? Diaries. She has mentioned all the person's name. What name? All the person's name. Now CSR is dead. He consumed the food and he is dead and he is buried. Now police did investigation and they caught hold of somebody. Now tell me, can this diary be used as an evidence? Yes or no? No. It is admissible. It's a fact or relevant fact. Fact in issue or relevant fact? Relevant fact. Yes or no? Because that explained the common design. What design? The diary explains that there was a criminal conspiracy. What conspiracy? Criminal conspiracy. Listen, listen. Anything said or done. Bolo, bolo. Anything said or done or written by any one of such person. Any one of what? Such person in reference to their what design? Common design. After the time when such intention was first conceived or entertained by any one of them is a what fact? Relevant fact. What fact? So anything said or done or written by one of the conspirator with respect to their common design, is it a relevant fact or not a relevant fact? Relevant fact. Are you guys clear with this? Yes or no? We're discussing what facts? Relevant facts. What fact? So we can provide evidence either to prove what? Fact in issue. Or which fact? Relevant fact. What fact? Next one, sixth one. When the fact not otherwise relevant become relevant. In what cases? Following cases. What cases? Generally, they're not relevant, but in the following cases, they become what? Relevant. What is the first one? If they are inconsistent with what? Any fact in issue or relevant fact. What in issue? Fact in issue or relevant fact. See, for example, let's say you are accused of a murder, but on the date of murder, you are there in USA. Tell me, is it a relevant fact? The fact that you were there in USA at the time when the murder happened? Why yes? That is inconsistent with whatever the inference drawn. Now it becomes what? Relevant. Becomes what? Relevant. Next one. By themselves or in connection with other facts, they make the existence or non-existence of any fact in issue. What an issue? Relevant fact. What fact? Relevant fact. Highly probable or improbable. Probable or what? Improbable. Probable or what? Improbable. Let's say this Saujanya case. There was a case. Person was the accused. One of the accused was uh, released. One of the accused was arrested. Right? Who is that person? I don't know. I don't remember the name of the person. He was suffering from a disease. Suffering from what? Disease, which makes him incompetent to have any sexual intercourse with any of the fact that he was suffering from the disease, is it a relevant fact? Is it a relevant fact or a relevant fact? Relevant fact. Because that makes that rape case improbable, right? Because he was suffering from a disease. When he is physically incapable of doing it, you say it is possible. That is the relevant fact. What fact? Relevant. Are you guys getting this? अरे हाँ ये ना so by themselves or in connection with the other facts, they make the existence or non-existence of any fact or issue or relevant fact highly probable or improbable. Probable or what? Improbable. Now there is the person who is having an item of, let's say, next one. Are you guys clear with this? Let's know what facts which are not otherwise relevant but becomes what? Relevant. In what cases? Following cases. And in what cases? What is the first situation? If they are inconsistent with any fact in issue or relevant fact or by themselves or connection with any other fact which makes the existence or non-existence of fact in issue or relevant fact highly probable or improbable. Next one, facts tending to enable the court to determine the what? Amount or what? Relevant means losses happen, damage to the car, damage to the property, or emotional sufferings. All these are what fact? Relevant fact. What fact? Next one, following facts are relevant if there is a right to custom. Right or a custom is in what? Question. What is the first one? The transaction that created a claim are modified, recognized, asserted, or denied the what? Right or a custom. What are a custom? Right or a custom, or that is inconsistent with the existence is relevant. Existence is what? Relevant. For example, whether not allowing the woman to Shabarimala temple, is it a valid custom or not? How the custom was created is a relevant. What fact? What fact? Relevant fact. Next one, specific instances where the right or a custom was claimed. In what and all situation that right was claimed is also what fact? Relevant fact. What fact? Relevant fact. Are below what fact? Relevant fact. Next one, the fact showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will, goodwill towards any particular person, or showing the existence of any state of body or bodily feeling is also what? Relevant or irrelevant? Relevant. So if a person is having a good faith, what faith? A person is of good reputation in a society. Is it a relevant fact? Yes, it is a relevant fact. Next one, fact bearing on the question whether the act was accidental or intentional. Accidental or what? The fact that such an act formed the part of series of similar occurrences. What occurrences? Similar occurrences in each of which the person doing the act was concerned is what fact? Relevant fact. What fact? Whether it is accidental or intentional. The series of acts which he has done and how he has done is also what fact? Relevant fact. Next one, when the question is whether the particular act was done in the ordinary course of business, according to which it naturally would have been done is also what fact? Relevant fact. Means in general how it is done. And if in the same way, if it is done, it is deemed to be in what course of business? Ordinary course of business. These are the 11 facts which are considered as what? Relevant facts. What facts? So we can provide evidence. We can provide what? Either to prove what? Fact in issue or relevant fact. Fact in issue or what? How many types of evidences? What are two types? Oral and what? What is oral evidences? All the statement which court requires are allowed to be made before it. By whom? Witnesses. Is called as what evidence? What is documentary evidences? All the documents which are allowed to be produced before the court. And what is fact? Anything or a state of thing or a relation of a thing which can be conceived by what? Or perceived by what senses? Human senses or any opinion, any other person is also called as what? Facts. The types of fact, fact in issue and relevant fact in issue and what is fact in issue? Any fact either by itself or through any other relevant fact. The existence, non-existence, nature, extent of any right or liability or disability is ascertained or denied. It is called as what for? Fact. Fact in issue. What is issue? Then we discuss the relevant fact. What facts? Relevant facts. Next one, for each of the cases, I have discussed detailed example in the class. This is a marathon revision. What revision? Marathon revision. Only to remember the points. Okay, to write in the examination. Next one, admission and confession. Admission and what? Admission and what? Confession. Admission and what? Confession. What is admissions? A statement that suggests any inference as to any fact in issue or relevant fact. I repeat, any statement made by a person which suggests an inference about the fact in issue or relevant fact, it is called as what? Admission. Called as what? Admission can be made by what? Maybe oral or it can be contained in the documents as maps, bills, receipts, letters, or books. Admission may be made by whom? Party or by the agent or by predecessor in what? Interest of the party or by a person having a joint proprietary of pecuniary interest. What interest? In the what matter? Subject matter. What matter? Subject matter. And what matter? An admission is the best evidence against the what? Party making the same. What is the best evidence? Admission is a what? Best evidence. Because nobody will lie. Which if a statement goes against himself, he will not lie that. Right, right. So any admission of a person is a best evidence. What evidence? Best evidence. An admission must be what? Clear, precise, and not vague or ambiguous. Not vague or what? Next one, all the statements made in the plaint are admissible as what? Evidence. One more time. Tell me what is admission? Any inference to any fact in issue or relevant fact. It is called as what? Admission. Admission may be verbal or contained in the documents as maps, bills, receipts, letter or books. Now, let's say, there was a letter written by a boy to a girl claiming that she is his wife. She has also responded saying that she is his wife. Is it those letters? Is it an admission? Yes or no? Yes or no? Now what if a kid needs a signature of his parents and the report card. He get a signature of a particular person, that is his father only. But later there is a question that he is not the father. That is the dispute. That is a fact in issue. What is my God? Example, right? So not Chet's father, beta, normal father. मम्मी का father, sorry, not मम्मी का father, husband का. हाँ, so father. So any admissions made by a party or by the agent. Oh, okay, that example I was giving, right? Father. So he has signed the report card. So now the fact that when he signed, he has signed as a father. In the father column, he has mentioned the signature. But now he is denying that he is not the father. Can the wife produce this report card as an evidence in the court of law? Yes, that is an admission, right? If you're not a father, then why did you sign in that report card? Then why were you acting as his father? Now, why are you denying it? You have to now yes, he is denying it. Are you guys clear with this? Next one. So admissions can be made in the form of what? Words, or maps, or bills, or receipts, or letters, or books. Are yes or no? Are you guys clear with this? Admission can be made by what? Words, or by documents, or maps, or bills, or receipts, or letter books. Admission made by what? Party. Made by who? Party. By the agent or predecessor in interest of the party. By person having what propriety rights? Propriety of pecuniary interest in the what matter? Subject matter. Joint interest. What interest? Joint interest. An admission must be clear, precise, and not vague or ambiguous. Are you guys clear with this? Next one, confession. What is the next one? Arey bolo, what is confession? In case of civil cases, it is called as what? Admission. Criminal cases, it is called as what? Confession. Everybody open your mouth and say, what is confession? Confession is a statement made by whom? Accused person. Arey bolo, what person? Admitting that he has committed the what? Offense. If a person and goes and tell the police officer that, sir, yes, sir, and the murder. If he appears before the court and says, I am the one who has committed this terrorist activity, it is called as what? Confession. Called as what? Confession. Even you admit your guilt in the absolute terms. What terms? Absolute terms. It is called as what? Confession. Called as what? What is confession? A statement made by an accused person. That's the what person? Accused person admitting that he has committed a what? Offense. It is called as what? Confession. Called as what? Confession is made by whom? Accused person. What person? Every confession is a what? Admission. You're admitting something. What you're admitting here that you've done a murder or an offense. Correct, right? A confession is an inadmissible in evidence if it has been made under the what? Promise or a threat or due to inducement. Due to what? Inducement. See, confession is a good evidence if it is not made out of threat or inducement. If it is made out of threat or inducement or a promise, is the confession is a valid evidence? No, it is not a valid evidence. Important, important, important. They may ask you to write what is confession and when the confession is not relevant. Confession is what? Not relevant. In the following three cases, follow how many cases? What is not relevant? Confession is not relevant. One more time. What is not relevant? Confession is not relevant. What is the first one? What is the first one? Confession made to a person. Bolo? Voice. Bolo. Confession made to whom? Person in authority, in a consequence of what? Some inducement, threat, or a promise held out by him in reference to the what? Charge against the accused. What against the accused? So confession made to a person in authority because of his inducement or a threat or a promise. Second one, whom? Police officer. What officer? Police officer. Or to anyone. Or to whom? At the time when the accused is in the custody of whom? Police officer and no magistrate is present. Are you guys clear with this? In these three scenarios, what is not valid? Confession is not valid. What is the first situation? Confession is made out of what? Threat. Out of what? Threat. Second one, inducement or a promise. And made by whom? Accused to whom? Police officer or to any other person when he is in the custody of a police officer and no is present, magistrate is present. No, who is present? Magistrate is present. Can you write about what is confession? What is confession? Admission of guilt of an offense. It is called as what? Confession. Types of confession. Types of confession. There are how many types of confession? Two types of confession. Sensation nahi hai. Confession. क्या है? Sensation. That's one. Real. Famous. Huh? Huh? Types of confession. Types of what? Confessions. There are how many types of confession? Two types. There are two types of confessions. Judicial confession and extrajudicial confession. Darshan, what is judicial confession, Darshan? Confession made before the court or recorded by whom? Magistrate. After he is sufficiently warned that he is not supposed to make such Confession. And if it is made, it may be used against him. It is called as what confession? Judicial confession. Are bolo what confession? Any confession made to the police officer or to any person other than whom? Judges. It is called as what confession? Extrajudicial confession. Extrajudicial confession is valid if it is not made out of inducement or a threat or a promise. Ha, yeah, na. Understood? Yes or no? Next one. Next one. Statement by a person who cannot be called as witnesses. Important, important, important. They may ask question based on this in the examination. Are you guys clear with admission and with admission and confession? Confession in case of what offenses? Confession in case of what offenses? Criminal offenses. Admission, civil cases. All admissions are not confessions, but all confessions are what? Admissions. All confessions are what? Admissions. Yes or no? That statement by a person who cannot be called as what? Witness. For example, listen, listen, listen. If see who is a witness, sir? A person is called as a witness only when he appear before the court and testify the veracity of his statement on a what? If somebody has seen a murder, you have to testify it before the court on a oath. Then only it is valid evidence. What evidence? Valid evidence. If somebody cannot appear before the court and testify his statement, can that statement made by the person be produced as an evidence? See, you have seen the murder. I record your statement saying that police officer while doing investigation, they will say, okay, you have seen the murder. Okay, this person, evidence number one, witness number one. But that witness number one has given some statement, but witness number one is dead. Now, the statement given by the witness number one, is it admissible as an evidence? Inadmissible as an evidence? Not admissible as a what? Evidence. Something can be admissible as an evidence only when you appear before the court and verify the veracity of the statement on a what? Oath. Correct, right? Otherwise, you cannot be called as witness. But there are exceptional cases. What cases? Exceptional cases. Where a statement by a person who cannot be called as what? Witnesses, still admissible as evidence. Admissible as what? Evidences. They may ask this question in the examination. Listen, everybody. Generally, no statement. Bolo. Everybody, no statement given by whom? Any person can be used as what? Evidence. One more time, one more time. What cannot be used? No statement given by whom? Any person can be used as evidence until he comes to the what? Court. Are bolo, until he comes to the what? Court and testified them on what? Oath to the veracity of his statement. He has to appear before the court and he has to verify the veracity of his statement on a oath. Then only it is called as what? Valid evidence. What evidence? Are there any exceptions where even if a person cannot verify the veracity of his statement before the court, it's still admissible as an evidence? Yes. What is the first one? A statement made by a person. Bolo bolo. Statement made by a person regarding the cause or circumstances of their death. For example, somebody stabbed CSR 10 times. How many times? 10 times. CSR is admitted to the Apollo hospital. What hospital? Apollo hospital. Now, who is the investigating officer? Our Abhishek is the investigating officer. He comes with a notebook. Comes with a what? Notebook. Oh, tell me, what is your name? My name is CSR. My name Hey, spell properly. My name is CSR. Okay, you had breakfast in the morning. When the person is about to die, he's asking whether you had breakfast in the morning. Okay. So now the investigating officer, what officer? Investigating officer asked, killed who did this to you? Did this to you? Not speak, but however, slowly I raise my hands and show my hand to the wife who is standing next to me. Now I'm dead. Who is dead? CSR is dead. Now tell me the statement made by CSR, is it admissible as evidence or not admissible as evidence? But he is not there to verify the veracity of the statement, right? It's a time declaration. What declaration? Time declaration. It is an exception. It is a what? Exception. A statement. अरे पागल लोग पढ़ाई करो क्या क्या करना पड़ेगा भाई सुन इन स्टूडेंट्स को समझने के लिए. A statement made by whom? Person regarding the what? Cause or circumstances of their what? Death. Admissible or not admissible? Admissible. अरे yes or no? Second one. Second one. Second one. A statement made in the what course of business? Generally, how the transactions are done, how transactions are recorded, passbook entries. The one who has done the entry will not be there to verify the veracity of the statement, right? Is it still admissible as an evidence? Yes. Next one, statement that go against the person's own interest. What interest? Or could expose them to what liability? Criminal liability. Anything, any statement which goes against the one person's own interest, even if you don't verify, that statement can be admissible as what? Evidence. Admissions. Correct, right? Fourth one, statement expressing the opinion, expressing the what? On a public right or a customs made before any what? Dispute arises. What arises? I have written a book on a custom, particular custom, and this book is written long back, even before there is a dispute with regard to whether it's a custom is valid or not valid. Can that be produced as an evidence? But the one who wrote the book is no more, he is dead. Is it admissible as evidence or admissible as an evidence? Admissible as a evidence. Why? Because that statement was expressing the opinion even before dispute has arisen. Dispute has what? Arisen. Yes or no? Next one, next one, next one. Statement about relationship. Statement about what? Relationship made by someone with what knowledge? Special knowledge before what arises? Dispute arises. What arises? Dispute arises. And what arises? Dispute arises. For example, Adi has helped to conduct the marriage between Chirant and one more person, right? Uh, is- and he also recorded. He has taken the pictures and all. Who has taken the picture? Listen. Adi takes Chirant to Nandi Hills to conduct his marriage, like a secret marriage. No, now he takes them to the Nandi Hills. He helped them to get married. Shashank, in front of Shashank, next to Adi, next to Adi, next to Adi. Ah, now, listen better. Chirat, who helped? Okay, Adi helps to conduct the marriage between Chirant and girl. He has he's taking the pictures, taking the what? Pictures. Who's taking the pictures? Adi are taking the pictures because Chiran did not want to have any evidences to be there about his marriage. What happened? He pushed Adi. Adi fell, and Adi is no more. Example: after now, the Adi is claiming that the girl is no more his wife, but the girl is saying that no, no, Adi is not nothing. Chiran is not his friend. Now there is a dispute about their relationship, about their what? Relationship. When and while taking the pictures, even Adi was writing a diary, writing a what? Diary. In the diary, he has mentioned Shirant weds Shiroti. Shirant weds Shiroti on this particular day in the Nandi, at the Nandi Hills. I have a presentation. The marriage of these two beautiful couples. He has written all these things and he has signed it. And he's not there. Now, Adi is denying this relationship, not Adi. Chirant is denying this relationship. Police officers found this diary and the camera pictures. Tell me, is it admissible as an evidence? Who had made this statement? Adi. Before dispute or after dispute? Before dispute concerning the what relationship, and he had a what knowledge? Special knowledge. It's admissible as evidence or admissible as an evidence? Admissible as an evidence, even though others don't need to testify the veracity of that statement. Yes or no? Because he had a what knowledge? Special knowledge. Next one. Statement regarding the relationship of whom? Deceased person made by someone with what knowledge? Special knowledge. What knowledge? Special knowledge. Now, for example, listen. Continuing with these, what if Adi is the one who has helped the Chiran to get married? After some time, Chiran got married, like officially got married to one more person. He has two wives. Now Chiran is dead. Who is dead? Chiran is no more. And now, now, the first wife, son, is claiming that Chirant is his father. Second wife's son is also claiming that Chirant is his father, but now there is nobody to verify this. Now Adi had a special means of knowledge, correct, right? Now Adi confirms that the deceased person was the husband of whom? Second wife also. Is it admissible as an evidence? Yes, admissible as what? Evidence. Are example, some topic, some are you guys clear with this? Yes or no? So statement regarding the relationship with the deceased person. What person? Deceased. Next one. Statement in legal documents. What documents? Legal documents like deeds, wills that relate to the what? Rights or customs are irrelevant, especially if they claim, assert, or deny the existence of what? Right or custom. See, a person wrote a will and is no more there to verify the veracity of the statement. Is the will valid or not valid? Valid. Last one, statement made by the number of persons express their what? Feeling of impressions. If group of people say that picture looks like somebody in a defamation. Is it admissible as an evidence? Yes. Even though we cannot produce all of them to verify the veracity, still it is admissible as what? Evidences. Are you guys clear with this? They may ask this question in the examinations. Correct, right? What are the statements by persons who cannot be called as what? Witnesses, generally not admissible as an evidence. Chirant, first case, statement made by a person regarding the cause of what? Death. Second one, statement made in the what course of business? Ordinary course of business like records are acknowledgement. Third one, statement that go against the person's own interest or could expose them to what liability? Criminal liability. Statement expressing an opinion or a public right or a customs made before any what? Disputes arises. Statement about what? Relationship made by someone with special knowledge before what arises? Dispute arises. What arises? Relationship with a deceased person. What person? Deceased person who had a special knowledge. In our example, Adi had a special knowledge. Are you guys can remember? That is why I gave this example. Yes, no. I can direct a movie. Next one. Statement for everything. Yes, sir. Yes, sir. Statement made under what circumstances? Special circumstances. What circumstances? Special circumstances. There are two cases where even though a person is not there to verify the veracity of the statement, admissible as evidence because they're made under what circumstances? Special circumstances. What are they? What is the first one? Entry in the books of account. Entry in the what? Kept in the what course of business? Ordinary course of business. Accountants will keep on changing, but still that book is admissible as what? Evidence because it is made in what circumstances? Special circumstances. अरे बोलो what circumstances? कितना बार पूछना पड़ेगा? बोलो what circumstances? Next one, entries in the public or official books. What books? Official books, registers are record made by public servants in discharge of what duties? Official duties. Or by other performing the what duties? Legal duties. A nurse has entered your date of birth in the on the books. Now the nurse is dead. What who is dead? Nurse is dead. Is that admissible as an evidence? It's an official record. What record? Casual official record. What record? Official record. Next one, beta. Statement in the published maps, charts, or a plan. Now, in the map, your property is there, and in that property, you are the one who is mentioned as the owner of the property. Is it admissible as an evidence? Yes, admissible as what? Evidence. Next one, when the court needs to form an opinion. Who needs to form an opinion? Court needs to form an opinion on the existence of a public fact. What fact? Any statement in the central or state act government notification, official gazette, whether it is printed or in the electronic form, it is admissible as what? Evidence, market important, most important. The statement under special circumstances are considered as evidences, even though the person is not there to verify the veracity of the what? Statements. Last one, statement regarding the law of any country. What of any country? Contained in the book or electronic record published under the what? Government's authority or reports of the foreign court rulings are relevant for the court to form an opinion on the what? Law. What on the law? Opinions on that particular laws. Next one, opinion of third parties. Opinion of what parties? Tell me, are opinions relevant or irrelevant? Generally irrelevant. But there are few cases where opinions of the persons are considered as the evidences, are considered as relevant. What are they? Let's discuss. When the court has to form an opinion upon a point of foreign law, what law? Or a science or an art or any other field as to identify of the handwriting or finger impression or opinion upon that point of a person specially skilled in such foreign law, science, art, or any other field. See, the court has to form an opinion on the art, science, fingerprint, or any impressions or foreign law. Any person who is expertised or having a specialized skill. What skill? His opinion on that particular finger impressions or law, is it relevant or irrelevant? Relevant. They're also called as what? Experts. Called as what? So even though he's just giving his opinion, is it relevant or irrelevant? Relevant. Are they relevant or irrelevant? Relevant. For example, let's say I have done a murder. I've done a what? Murder. Who has done a murder? I've done a murder. Am I punishable? Not punishable. Punishable. But however, I'm acting like an unsound mind. Is unsound mind punishable? Not punishable. Punishable? Not punishable. Now, court wants to have an opinion whether he is sound mind or unsound mind. Now, the opinion of an expert in the medical field, opinion, admissible or inadmissible? Admissible or inadmissible? Admission. Admissible because he's just expressing, even though he's just expressing the opinion, expressing the what? Opinion. Is it admissible as an evidence? Yes, admissible as what? Evidence. Because he's a what? Having a specialized knowledge. What knowledge? Specialized knowledge. Next one, fact not otherwise relevant. Fact not what? Otherwise relevant are relevant if the support are inconsistent with the what? Opinion of experts. Opinion of what? Means one doctor gave an opinion that CSR is unsolved. Other doctors come and said, no, this doctor opinion is wrong. He's sound mind. Is it relevant? Yes or no? Yes, it is also considered as what fact? Relevant fact. Next one, the opinion of someone familiar with the handwriting of a person. What of a person? First two are experts. First two are what? Concentrate everybody. First two are what? Experts. Third one is what? Opinion of a person who is familiar with what? Handwriting. Relevant or irrelevant? Relevant. Next one, when the court needs to determine the existence of general custom, the opinion of the what? People who are likely to know about it are considered as what? Relevant fact. What fact? When the court has to form an opinion on the usages, constitution, and governance of any religious or charitable foundation, the meaning of the words, the opinion of the person having the special means of knowledge they know are what? Relevant facts. What facts? When the court has to form an opinion as to the relationship of one person to whom another, the opinion of the member of the family. What of the family? Member of the family or the one who has special means of knowledge. Is it relevant or irrelevant? Relevant. First one, opinion of an expert. When relevant is important. Correct, right? The one who is having what knowledge? Special knowledge. When a court has to form an opinion about what? Art, science, foreign law, or handwriting of a person. Is it relevant or not relevant? Relevant. Relevant or not relevant? Relevant. Are you guys clear with this, everybody? Next one. Next one. Facts, evidence of which cannot be given. This cannot be what? Given. For example, listen everybody, listen everybody. Are you guys listening to me? Yes. I will keep giving example. You guys should tell me whether it is admissible or not admissible. Tell me now. Continuing with the example, children is married, and after the marriage, one day when they were discussing, when they were sitting in the sitting in the balcony and discussing something. He cannot disclose the fact that he has done a murder. He has done a what? Murder. Now, here, listening to this, the wife felt bad. She started feeling bad to the person who has been killed, that she wants to be punished because she believes in justice. Now, she only files a complaint and she says, I will be the witness against whom? Chiran. Now tell me, can the wife be produced as a witness in the court of law? No, no, because any communications during the marriage it is considered as what? Trivialized communication. What communication? Admissible as evidence or inadmissible as evidence? Inadmissible as an evidence. Evidence cannot be given. What if before the marriage to impress the girl, what Chirant has done, he has made a statement to the girl saying that I have done 5 murders. How many murders? 5 murders. This communication was made before the marriage, before the war, marriage. Then he later got marriage. Then the wife want to be a witness against whom? Chirag. Can she be produced as a witness against Chirag? Answer is yes. Because only a communication made during the wedlock, during the marriage, is not admissible as a evidence, or she cannot be a witness. Why? Because it's considered as what communication? Privileged communications. Are you guys clear with this? One more thing. One more thing. For example, a client make a communication with a CA or a CS or with an advocate. Can the advocate be a witness? It's called as what? Professional communication. What communication? For a what communication? Professional communication. Can judge be compelled to be a witness? So judge cannot be compelled to be a witness for any statement made before him unless by a special order of which court? Superior court. What court? So these are called as what communication? Privileged communication. What communication? Evidence can be given, evidence cannot be given. Evidence cannot be given. Correct, right? Let's start. First one. What is the first one? Evidence of a judge and magistrate. No judge or a magistrate shall be compelled to answer any question as to his own conduct in the court or as to anything that he has come to his knowledge in the court as a what? Judge. He can be compelled to give evidence on a special order of which court? Superior court. Or which court? They may ask question based on this. Next one, communication during marriage. Communication during what? Admissible? Not admissible. There can be practical question based on this. Read everybody. Answer. Read. No person. Bolo, who is or has been what? Married shall be compelled to disclose any communication made to him during the what? Marriage. Underline the word during the marriage. During the marriage by any person whom he is or has been married. No such person shall be permitted to disclose any such communication unless the person who made it or his representative consent to it. Means only if other person consent, then she can disclose a particular fact. Next one, evidence as to what affairs? State affairs. What affairs? No one shall be permitted to give any evidence derived from the what records? Unpublished official records. Bolo bolo. Unpublished official record. Only the published official records can be produced as a what? Evidences. Clear with this? Next one. Next one. Official communication. Bolo. What communication? Official communication. No public officer shall be compelled to disclose communication made to him in his what confidence? Official confidence. What confidence? Official confidence. Which when he considered that public interest would suffer by because of that what? Disclosure. Because of that what? Disclosure. Next one. Information as to the what? Commission of offences. No magistrate, police officer shall be compelled to say when he got any information as to the commission of any offence, and no revenue officer shall be compelled to say when he got any information as to the commission of any offence against the what revenue? Public revenue. What revenue? Police and magistrate, and they cannot be produced as a witness. Produced as a what? Witness. Next one, professional communication. What communication? Between the advocate and client. They can ask practical questions either based on this or based on this or based on the point number 2 or point number 1. Practical question. What question? Practical questions. Are you guys clear with this? Evidence cannot be given. What cannot be given? Evidence cannot be given. Next one. Types of evidence. What types of evidence? Oral evidence, documentary evidence. What evidence? Version of evidence, oral evidence. What is oral evidence? All the statements which are required are allowed to be made by the court before it is called as what evidence? Oral evidence. What evidence? What is documentary evidence? All the documents which are allowed used before the court, it is called as what evidence? Documentary evidence. And what evidence? Oral evidence must be direct. What must be direct? Oral evidence in all cases must be what? Direct. Means what? Evidence should be given by the one who has seen it, or one who have heard it, one who have experienced it. Yes or no? It is called as what evidence? Oral evidence. What evidence? Next one. Types of evidence: primary evidence, secondary evidence. See, documentary evidence can be classified into how many categories? Two categories. You know how many categories? What are two categories? Primary evidence and secondary evidence. You know what evidence? Primary evidence and secondary evidence. When the document itself is produced for the inspection of the court, it is called as what evidence? Primary evidence. You know what evidence? The best evidence rule is considered as a core principle of the what? Law of evidence. What of evidence? Law of evidence. What is secondary evidence? And what is secondary evidence? The compared copies, certified copies, copies made by such mechanical process as in themselves ensures the what? Accuracy is called as what evidence? Secondary evidence. What evidence? Secondary evidence means and includes certified copies given by government, copies made from the mechanical process, copies made from or compared with the which one? Original one. Next one. Counterparts, then oral accounts of the contents of a document, oral admissions, written admissions, who has been examined on a document. All these are called as what? Secondary evidence. What evidence? Cases in which document relating to the documents may be given. That is, secondary evidences can be given. What can be given? Secondary evidences may be given. Secondary evidence may be given of the existence, condition, contents of a document in the following cases. When? What is the first one? When the original is in the possession of whom? Or of the person against whom the document is sought to be proved, and any person out of reach of or not subject to the process of the court, or person legally bound to produce it. After notice of such person does not produce it. In that situation, we can provide a fee of the document. Arbitration agreement is not with you, is with the other person. You can produce a copy of the document to put in the court of law. Then court will compel him to produce the what document? Original document. What document? Original document. Next one. When the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is what? Proved. Against whom it is what? Proved. Next one, when the original has been destroyed, lost, when the party offering evidence its content cannot, after any other reasons not arising from his own default, produce it in a what time? Reasonable time. What time? Cannot produce it in reasonable time. When the original is of such nature, is not easily movable. Easily what? Document doesn't mean only paper, it can be stone also. Document doesn't mean only a paper, it can be any substance on which any matter is expressed to be stored for a longer period of time. It is called as what? Document. Called as what? Document. A documentary evidences. When the original is a what document? Original is the what document? Public document. Is it possible to produce the original document of the public records? No. Next one. The original is document of which certified copy is permitted as per the word adhiniyam. When the original consists of numerous accounts, you can give a brief of the numerous transaction. What transaction? Numerous transactions. Clear with this? Circumstantial evidences in England, direct evidence is used to signify the what? Evidence with respect to what in issue? Fact in issue. Circumstantial evidence is signify the evidence with respect to what? Relevant fact. What fact? But in India, all evidence must be what? Direct evidence. Direct evidence has altogether a different meaning, and it is not intended to exclude the circumstantial evidence of things which could be seen, heard, or felt. So in India, there is no difference between the direct evidence and circumstantial evidence. Even the circumstantial evidence, that is relevant fact, should be what? Direct. Should be what? That is by the one who has seen it, one who have heard it, one who have experienced it, or one who have what? Conceived it. Correct, right? Next one, we have the presumption. What do we have? Presumption. And what do we have? The the facts of which evidence cannot be given. The facts of which evidence cannot be given. Communication, judge statement of the judges, evidence during the facts disclosed during the marriage, professional communications, and official communication. What communication? Communication. Tell me, are opinion relevant? Generally, no. But opinion of expert, relevant or not relevant? Relevant. Are you guys clear with this? Can you tell me statement of which evidence cannot be given? Or statement which cannot be called as a witness. This one, statement by a person who cannot be called as what? Witnesses. Lying declaration. What declaration? Lying declaration. Presumption. What is presumption? Any inferences that are drawn by the court. Drawn by whom? Court. With respect to the existence of certain facts. Existence of what fact? Certain facts. It is called as what? Presumption. Called as what? Presumption. There are three categories of presumption. What is the first one? Presumption. Law, presumption of fact, mixed presumption. What presumption? What is presumptions? First of all, inferences drawn. Or what drawn? Inferences drawn by the court with respect to the existence of certain facts are called as what? Presumption. Presumptions can be of how many types? Three types. What are the three types? Presumption of law, presumption of fact, mixed presumption. What is presumption of law? It is also called as shall presume. What presume? Shall presume. It is the rule of law that a particular inference shall be drawn by a court from a particular circumstances. For example, 30-year-old document is presumed to be what? Genuine. Presumed to be what? Genuine. And at the same time, any kid below how many years? 7 years. Can he commit a crime? Cannot commit a crime. Can he be? Can what is the law presumes? He cannot commit a war. Correct. He cannot have what here? Men's here. What here? Punishable, not punishable? Not punishable. Next one, presumption of a fact. It is a rule of law that fact otherwise doubtful may be inferred from that word. Fact which is to be proved. What is to be proved? Fact to be proved. Example, last seen together. Possible involvement in the what? Murder. Let us say inference drawn from the fact. Drawn from the what? Fact. It is called as what? Presumption of fact. Is it rebuttable or irrebuttable? Rebuttable. You can provide an evidence to show that even though we both were together, doesn't mean you were done the murder. That right. Next one, mixed presumption. Mixed presumption. What presumption? Mixed presumption. Mixed presumption. What presumption? Mixed presumption. Certain inferences between presumption of law and presumption of fact. It is called as what? Mixed presumption. For example, a child born during the continuation of a valid marriage is presumed to be the what? Legitimate. It's the presumption of law as well as the fact. Correct, right? It's a mixed presumption. Terms used in the Sanhita. We have a conclusive proof. What proof? What proof? What is conclusive proof? Specifies those presumptions which in English law are called as what? Irrebuttable presumption. What presumption? Irrebuttable presumption. For example, it is presumed that any person who is below how many years? 7 years cannot have what ria? Menstrual. Is it an irrebuttable presumption? Rebuttable presumption. Irrebuttable. Conclusive. Shall presume means what? Shall presume indicates rebuttable presumption. What presumption? Means which can be changed by law. For example, any kid above 12 years, above 7 years, below 12 years may not have menstrual. Correct, right? May not be a punishable for a crime. Plus, if it doesn't have what? Guilty mind. What mind? Not a person of maturity. Correct, right? It is a shall presume, rebuttable presumption. If there is evidence to show that he had a guilty mind, punishable, not punishable? Punishable. Last one, may presume. The term may presume indicates what? Presumption of fact. What of fact? Presumption of fact. Yeah, below what of fact? Presumption of fact. Clear with this? Presumption of what? Fact. For example, any death happens if a wife, if a girl dies during the marriage within one, if a girl commits suicide within 1 year or 2 years of marriage, it is presumed that it can be a dowry death. What death? Dowry death. There is a presumption of fact. May presume. Next one, estoppel. Have you heard about estoppel? Estoppel means what? Stop from denying. It is believed, it is based on the principle that a person alleging a contrary fact should not be heard. Should not be what? Heard. Whatever is said earlier cannot deny it at a later stage. Partner by estoppel. What by estoppel? Partner by estoppel. Principle of estoppel provides that a man cannot approbate as well as what? Reprobate. Or that man cannot blow hot as well as what? Cold. Or that a man shall not say one thing at one time and later on say what? Different thing. What thing? You cannot blow both cold as well as what? Hot. When one person has by his declaration or act or omission intentionally caused or permitted another person believe a thing to be true and act upon such belief, neither he nor his representative shall be allowed in any suit or a proceedings between himself and such person or his representative deny the what? Truth of that thing. Once you said that and somebody has done something based on the statement, can you deny it later? No. That is called as what? Estoppel. Called as what? Then we have electronic evidence. What evidence? Can we produce electronic evidences? Yes. Electronic evidences are admissible as evidence in the court of law. Electronic records produced by computers, communication devices, including data stored in magnetic optical media, are considered as what? Documents in legal proceedings. What proceedings? Computer output is admissible if it meets the certain condition regarding the usage, regularity, and accuracy of the device. The device must have been used regularly. Must have been what? Used regularly during the period of information was created or processed. Either you can produce the device itself or you can produce the copy of the record. Copy of the what? Record. Along with that, the one who is in charge or the one who is in possession of that instrument or a device should give a certificate saying that the copy is a genuine one. What one? Genuine one. Is it admissible or admissible? Admissible as an evidence. Clear? Next, we have a concept of logical relevancy, legal relevancy. Listen, everybody. All facts which are logically relevant are not legally relevant, and all facts which are legally relevant may not be what? Logically relevant. Under the BSA, what is important? Legal relevancy is important over the what? Logical relevancy. What relevancy? Logical relevancy. A fact is logically relevant to another if it has a what relationship? Causal relationship with it, making the existence or non-existence of the second fact more probable. All facts are logically relevant, are not, however, what relevant? Legally relevant. Relevancy under the Act is a question of what? Question of what? Law. It's not a question of logic. Correct, right? Whether the fact is relevant or not, it is not based on the what? Logic. It is based on the what? Law. Based on the what? Law. Based on what? Law. Based on what? Law. Under Adhiniyam, legal relevancy is to be considered. Against what relevancy? Logical relevancy. Tell me all instruments, all facts which are legal relevant are admissible or inadmissible? No, it is not always true that all legally relevant facts are admissible. For example, confession is legally relevant, may or may not admit it. Right, right? So all legally relevant facts are not admissible, not always admissible. Relevancy and admissibility are not coexisting or interchangeable terms. A fact may be legally relevant, yet its reception in evidence may be prohibited on the grounds of public policy or on some other grounds. Example, custodial confession. What confession? Any confession made in the custody, during the war, custody. Next one, factum probandum and factum probandum. What is factum probandum? The principal fact, the fact in issue that needs to be what? Proved. It is called as what? Factum probandum. What is factum probandum? The relevant fact that helps to establish the what? Principal fact. What fact? Nothing but relevant facts are called as factum probandum, and fact in issue is called as what? Factum probandum. Fact in issue and issue of fact. Fact in issue is used in case of evidence, and issue of fact is used in case of what? CPC, based on which the court decides the case. And these are the provisions with respect to what? With respect to what? Evidence. Law with respect to what? Evidence. Array law with respect to what? Bharatiya, Sakshya, Adhiniyam. I want everyone to answer my questions now. Answer my questions, answer my questions. Concentrate, guys. Concentrate. Listen. Evidence can be given to prove what? Fact in issue or relevant fact. We'll solve the questions. We'll solve the questions. I want everyone to focus and answer these questions. Listen, there are some practical questions. Same practical questions may come in the examination. Okay, solve करना ही पड़ेगा this question by. Let's start. Deals with the term evidence. Explain the evidence term. Evidence includes what evidence? Oral evidence and documentary evidence. Everybody look over here. Look at the screen. Evidence can be of how many types? Oral evidence and documentary evidence. Clear? Facts. Distinguish between the relevant facts and facts in issue. Just now we discussed. State the physical and psychological facts. Physical facts means what? uh, which can be conceived. Like, for example, certain things are arranged in certain order. It's a what fact? Physical fact. A man heard something, saw something. It is called as what? Physical. I have an opinion about some you. It is called as what? Psychological facts. I hate you. Psychological facts. Somebody likes somebody. It is what? Psychological fact. I have seen a murder. Physical fact. What fact? Physical fact. This water bottle is half full. Physical fact. What fact? Physical fact. Correct, right? Camera is recording. Physical fact. What fact? Physical fact. Correct, right? Yes or no? Biryani was good. What fact? Physical fact. Here with this psychological factor, physical fact. Next one. All facts are darshan. All facts are logically relevant or not legally relevant. Narrate. Can you narrate this? All logically facts are not legally relevant, but all legally relevant legally relevant facts are also not logically relevant. Which facts are admissible? Legally relevant facts. Correct, right? Whether a fact is relevant or not based on what? Not on the logic, based on the what? Law. Based on the what? Law. हमने discuss किया था ना when a fact is considered as a relevant fact. Yes or no? Next one, relevant facts connected with the what? Facts to be proved. Relevancy of a facts forming the part of what transaction? Same transaction. What transaction? Discuss किया था ना first one. Let's get it. Let's do the example. Question, practical question. First question. साथ में पढ़ाई करेंगे. पढ़ाई करो. A is accused of the murder. Can you guys read English? Then read. A is accused of a murder of B by hating him. Discuss the rule of relevancy of the fact of the statement. Such are done by A or B or by the bystander at the meeting or so shortly before or after. Is a relevant fact or relevant fact? Relevant fact. Next one. Ajoy, after learning that Chandler had been murdered by Vijay, went to the spot and found that body of Chandler was being taken to the house of Chandler by poor person who told him that Vijay had murdered Chandler and he had run away. Is the statement by Ajoy. He was told by four persons that Vijay had murdered by the Chandler and ran away. Admissible as evidence? No. It's a hearsay evidence. What evidence? Hearsay evidence. Admissible or admissible? Not admissible. Yes or no? Next one. Satyam is facing a trial of the charge of committing a murder of Raja at Pune at 5 p.m. Remember, evidences, facts which are generally not relevant because they become relevant because they makes the occurrence of a fact a relevant fact highly probable or highly improbable. Discuss किया था ना हम लोग. Example in this case, let's see. Satyam is facing. Everybody who is facing? Satyam is facing what? Trial for the charge of committing the murder of Raja at Pune at 5 p.m. on 5th November 2019. Satyam wants to prove that he had a telephonic conversation with Nalin from Delhi on 5th November 2019 at 3:30 p.m. Will he be permitted to do so? Yes. This makes that it is highly improbable. Is it possible to come to 5 p.m. and kill that particular person? He is in Delhi at 3:30. Even if you want to come by flight, it will take how many hours of time to reach Bangalore? Not Bangalore. Which one? Pune to Delhi take how many hours of time? Minimum 2 hours. But here, murder happened at what time? Fine. So 1.5 hour, is it possible to Pune and kill from airport to go to that particular place, kill the person? Possible, not possible. It makes the occurrence of the event is what? Highly improbable. Is it a relevant fact? Not a relevant fact. Relevant fact. Are yes or no? Next one. Admissions. Can you write about admission? Confession. Discuss किया नहीं किया? Discuss किया है. Confession. When confession is irrelevant, read the first question. Not first question. Let's solve the last question. Practical question. A was tried for the murder. Right for the what? Of whom B, whose body was found in the well, and the ornament that B was wearing were missing from his body. A, while in the police custody during the investigation, said that he had removed the ornaments, pushed B into the well, and had pledged the ornaments with whom? C. In consequences of this statement, the ornaments were recovered from C. Discuss the admissibility of A's statement. Admissible or inadmissible? Inadmissible because the statement made during the what? Custody. Was the magistrate present when the statements were made? Is it a valid confession or not a valid confession? Not a valid confession. Yes or no? I have given the answers for all the three cases. Yeah. Next one. Anand is on trial for the murder of Chanchal. Who? Chanchal. This is evidence to show that Chanchal was murdered by Anand and Birender, and that Birender's son, Anand and I murdered Chanchal. Can you see admissible as an evidence? Yes. Confession by one of the co-accused in a joint trial. What trial? Joint trial. Admissible as what? Evidence. Admissible as what? Evidence. And how many types of confession? Two types. There are two types. Judicial confession, extrajudicial confession. What confession? Extrajudicial confession. Beta, you should talk. Beta, you should answer. Next question. Question number 3. Mohan and Sohan are jointly tried for the murder of Rohan. It is proved that Mohan said Sohan, I murdered Rohan. And can the court consider the effect of this confession as against Sohan? Give reasons. Yes or no? Jointly tried for the murder of Rohan. Can it be considered as this one? Yes. Statement by a person who cannot be called as what? Witnesses that who cannot come and verify the veracity of the statement. Read everybody. Let's stop the padai karenge. Let's see how it sounds when we study together, when we read together. Are you guys with me? Yes or no? Have you seen this Katti movie in which Vijay says, right? Katti movie. Have you seen Katti movie of Vijay? Tarapati Vijay. You not seen Tarapati Vijay? Then here that on 20th March. And what? 20th March. Someone told his wife. I said साथ में पढ़ाई करेंगे. Next 5 chapters. We have the juice now, correct, right? Let's finish those 5 chapters in the juice. Five possible, mission possible. Concentrate, come. On 20th March, Kamal told his wife that he was going to Bhairavpur as Pankaj's wife has written a letter and asked him to come and receive the payments due to him. On 21st March, Kamal left his house in time to catch a train for Bhairavpur, where Pankaj lived with his wife. On the 23rd March, Kamal's dismissed body was found in a box that had been purchased for the Pankaj. Decide whether on the trial of Pankaj for the murder of Kamal, the statement made by the Kamal to his wife was admissible as an evidence. If so, on what grounds? Yes. Any statement made by a person before or after the death. Admissible or not admissible? Admissible as a evidence. Admissible as what? Evidence. Yes or no? Right, right. Next one. Opinion of which parties? Third parties. Relevant or irrelevant? Irrelevant. Are there any exceptions? Yes. Explain the expert opinion of the word. PSA 2023. See, according to And the weightage of the question, you will reduce the points or increase the points. Okay? Yes, this, yes, sir. Next one, when the opinion of any person relevant except under the what? Except the experts. Expert is always relevant. And there are a few more cases now where the opinion of a person is relevant. Handwriting and also customs, group of peoples and person having special knowledge. What knowledge? Special knowledge. Facts which evidence cannot be given. Privileged communication. A commits a murder. A commits a murder of his colleague in spur of the heated movement argument. A on reaching the home confessed the offense before his wife. The wife was summoned by the court to testify against her husband, who was on trial for the allegedly committing the murder. Can A's wife act as a witness? No, no, no. Because it is a what communication? Marriage communications. Communication between the husband and the wife during the marriage is not be admissible as a evidence. Family, but still their husband and wife during the marriage. During the marriage means only after the marriage, no? Hmm? Kamini informed Ajay in the year 2001 that she had committed a theft of the jewelry of her neighbor. Thereafter, Kamini and Ajay were married on what? 4th 2002. In the year 2003, criminal proceedings were instituted against the what? Kamini in respect of the theft of jewelry. Ajay is called to be give evidence in the case. Can Ajay disclose the communication? Yes, that happened before the marriage. I gave examples. अरे ऐसा नो ओके ठीक है बिकॉज मैंने पढ़ाई किया है सब कुछ पढ़ाई किया है the evidence which cannot be given evidence of a judges and magistrate communication during the marriage evidence as to offense of the state official communication information as to the commission of offenses professional communication documentary and circumstantial evidences. Can you discuss this circumstantial evidences में primary evidence secondary evidence primary evidence and what secondary evidence document itself is produced with what evidence primary evidence copies secondary evidence. What evidence? Secondary evidences. Circumstantial evidence means what? Nothing but relevant facts. What facts? Based on that, we can draw an inference that the person has committed a crime. Yes or no? Hearsay evidence admissible or not admissible? Not admissible. Presumptions. Can you write about the presumption? Types of presumptions. Presumption of law, presumption of fact, mixed presumption, conclusive proof, shall presume, may presume. Estoppel. And there is a case study. The student of Patra University appeared in an examination under some special scheme and their results were declared. Once results declared, you should do graduation. Give a certificate. You cannot deny it. You know. ठीक है. That is why the state government does not declare results only for this KPSC exams or KAS exams. Because once they declare results, they have to make the enrollments, right? They cannot approbate as well as reprobate. They cannot do both hot and cold at the same time. That is called as what? Estoppel. Electronic evidence. Can I write a short note on electronic evidence? So these are the questions which were asked in the what? PSA in the previous examination with respect to Bharatiya Sakshya Adhiniyam. Now tell me, मेरा satisfaction के लिए, my own satisfaction. See, practical question though we can answer because we have covered all those practical questions. And in the original material, I have given so many examples for every case or every scenarios. If you have gone through that, you can answer practical question. Now, theory questions answer करने के लिए, how to write the provision. Are there any few points in your head now? With respect to BSA, Bharatiya Sakshya Adhiniyam, facts, relevant facts. What facts? Fact, relevant facts, evidence which cannot be given, a person who cannot be called as a witness, opinion of the experts, opinion of the what? Experts, communication during the marriage, fact in issue, relevant facts, fact, direct evidence, indirect evidence, oral evidence, documentary evidence, evidence. अरे हाँ ये ना yes. I will tell you guys, listen. With these, we are done with what? Bharatiya Sakshya Adhiniyam. If you would have done this revision on your own, I'll tell you what most of the students will do. They'll skip this chapter. because I don't have the patience to study. But this is the one of the easy chapter. Either they'll ask question based on the confession or admissions, or they'll ask question based on the practical examples which are already given in your material. And the questions which no other students write the answer. That is where you stand apart from the other students. Correct, right? Yes or no? You should always write answers for all the papers, 100 marks answer. You have to make sure, you should make sure that you complete the full paper. You should write the answers for 100 marks. Correct, right? Yes or no? Even if you write the perfect answers for 80 marks, you don't get 80 marks. Correct, right? Try always writing the answers for 100 marks. You may end up getting 80, 60, 70, who knows, 90 also. That, okay. So next, we'll start with what? Specific relief. What relief? Specific relief. What relief? Specific. Welcome back. Let's start with lesson number 9. Law with respect to law relating to the specific relief. What is specific relief? A relief in the form of specie means when the court compels the person to fulfill the promise he has made, it is called as what? Specific performance. When a person is forced to fulfill what he has promised, it is called as what? Specific relief. What relief? Specific relief. Correct, right? What is the act name? Specific Relief Act 1963. 1963. Let's start. Section number 5. Section number one. 5. Section number 5 deals with what? Recovery of what property? Specific immovable property. What property? How a person can recover the specific immovable property. Concentrate. A person entitled to specific immovable property can recover it by following the what? Legal process as per what? CPC. What is the legal process as per CPC? Filing a suit. We discuss the various stages of the suit, right? Yes or no? Yes. Second one, a lawful owner. What owner? Of immovable property can recover the possession of to the what? Suit based on their title. Based on their what? Nothing but the ownership. But however, the lawful owner can file a suit for ejectment. Suit for what? For how many years? Within how many years? 12 years. How many years? Relying upon their what? Title. That is why nobody gives a lease beyond 12 years. Beyond what? 12 years. Especially residential property. What property? Because you cannot file a case after how many years? 12 years. For what? Ejectment. For what? Ejectment. Are you guys clear with this? Recovery of possession as per CPC. Ejectment within how many years? 12 years. Recovery of what property? Immovable property. Next one. See, you claim the possession of property as per section number 5 based on title. Based on what? But you claim the possession of the property under section number 6 based on what? Possession. Based on what? Possession. Based on what? Possession. Listen, 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 concentrate everybody. A person dispossessed of what property? Immovable property with consent or without consent? Without consent, not in the course of what? Law. Even though I am an illegal occupant of your house, you cannot dispossess me of the property without due process of law. If you illegally dispossess me of property, can I take back the possession of the property on the right or on the right of possession of the property? Yes, they can file a suit. Who can file a suit? The person who is dispossessed can file a suit for recovery of what? Property, regardless of title, but within how many months? 6 months. Based on section number 5, you can file it within how many years? 12 years. But based on section number 6, you can file a suit within how many months? 6 months. Which one is based on title? Section number 5. Which one is based on the possession? Section number 6. The main purpose of this section is to ensure that even the lawful owner, follow what owner? Lawful owner of the property follows the due process of the law, enforce their what? Right. Enforce their what? Right. We team today till 8:30. What? 8:30. Let's make it happen, guys. Let's make it happen. Yes or no? We'll cover 3 more chapters. How many chapters? 3 more chapters. Let's start. Let's start. Let's start. करेंगे हम लोग जून में एग्जाम है कब एग्जाम से जून में एग्जाम से Let's start. The main purpose of this section is to ensure that even a lawful owner, what owner? Of the property follow the one process of law, due process of the law to enforce their right. No appeal or review is allowed against the order or decree under section number what? 6. Are you guys clear with this? 5, section number 4 and section number what? Sorry, section number 5 and 6. 5 is based on what? Ownership. 6 is based on what? Possession. What is the time limit? 12 years, 6 months. Next one. Recovery of what property? Movable property. What property? Under which act? CPC. Following persons can file a suit for what? Possession. What is the first one? Person having a right to possession. Right to what? Second one, person with a temporary right to possession. For example, daily, Connie. Next one, the trustee can sue. Who can sue? Trustee can sue. On behalf of what? Beneficiary. On behalf of what? On behalf of what? Beneficiary for recovery of possession of what property? Movable property. What property? Next comes specific performance. What performance? Concentrate, guys. Specific performance. First one, contracts connected with the what? Trust. Tell me any contract which are connected with the trust. Specifically enforceable, not enforceable. Specifically enforceable. If a trustee makes the contract on behalf of the trust with a person, third party, can he enforce the contract specifically? For example, there is a trust. There is a what? Trust. The trustee, you made a contract with me. Is it specifically enforceable or not enforceable? Enforceable. Against the what? Trust. Against the what? Trust. Even though it is made by who? Trustee. Enforceable, not enforceable? Enforceable. What if the trustee has made a contract beyond his power? Enforceable, not enforceable? Not enforceable. Yes or no? The specific performance of a contract can be enforced when the act agreed to be done is with respect to the what? Performance of a trust. What of a trust? Performance of a trust. And what of a trust? If a trustee enters into a contract that is beyond their powers or breaches the trust, such a contract cannot be specifically enforced. Specifically what? Enforced. Then comes specific performance of what? Part of the contract. What of the contract? Part of the contract. Important, important, important. Based on this, they may ask practical question in the examination. You guys tell me, can specific performance of part of the contract allowed or not allowed? Generally not allowed. Generally what? Not allowed. Yes or no? But there are three exceptions. How many exceptions? Three exceptions. General rule. What rule? General rule. Array, what rule? General rule. I made your job simple. Correct, right? See how simple it looks like. Yes or no? I understood that you are finding it difficult remember so many provisions. So I made this keynotes. What notes? Keynotes. Section number 5 is clear. Section number 6 is clear. Yes or no? And we also discussed question with respect to the trust. There may be a practical question. What question? Practical question. Trusting is a contract on behalf of the trust. Is it enforceable? Not enforceable? Enforceable. However, if he makes a contract beyond the powers, beyond the what? Powers. Enforceable? Not enforceable? Not enforceable. Next one, specific performance of part of the contract. Specific performance will not be enforced unless the entire contract can be what? Performed. Bolo bolo. Entire contract can be what? Performed. Exception to the general rule. What rule? General rule. What rule? Array, what rule? General. Please don't watch this marathon revision video if you're sleeping. You're sleeping because the actions, reactions, too violent. Correct now. Next question. Exception to the general rule where part performance is allowed. First one, small portion is what? Unperformed. Important, listen points wise. Party cannot perform the entire contract. What contract? Below what contract? Entire contract. Unperformed part is a small in value. What in value? Small in value. It can be compensated in what? Money. Compensated in what? Money. First condition. What is the first condition? Party cannot perform the full contract. Unperformed part is this what? Small in value. What in value? And it is compensated in terms of what? Money. Then the court can enforce the what part? Per part. Award what compensation? Monetary compensation. I used to sell 100 acres of land. Out of 100 acres, I can sell 9.5 acres of land. Remaining 5 acres, not 5 acres, remaining zero point 0.5 is not within my control and not within my possession. Can the court enforce the 9.5 part? Yes or no? Because it is substantial portion is performed, right? Only small portion is not performed. Correct? Na? Enforceable, not enforceable? Enforceable. Next one. considerable part is unperformed. If a considerable part is unperformed, in that situation, generally specific performance is not allowed. But a person can still claim specific performance in the following scenario. Listen, everybody. What is the situation here? Unperformed part. Bolo? Is what? Substantial. First case, it is small. In this case, substantial. Defaulting party. What party? Cannot claim the what? Specific performance. But however, the person not in default, person not in what? May enforce the what? Contract if they pay the what price? Full price. Or what price? And relinquish all other remedies for the unperformed part of the contract. You promised to sell me 10 acres of land, but you have only a right to sell only 5 acres. Now, can you demand specific performance? No. But can I demand it? Yes. But I have to pay the price for the what? Entire 10 acres. Entire what? This is the one more scenario where substantial portion is unperformed. First one, small portion is unperformed. Second one, substantial portion is unperformed. Next one, what is a separate and independent contract? There are two contracts where one contract is performed, other contract is not performed. Which one is specifically enforceable? The other part of the contract. If a part of the contract is independent and can be specifically performed, while the other part cannot, which part is enforceable? The part of the contract which is independent. Bolo, which is independent, specifically enforceable, not enforceable? Enforceable. Bolo, bolo, enforceable. Are you guys clear with this, everybody? Yes. Next one. Next one. Clear with this? Specific performance of what of contract? Part of contract. What of contract? How many scenarios? Three scenarios. Small portion unperformed, considerable portion is unperformed, and the last one is what? Separate and independent contract. What contract? Next one, Darshan. Rights of a purchaser or a lessee against the person with what title? No title or imperfect title. See, a person is having an imperfect title or no title. He sold or she sold property to me at a later stage. If she acquires the ownership, can I compel her to transfer the ownership to me? When the contract was made, she had an imperfect title. Later, she acquired what title? Perfect title. Can I compel her to transfer the property to me or convey title to me? Yes. And what if a consent is required? What is required? What is required? Consent is required. A sale or a transfer requires the consent of a third party. Which party? And if the party demands, she is bound to give an consent. So bound to give the what? Evidence, sorry, consent. But she is not demanding it. Can I compel her by a suit? Take a consent of the other person, transfer a property to me. See, transfer by Nivedita requires the consent of whom? Akanksha. Okay, she has already sold it to me, but if she asks for consent, she's supposed to bound to give a consent, but she's not asking for it. Can I file a case against Nivedita to compel her to obtain the consent from Akanksha? Yes, because she already entered into a contract with me, right? Yes or no? Let's read the provision. Concentrate, everybody. If the vendor, vendor or a lessor subsequently acquires what? Any interest in the property after what is made? Contract is made. The purchaser or lessee can compel them to fulfill the what? Contract using the what? Interest, newly acquired interest. What interest? Newly acquired interest. If the consent of another person, what person? Is required to validate the ownership. Validate the what? Ownership. And the vendor or lessor is bound to obtain that what? Consent. The purchaser can compel the vendor to get the consent or have it what? Validated. If she is supposed to get a consent of her for a valid title transfer, I can compel her to get a what? Consent. Are yes or no? Next one. If the property is sold, is mortgaged, and the vendor has a right to redeem, right to what? You have mortgaged it and you have a right to redeem it. Can I compel you to redeem the mortgage? Yes or no? And if a vendor files a lawsuit, what suit? Against whom? Purchaser. And eventually it is dismissed. Who can claim compensation? Purchaser. From whom? Vendor. Can you write answers if there's practical question based on this? What is the first one? Imperfect title acquires the title. I also get the perfect title. Consent is required. Can compel to obtain the consent. Third situation, mortgage, having a right to redeem the mortgage. Can you be compelled to redeem the mortgage? Yes. Clear with this? Next one. Next one. Contract which cannot be specifically enforceable. Market important, important, important. There are four contracts for which specific performance is not allowed, cannot be specifically performed. What is the first one? If a party to the contract has obtained what performance? Substituted performance. What performance? I made a promise to supply the goods. I defaulted. You can file a case against me for what performance? Specific performance. But before you file a case, I have obtained the substituted performance. What performance? Means I obtained it from whom? Someone else. Can I claim specific performance from you now? Because I already obtained what performance? Substituted performance. And what performance? Next one, a contract, the performance of which involves the what? Performance of a continuous duty. What duty? Which the court cannot supervise, means a minute things. For example, taking care of a child. It's a continuous duty. Can court supervise it? No. In that situation, there is no what performance? Specific performance. Next one, the contract which is so dependent on the what qualification? Personal qualification. Or what qualification? Like teaching, singing, dancing. These are personal skill. What skill? Can they be specifically enforced? No. And the last one, contract which are what? Determinable nature. What in nature? Determinable in nature. We have clearly agreed in the contract that this contract is terminable by one party giving notice to whom? Other party. And if I cancel it, can you first put against me for recovery of compelling me to perform specifically? No. So these are the four cases. Well, how many cases? Where what is not allowed? Specific performance is not allowed. Well, what is the first one? Substituted performance. Second one, continuous nature. What nature? Continuous nature. Third one, personal skill. Arre, what skill? Is teaching is a personal skill. Can somebody compel me to teach? We will not teach properly. 11. Example. Yes or no. And the last one is what? Last one is contract is what? Determinable in nature. What in nature? Determinable in nature. Are you guys clear with this? They asked questions based on this in the many times in the previous examinations. Yes or no? Next one, guys. Next one. What is the next one? Who power of the court to engage what? Expert. Same thing is there even in case of companies act, right? Expert. Who is an expert? The one who has a specialized knowledge. Engineer, doctor, CA, CS are called as what? Expert. So when court is ordering a specific performance for the purpose of obtaining an opinion, who can employ an expert? Court can appoint an expert. Appoint a what? Expert. It is the duty of the parties to provide assistance to whom? Expert, to carry out any inquiries or examinations or samples or experiments. Yes or no? Next one. Expert is entitled to what? Fees. Correct, right? An expert may require to appear and give evidence in the what? Court of law. Court of law? Court of law. Next one, important. Who may obtain the what? Specific performance. What performance? Regular what performance? Specific performance. Who is the first party? Party contract having a what interest? Legal interest. What interest? In its enforcement. In what? Enforcement. Correct, right? Any party to the contract who has a legal right. What right? Can file a suit for what performance? Specific performance. X and Y have a contract. Now, who can file a suit for specific performance? X against Y and Y against O. X, because they have a legal interest. Next one, a representative in interest or principal. Who is representative in interest? Agent. Who is representative in interest? Agent or the principal, unless the contract involves what qualities? Personal qualities. What qualities? What qualities? You cannot seek what performance? Specific performance from third party. Not allowed, no? Because it involves what skill? Personal skill. Or if it prohibits the what? Assignment of interest. Or the performance of the contract has already been what? Completed. Already been what? Third one, beneficiaries under the what? Settlement on a marriage or family compromise. What compromise? Contract act. There are three members in a family. Two brothers made a contract for the benefit of sister. Can sister file a suit for specific performance? Yes or no? Even though she is not a party to the contract, she can file a suit for what performance? Specific performance. What performance? Specific performance. Because she is the beneficiary under the what? Beneficiary under the what? Family compromise. What compromise? Family compromise. Next one, reversionary in possession. What in possession? You know what is reversionary interest? What is reversionary interest? The right which is residue of the interest which is left with the owner after or the grantor after you have created what? Specific interest. What interest? Specific interest or limited interest. Is it transferable or transferable? Transferable. So reversioner in possession has a right to file a suit for enforcement of what? Covenant. Enforcement of what? Covenant. Entered into with whom? Predecessor on title, and the reversioner is entitled to the benefit of what covenant? Such covenant. Or what covenant? Alright, listen everybody. You transferred property to the X with a condition. I am the one who get the property. There is some condition in that contract. Can I enforce the condition in the contract? Yes, because I'm the what? Reversionary in possession. What in possession? Reversionary in possession. Next one, reversionary in what? Reminder. Reversionary in what? Reminder. Is someone who is entitled to the property after the life's tenant's death. Whose death? But is not in possession during the what? Life tenants, lifetime. Correct, right? I have given this property to X. On death, it goes to Y. Who can enforce the terms of the contract here? Y. Who can enforce it? Y. Next one, in case of LLP, in case of what? LLP has made a contract, it gets merged with a new one more LLP. Now, which LLP can file a suit? New LLP. What LLP? For the enforcement of contract. Next one, company entered into a contract. Who entered into a contract? And subsequently becomes what? Amalgamated with another company. What company? Another company. Which company can enforce the contract? New company. Well, what company? New company. Next one, next one. If a promoter of a company have made a contract before its incorporation, before its what? For the purpose of the company and ratified by the company post incorporation, company can enforce the what? Contract. Who can enforce the contract? Company can enforce the contract only if it is ratified by company. You know, ratification of pre-incorporation contract. Yes or no? Made a contract on behalf of the company with X to buy the property. Once company comes into existence, if company ratifies, now who can file a case for the enforcement of contract? Company can file a case. For what performance? Specific performance. They may ask this question also. Who can file a suit for what performance? Specific performance. What performance? Specific performance. Are you guys clear with this? Tell me in how many cases specific performance is not allowed. What is the first one? What is the first one? First one, substituted performance. Second one, which continuous nature. What nature? Continuous nature. Third one, personal skill. What skill? Personal skill. Fourth one, determinable in nature. Contracts are determinable in what? Nature. Next one, person in whose favor specific performance cannot be what? Enforced. Who are they? What is the first one? One who has obtained what performance? Substituted performance, or he has become incapable of performing or violates any essential terms of what? Contract. If you don't perform your part of the contract, can you compel the other person to perform his part of the contract? No. Next one, fails to prove that he has performed or was willing to perform the essential terms of the what? Contract. Court will not grant or grant what? Specific performance. What performance? First one, you already obtained substituted performance, no specific performance. Second situation, you are incapable of performing your part of the contract, or you violate the terms of the contract. You cannot get what performance? Specific performance. Third situation, you have failed to prove that you have performed or was ready to perform your part of the contract. You cannot get what performance? Specific performance. What performance? Specific performance. Are you guys clear with this, everybody? Next one. Next one. Contract to sell or let the property by one who has no title, not specifically enforceable. I made a contract to sell this building. Am I the owner of this building? No. Can I compel you to perform your part of the contract? Because I don't have any ownership. I don't have any what? Ownership to perform my part of the contract. Yes or no? Next one. Contract which cannot be enforced except with variation. Except with what? Variation. Importantly, they may ask question based on this. Which cannot contract cannot be enforced without variation. Without any what? Variation. First one is what? When one of the party was misled or deceived, or when there is an honest mistake. What mistake? Resulting in not reflecting the intention of the party cannot insist on the performance of the contract as originally written unless they agree to the what? Modified version. What version? Because of deception, because of mistake, excuse me, the contract is not conveying the true intention of the parties. Then the contract is not specifically enforceable unless both the party agree for what? Modification. Agree for what? Modification. Next one. The contract is framed in a way that fails to meet the what? Legal objectives the party had in mind. The plaintiff cannot demand the what performance? Below what performance? Specific performance of the contract without considering the changes needed to align with what intention? Original intention. What intention? If it fails to convey the what? Legal objectives. Last one, if the parties have changed the contract terms after signing it, the plaintiff must accept the modified version of the contract for enforcement of the contract specifically. Next one, person against whom specific relief can be claimed. Means against whom we can file a case. For what performance? Specific performance. Earlier we discussed who can file a case for specific performance. Now we are discussing against whom. Obviously other party. Which party? Other party. Or what party? If it's a valid contract. What contract? Both the parties are liable to fulfill their obligation under the contract and the court can compel the performance from which party? Either party. Which party? Second one, against any person claiming under original party with a title arising after the contract. After the what? Right, what? After the what? Against any person claiming under original party by title arising after the contract. Did you understand anything? Did you understand anything by this point? See, simple, say simple. For example, Mr. CSR sold property to whom? Mr. X to whom? Mr. X. After selling it to X, I sold the same property to whom? Y. Now, who can file a case here? X can file a case against whom? Y. Because he acquired the right after contract, after this contract, or after first, before this contract, after the first contract. Now, who can file a case? X against whom? Y. For recovery of property. Recovery of what? Property. Or a recovery of what? Property. One more time, one more time. Against any person. What person? Claiming under the what? Original party. What party? By title arising after the contract. After the what? Contract. What was the original contract with Mr. X? Then there was a contract with whom? Y. Who can recover it? X from whom? Y. Next one. Against a person. Against a what? Person claiming under the what? Title prior to the contract. What is the contract? Prior to the contract. Same example. CSR. Mr. X. Mr. What? Y. Contract is with whom? X. But however, this contract is invalid. Which contract is invalid? First contract is invalid. Who is the second party here? Y. Can Y claim the performance from Mr. X here? Because who has title here? Y. Because this one is what? Defeated. This one is no more a valid contract. Now who can file a case? Y. Against who? X. Even though there is no privity of contract, there is no what? Arey bolo, there is no what? Privity of contract. Who can file a case? Y. Against whom? X. Against whom? X. Next one. LLP, amalgamation. Again, you can file a case against which LLP? New LLP. What LLP? New LLP gets merged. You can file a suit against which LLP? New LLP. Two companies get merged. You can file a case against which LLP? New company. What company? New company can enforce a contract. If the promoters of the company, what of the company? Made contract before its what? Incorporation. For the purpose of the company, ratified by the company post incorporation, who can enforce the contract? Company can enforce the contract. Who can enforce the contract? Company can enforce the contract. Who can enforce it? Company can enforce it. Who can enforce it? New company can. The company can enforce it. Next one. Have you heard this word called as substituted performance? What performance? You made a promise to supply me raw materials. You failed to supply. Either I can sue for specific performance or I can obtain the what? Substituted performance. First, I have to give a notice to you demanding the performance, and I should give it 30 days of time. Even after giving 30 days of time, if he fails to perform, I can obtain the performance from whom? Alternate person. What person? Alternate person. That is called as what? Substituted performance. What performance? Substituted performance. Are you guys clear with this? Once you obtain substituted performance, you can claim compensation, but can you claim specific performance? No. Clear with this? Can we go to the provisions once? Concentrate everybody. Ulu, when what is broken? What about the remaining? When what is broken? Contract is broken due to the what? Non-performance by a party. The affected party. What party? Has the option to get the contract what? Performed. By which party? Third party. Or through their what agency? Agency. Correct, right? Either I can get it from the third party or from my own agency. The affected party can recover what expenses? Actual expenses, cost incurred to perform the what? Contract. Before obtaining the what performance? Substituting performance. Affected party must send a what notice? Return notice to the which party? Breaching party, giving them at least how many days time to perform the contract? 30 days. If the breaching party refuses or fails to perform, the affected party can arrange the what performance? Substituted performance. And what performance? Substituted performance. If they fail to perform it in how many days? 30 days. Sorry, how many days? If the affected party gets the contract performed by a third party or to their own agency, they cannot claim what performance? Specific performance. That is what I'm shouting since the starting of this chapter. Yes or no? If there is what performance? Specific substituted performance. They can't be what performance? Specific performance. What provision? Performance? Specific performance. Next one, special provisions for a contract with respect to what project? Infrastructure project. See, there is to be cases where one who is having a contract with developers or the banks, they used to get an injunction, prevent the construction process. Because of that, they used to delay the construction. Delay the what? Construction. If they delay the construction of the project, entire project will be in what? Being correct, right? So, इसीलिए with respect to infrastructure project, what project? There are few certain special provision. What provision? What provision? Special provision. So section number 28 provides that. Which section number 28? Bolu, which section number provides the no injunction shall be granted. What should not be granted? Injunction shall be not granted involving the contract with respect to the what? Infrastructure project if it causes the impediment or delay in the progress or completion of such infrastructure project. Central government has the power to amend the what? Schedule contained in the list of what project? Infrastructure project. What project? Can there be an injunction? No. Can the central government alter the list of the infrastructure project? Yes. And this amendment notification should be laid in both the houses for how many days? 30 days. Or how many days? At any cases involving the infrastructure project should be disposed within how many months? 12 months. How many months? How many months? Next one, liquidation damages. What damages? Bolo, what is liquidation damages? We're almost done with the provisions of specific relief. Tell me, what is liquidated damages? Prefixed by the parties. What by the parties? Prefixed by the part. Just because we have agreed that if you break the contract, you are liable to pay this amount of compensation, will that prevent me from obtaining the specific performance? No. If it was the intention of the parties that that amount of money is mentioned just to compel you to perform the contract, not as a compensation. See, if it was mentioned as a compensation for the breach of contract, obviously they cannot ask for what performance? Specific performance. But what if the liquidated damages were mentioned just to force the person to perform the contract? Just because I have mentioned the amount to be payable in case of breach of contract, will it disable me from obtaining the specific performance? No, no, no. Clear with this? Let's read important text. What is the provision? What is the provision? Contracts provides certain amount of money to be paid if the what is broken, contract is broken. What is broken? Court can still order the contract to be performed what? Specifically. If the court believes that money was mentioned only to make sure that contract is what? Performed, not for the purpose of giving to the party in default an option of paying the money in lieu of what performance? Specific one. अर्थमाइंड अंडरस्टूड समझ में आ गया ऐसा नो then we have some specific provisions rectification of instrument rescission of contract and also cancellation of contract. What is rectification? Correction. What is rectification? Important. Rectification means correction of an error. Correction of an what? Error in the what? Instrument where the contract is reduced into writing. Reduced into what? Writing in pursuance of the previous agreement but fails to express the what intention of the parties. Real intention of the parties. Who will rectify the instrument? Court will rectify the instrument. Was in writing but fails to express the real intention of the parties. Party can apply to the court. Who will rectify the instrument? Court. Writing, not expressing the true intention of the parties, court will rectify it. You know, write in the examination condition, there must be a complete agreement between what form? Array bolo what form? Second one, there must be a clear evidence. What evidence? Of actual mistake or fraud. It does not show the real intention of the parties. Rectification of instrument shall not be granted to any party under this section unless it has been specifically claimed. Rectification cannot prejudice the right of what? Acquired by which person? Third person. In what faith? Good faith. For what? Value. So based on the main instrument, I will change the property. Then you are going for rectification. Allowed or not allowed? Not allowed. That will influence my rights, right? You write about rectification of instrument. Yes or no? Next one, rescission of contract. What of contract? You guys tell me what is rescission of contract? Cancellation of contract. Putting an end to the war, contract, and making it null and void ab initio. Tell me when a party can resign the contract if the contract is voidable contract. What contract? Where the contract is voidable or terminable by the plaintiff, or the where contract is what? Unlawful, or defendant is more to blame than the what? Plaintiff. Who can cancel it? Party can cancel it. Who can cancel it? This point is most important. Rescission is not allowed. What is not allowed? In what cases? Following cases. What cases? What is the first one? Expressed or implied ratification by plaintiff. See, I have done fraud, sold shares to you. You discovered the fraud. What are you supposed to do? Cancel it. But you continue to receive my dividend of the company, attending the meetings of the company. Can you cancel it at a later stage? No, you cannot cancel it. Next one, if the circumstances have changed significantly since the contract was made and it is no longer possible to what? Return the parties to their what position? Original position. What position? Original position. God was made. Boy has said that he's a CS. Got married to the girl. Girl, after the marriage, discovered that he's a fraud. But she continues to live with him. She got babies also. After that, she want to cancel. Can she cancel? She could have cancelled it immediately now. Yes or no? You cannot reach to them to what position? Original position. Next one, third party acquired the goods in what faith? Good faith. What faith? I having a possession of the goods under voidable contract, sell it to a person who's acting in what faith? Good faith. You cannot cancel it. Here, and the last one, if only part of the contract is sought to be rescinded and the part cannot be what? Separated. Is it possible to rescind it? No. There is one contract. Part is you only want to cancel part of it, which is not possible to separate. Is the rescission allowed or not allowed? Not allowed. Allowed or not allowed? Not allowed. Next one, cancellation of instrument. What of instrument? Cancellation of instrument. Listen, everybody, when the instrument is what? Void. Instrument is what? Void or voidable. And a person has a reasonable apprehension that instrument, if left unchanged, may cause a serious injury. What injury? He can apply to the court to get it cancelled. Get it what? Cancelled or declared as what? Void or voidable. Void or what? If the court cancels an instrument due to it being void or voidable, the court may also order the person who benefit from the cancellation to register any what? Advantages or benefits they receive from the which party? Other party. Which party? Other party. Clear with this? Yes or no? If you have an apprehension that if the agreement is not declared void, you may suffer a loss. Suffer a what? Loss. Apply to the court to be declared as void. Next one is declaratory decree. What decree? What is declaratory decree? Declaratory decree just declares the rights of a person. For example, now there is a dispute over the parental rights of a kid. Mother is saying you are not the father, but father is saying no, I am the father. Both of them can go to the court and file a case, and court will decide whether he is a father or not a father. That is a declaratory decree. What decree? Declaratory decree. Arrest or no strange situation. A decree by any decree whereby any right to property, right to what? Property or legal character of a person is judicially ascertained. Judicially is called as what? Declaratory decree. Conditions to be satisfied that he has entitled to a legal character or right to property. Defendant is either denying or interested to deny his title to such character or right. Example, status of a adopted son, priest of a temple, legality of what? Marriage. This can be declared by the court, by a declaratory decree. Effect of declaration binding on the what? Parties to the suit, parties to the what? Suit, and anyone claiming the rights to them. It clarifies the right between the parties. What between the parties? Rights between the parties. Yeah. Next we have injunction. What do we have? What is injunction? Order issued by the court which requires a person to do something or forbids him from doing something. That is called as what? Injunction. Either it can command a person to do something or forbids a person from committing a wrong. It can be of how many types? Two types. Prohibitory injunction or mandatory injunction. If it prevents a person from performing certain action, it is called as what? Prohibitory injunction commands a person to actively to restore a previous state or to perform a specified act. It is called as what? Mandatory injunction. What injunction? Mandatory injunction. What is the difference between specific performance and injunction? Specific performance is granted when a party is compelled to perform an active duty or obligation under the what? Contract. An injunction, on the other hand, is granted to prevent the violation of what duty? Negative duty. One is positive in nature, second one is what? Negative. आपने बोला था you will not teach anywhere else. If you're planning to teach anywhere else, they can bring a what? Injunction. Bring a what? Bring a what? Injunction. Next one, specific performance generally applies to what? Contract. Injunctions are primarily applied to what cases? Tort cases. What cases? Tort cases. Contracts positive in nature calls for one relief of specific performance. If a contract involves negative duty, calls for what? Injunction. Calls for what? Tell me when perpetual injunction is granted. What is perpetual injunction? Perpetuity for a particular period of time. Where a defendant is a trustee of the property for the plaintiff, you can get a what? Perpetual injunction, or where there exists a no standard for ascertaining the actual damage caused are likely to be caused by what? Invasion of right. There can be a perpetual injunction. What injunction? Perpetual injunction. Next one, where the invasion is such that compensation in money would not offer what relief? Adequate relief. What relief? Adequate relief. Where the injunction is necessary. What is necessary? To prevent the multiplicity of what? Judicial proceedings. There can be what? Perpetual injunction. What injunction? And the last topic is when injunction can be refused. Important. Based on this, they've asked questions in the examination. When injunction can be refused? To restrain any person from performing a what? Legal case. What case? It has already been started. You cannot refrain a person what he is already doing it legally. Through what? Injunction. Or to restrain a person from starting or continuing a legal case in a court that is not under the what? Authority of the court would give in the injunction. You don't have an authority to issue an injunction to prevent the proceedings already instituted. There cannot be an injunction. Third one, to restrain any person from applying to what? Any legislative body. There can't be an injunction. Anybody can apply to legislative body. Next one, to restrain any person from instituting or prosecuting any proceedings in a what matter? Criminal matter. Next one, to prevent the breach of contract, the performance of which would not be specifically enforced. Means we have discussed the contract which cannot be specifically enforced, continuous nature, personal skill. Next one, prevent on the ground of nuisance an act of which is not reasonably clear. It will be a nuisance. Unless it is a nuisance, it cannot issue a perpetual injunction. To prevent the continuing breach in which the plaintiff has what? Acquiesced, is admitted. You already admitted the fact. You cannot claim the injunction for the breach. Next one, when equally efficacious means what? Effective relief can be certainly obtained by any other usual mode. Next one, when the conduct of the plaintiff or his agent has been such as to be disentitle him to be the what? Assistance of the court. When the plaintiff has no personal interest in the matter. What in the matter? Personal interest in the matter. What in the matter? Personal interest in the matter. There cannot be what? Injunction cannot be granted. What cannot be granted? Injunction cannot be granted. These are the provisions with respect to specific relief. What relief? Specific relief. Now listen, everybody. Everyone must concentrate. Just see. We have discussed this topic, right? Just see whether it is possible for you to answer these questions or not. I want everyone to read these questions honestly. Then only I will share this question, right? Otherwise, I will not share for sure. Because I don't have any obligation to share it. Right, right. Do I have an obligation to share it? Did I had an obligation to make a short notes and share it? But it is my obligation, moral obligation. What obligation? Moral obligation. Because I shall always try to do something extra. Whatever makes the student's job easy is my duty because I'm getting paid for it. I know. Is that no? That is what gives the satisfaction to the teacher. Let's see. Let's see. कुमार क्वेश्चन कुमार लेट्स स्टार्ट साथ में पढ़ाई करेंगे पक्का ऐसा नो चलो guys see hardly we have one more day of class after that even if you want to study or even if you want to read with me is it possible or not possible not possible correct right let's make use of this time and let's learn something take that one more step towards your dream of becoming a company secretary correct now I know it is already 8 hours of class or 9 hours of class 10 hours or 9 hours doesn't matter the time once time starts limitation period start it never waits for anybody there's a continuous running of time what running of time continuous running of time let's start kumar kumar rehu kumar unlawfully takes possession of the house x from the neighbor kumar unlawfully takes the possession of what house x from the Hemant on 4th April 2019. On 9th January 2020, Hemant initiates proceedings under Section 6 of the Specific Relief Act 1963 against the what? Kumar for regaining the possession of the house. Kumar pleads that he is entitled to take the possession of the house because he is the owner of the house. Beside, is he the owner of the house? Because Kumar has taken the unlawfully takes the possession of the house. X from whom? Hemant. On 4th April 2019 and on 9th January 2020, Hemant initiate the proceedings. Who initiate the proceedings? Hemant. Correct, right? And Kumar pleads that he is the owner of the property. Who is the owner of the property? Kumar. Even if he is the owner of the property, you should take the possession of the goods back or property back. Only as per what? Law. Only as per what? Law. If somebody takes the possession of the property in an unlawful way, in that situation, the one who had the possession, can he regain the possession of the property? Can he regain the possession of the property? But if you find a case within how many months? But here it is already how many months? More than how many months? 6 months. Allowed or not allowed? Not allowed. Are you guys in a position to answer the question? Next one. Specific performance of part of the contract. What of the contract? Part of the contract. Have I discussed it? Yes or no? Read the question. Allow contract to sell piece of land to Vimal consisting of 100 bigas for 10 lakh and turns out that only 60 bigas of the land belongs to Alok. Who can demand the specific performance of the contract? Only Vimal can demand a specific performance of the contract, but he has to pay for the what contract? Entire contract. Because substantial portion is what? Not performed. Right, right? I know. Yes or no? Contract which specifically cannot be performed. L a single. Read this question. L a singer agrees to sing at M's theater. CSR a singer agreed to sing at M's theater for a certain period and not to sing anywhere. अरे मैंने बोला इसको. Personal skill. What skill? Is it specifically enforceable? No. But can there be an injunction? Yes. Negative duty है ना. अरे ऐसा no. Abhinav contract with Manoj that he will paint his house. Same thing. Who may obtain what performance? Specific performance. Have I discussed this? And next one. Person in favor of whom specific performance cannot be enforced. Mention the person against whom specific performance cannot be enforced. Who are they? Discuss किया था ना obtain what performance? Substituted performance. Incapable of performing his part of the contract. Here with this next one. Substituted performance. What performance? 30 days of time given, recover expenses obtained from the agency or some other own agency or third party. Yes or no? Can you write something about specific performance, not something exact provisions? Yes or no? Next one, rectification, correction, not containing, not conveying the intention of the parties. Yes or no? Next one, rescission, cancellation. There is a question about rescission. Next one, cancellation of instrument if it is left not declared as void, it may cause the irreparable loss to a person. You may get it what? Cancelled. Get it what? Cancelled. Declaratory decree. What decree? Darshan, read Darshan. Read. Stop talking and read. Let's read. A Hindu in a suit to which B, his alleged wife, is the defendant, seeks a declaration that his marriage was duly solemnized and pray for the order of restitution of conjugal right. What is conjugal right? To live together. ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. Who is ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ? Wife has deserted him. Now the husband wants the wife back. But wife is saying that no, 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 was not a valid marriage, so I don't want to come back. Now we want a declaration of the court that it was a valid marriage. Can you get that declaration? Yes. See a third party claiming that B is the wife, sues A for the recovery of B, decide whether the declaration made in former suit is binding upon the C. Uh, the court makes a declaration and order of restitution of what? Conjugal rights. C is a third party claiming that B is his wife. Oh, sues A for the recovery of what? B. Oh my God. What a twist in the story. So, now who has the right? A has the right. Now, there is already a declaration that she is the wife of A. But yes or no? She is the Ibbara Kannada Muntina. Next one. Effect of declaration binding on the parties to the suit and anyone claiming under the what? Rights to them. It clarifies the rights between the what? Parties. Between the what? Parties. When perpetual injunctions can be granted. Injunction when refused. Discuss किया था ना when it is refused. Yes or no? These are the provisions with respect to what? With respect to specific relief. What relief? Specific relief. Easy question से एक बार go through कर लेना. Hardly it takes 30 minutes of your time for revision purpose. 30 to 35 minutes of time. Correct, right? Once you do the revision, solve the question and answers, you'll be thorough and you'll be ready for the exam. Correct, right? Because we have covered every topic which is there in the material, ICSM material. Correct now, yes or no? And for example, should refer to what material? Detailed material. What material? Detailed. This is only for a revision purpose. What purpose? Revision purpose. Are you guys clear with this? Yes or no? Make some noise, guys. Yes or no? Let's start with the next. See, law relating to limitation. So why do we have limitation act? To make sure that no person is harassed for a long period of time, the commission of any or violation of any right. So there should be a time limit within which a person should enforce his right in the court of law. No one should sleep over his right. If you have a right, you get the remedy as early as possible. It is based upon the principle called as vigilantibus, not tormentibus. Means the court will assist a person who is vigilant and active, not the one who is dormant or not the one who is sleeping. Right, right. Yes or no? Limitation Act, the most important section. I will not get into the basic concept. We have discussed the basic concept. What is suit? What is appeal? What is application in the class? This is a marathon revision. So let's focus from the examination point of view. What point of view? Examination point of view. Most of the previous examinations, they asked question based on section number 3. Section number 3 is a bar of limitation. Bar of what? Limitation, which provides that any suit, appeal, or application made beyond the what period? Prescribed period. It's the duty of whom? Court not to proceed with such suit, irrespective of the fact that the plea of limitation is set by whom? By the defense or not. It is the duty of the court. Section number 3 imposes the duty upon the court to not be proceed with the trial of a suit if it is what bar? Time bar. What bar? Time bar. The provision of section 3 is or what? Mandatory in nature. What in nature? Mandatory in nature. The court can take suo motu note of the what? Question of limitation. Question of what? Limitation. The question whether the suit is barred by limitation should be decided on the facts as they stood on the date of what? Presentation of plaintiff. Presentation of what? Court is under an obligation to dismiss the suit if it is filed beyond the what time prescribed by the limitation act. Now tell me, do section number 3 deprive the jurisdiction of the court? No. It only imposes an obligation upon the court because we know that any decree or order passed by the court without jurisdiction is nullity. Point from the beginning itself. But however, if a court has jurisdiction, having jurisdiction, if it passes the order, exercising the jurisdiction in an irregular manner. What manner? It is an error committed by the judges that can be set right by an appeal. By what? Appeal. What if a person does not prefer the appeal? The decision becomes what? Valid. Becomes what? Valid. Because section number 3 does not deprive the jurisdiction of the court. It only provides a time limit and it only imposes an obligation upon the person, not person, on the court to not to try the suit beyond what period? Prescribed limitation period. Therefore, decision of a court allowing a suit which had been instituted after the what period? Prescribed period is not vitiated for the want of what? Jurisdiction. A decree passed in a time barred suit. What suit? Time barred suit is not a nullity. Not a what? Nullity. Yes or no? सेक्शन नंबर क्या है? 3. सेक्शन नंबर क्या है? 3. Bar on limitation important है. Tell me any decree or order passed admitting a time barred suit, valid or not valid? Valid unless it is set aside by the higher court through an appeal. Because section number 3 does not deprive the jurisdiction of a court. It only imposes an obligation upon the court to not try a suit after the prescribed period of what? Limitation. Prescribed period of what? Limitation. Next one, closure of court. Simple provision. If a court is closed on the last date to file a suit or appeal or application, in that situation, the same thing can be done whenever the court reopens. What reopens? Court reopens. Next one, section number 5. Section number what? 5. Tell me section number 5. Applicable for suit or only for appeal or application? Appeal or what? Application. Because for a suit, there is a considerable time, longer period of limitation. But for appeal and application, there is a shorter period of limitation. If there is a sufficient cause, what cause? Court may extend the time limit to prefer an appeal or application. Tell me, section number 5 is a discretionary power or a discretionary powers? Tell me, can court reject to extend the time even if there is sufficient cause? If there is no justice, if there is no question of justice, in that situation, who may reject it? Court may reject the application or an appeal, even if there is a what cause? Sufficient cause. Remember, I discussed a divorce case law. What case law? Divorce case law. Person was in coma, then he comes back. By that time, she get married to some other person, waiting for a limitation period. There can't be any remedy by the court, right? Because she already got married to whom? Someone lawfully married, even though he has a sufficient cause. There is no question about extension of time period. Extension of what period? Time period. First of all, doctrine is sufficient cause applicable only for what? Appeal or what? Application. Not applicable to what? Suit. Next one. The term sufficient cause is not defined in the which act? Limitation Act. The party applying for condonation of delay should satisfy the court for not making an appeal or application within the prescribed period for what cause? Sufficient cause. What cause? Non-availability of the case file. What file? The state council is not a sufficient cause because you are a government. We are having all these uh, documentations, correct? Right? Are you guys clear with the sufficient cause? It's the what power of the court? Discretionary power. What power? Court may extend it, may not extend it. Applicable only for what? Appeal or application. Appeal or what? Application. Next one, section number 6. Important. Based on this, they ask questions many times in the previous examination. Person under what disability? Legal disability. What disability? If a person entitled to file a suit or to make an application is a minor or an unsound mind or an insane or an idiot, when the limitation period begins, what begins? They can file a suit within the what time? Same time. After what ceases? Disability ceases. If a person is under two disability, what disability? At the time when the limitation period starts, or if they get second disability before the first ends, they can file a suit or application within the what time? Same period after both disabilities ends. What is the first one says? Person entitled to file a suit or application is a minor or an insane or an idiot. Then uh, when the limitation period begins to run, then for such person he can file a suit within the same time limit after what ceases? Disability ceases. What ceases? Disability ceases. Next one, if a person is under double disability at the time of starting of the what period? Limitation period. Or if you get second disability before the first disability season, the limitation period starts for him. When both the disabilities ends. Clear or ceases? Clear? So we are discussing when the limitation period starts. What start? Limitation period starts. You should tailor your answer or you should write your answer keeping this mind when the limitation period starts. Scenario. First scenario. What is the first scenario? Minor, idiot, insane. When? When at the time when the limitation period starts. When we can file a suit? When the disability ceases. Second one, double disability or one disability before the other disability ends. Then when you can file a case, both disability ends. Next one, if a legally disabled person dies before legal disability ends, the representative can file a suit and an application within the what period? Same limitation period, starting from the date of what? Person's death. Whose death? Person's death. Same limitation period, legal ends. Next one, if the legal representative of the deceased person is also under legal disability, after disability ceases, or there is a legally abled representative disability ends. And the last one, if a legally disabled person dies after legal disability ceases, then the legal heads can file a suit within the remaining limitation period. Section number 6, not applicable for what? Appeal. Only for what? Suit or applications. Clear with this? First one, disability ceases. Second one, more disability ceases. Third one, legal heads. Dies, legal heads. Fourth one, after disability ceases, dies, legal representative within the what period? Same remaining limitation period. Clear with this? Next one, disability of one of the joint person. What person? Joint person. See, if two or more persons have inherited a joint rights. What rights? Joint rights. Are some of them under the legal disability? What disability? I repeat, a joint right is inherited by group of persons. one of them under legal disability. In that situation, the limitation period will start only when one of the person can give a valid discharge to all the person without their consent, without their what? Consent. What if one person cannot give a valid discharge to the other person without the consent of other person? Can there be a limitation period? It will not start. It will not start. Only if it can give a valid discharge. For example, Karta of HUF can give a valid discharge without the consent of whom? Family members, then the limitation period start. Otherwise, limitation period will not start. Keep this in mind. A joint right inherited by group of person, group of what? People, and some of them under what? Legal disability. The limitation period for enforcing the right will run only if a valid discharge can be given by one of the joint owners without the consent of one person, disabled person. What person? Section number 8. What is section number 8? If a person is under legal disability, the limitation period for them to file a suit or take action will extend only for how many years? 3, irrespective of the normal period of limitation. It may be 8 years. If you claim the benefit of section number 6 or section number 7, once your disability ceases, you will get only how many years? 3 years. How many years? 3 years. Clear with this? Yes or no? 6, disability. 7, joint rights. 8, restrictions on 6 and 7. How many years? Section number 9, continuous running of time. Once limitation period starts, it will never start for whom? Anybody, irrespective of disability or inability to file a suit. कोई रुक नहीं सकता. एक बार शुरू किया और शुरू हो गया, कोई रुक नहीं सकता है. Once it starts, nobody can stop. Nahi. Provision says time limitations. Ah, very good. I was expecting this. Very good. Time limit for limitation runs when the cause of what arises? Action arises. Once the time has started running, it will continue to run. Continues to what? Run. Even if the party becomes what? Subsequently disabled or unable to institute a suit or application. Once the limitation period begins to run, it continues to run irrespective of the party becomes subsequently disabled or to file a suit or application. Section number 9 does not apply to what? Appeal. Does not apply to what? Is it applicable for suits? Application? Yes. Exception? If a debtor is granted letter of administration to the estate of creditor, the limitation period for filing the suit to recover the debt will stop running while the administration process is ongoing. See, simple, say simple. I am the creditor, she is the debtor, I am dead. Now she got the letter of administration to administer my property. My legal heir have a right to file a case against her, but she is only managing my assets. Will she file a case against herself? Will she file a case against herself? No, she will not file a case for the time period during which the debtor was granted letter of administration, letter of what? Should be excluded or the time period will stop for the purpose of limitation. Purpose of what? Limitation. Are you guys clear with this? See, I am the creditor. She is the debtor. Do I have a right to file a case against her? Yes. Defaulted already 1 year over. How many years left? 2 years left. Now I am dead. My legal heirs has a right to file a case within how many years? 2 years. How many years? But however, she got letter of administration. Means she is the one who is managing my assets. She got this letter of administration for how many years? 1 year. How many years? In this 1 year, will she file a case against herself? No. So this 1 year period, but this 1 year period, what will stop? Limitation period will stop. Because letter has been granted what? Letter of administration. Letter has been granted with what? Letter of administration. Next one, next one. Are you guys clear with section number 9? What section number 9? Once the limitation period stop, it continues to run irrespective of any subsequent disability or inability. Yes or no? Only exception is what? If a debtor has been granted letter of administration to the assets of the creditor, the limitation period for filing a suit or to recover the debt will stop running while the administration process is what? Ongoing. Section number 10, section number 10, cases involving what? Trustee. Suits are not barred by time if it is a case involving what? Trustee. Trustee beneficiaries can file a case against trustee for alleged violation of trust whenever they want, irrespective of time limit, and as suits with respect to property held in what? Trust. There is no what limit? Time limit. Or a what limit? Any suit involving a trustee or any suit to a property held in trust, not barred by what? Time, regardless of how much time it has passed. Next one, section number 12. Section number what? 12. Important. Based on this, they may ask question in the examination. Exclusion of certain days a time in what proceedings? Legal proceeding. While counting the limitation period, you should not include following days. You know what is the limitation period, right? Limitation period starts on the date when what occurs? Cause of action. For a debt, what is the cause of action? Default in payment of debt. Default in payment of what? Debt. For recovery of right to recover compensation for a tort, the date on which what is committed, tort is committed. Correct, right? So when calculating the limitation, you should exclude the following thing. First one, suit, appeal or application. The day on which what starts? Limitation period begins to run. Should be what? Excluded. Should be what? Excluded. What should be excluded? The date on which what starts? Limitation period starts. What start? Should be included, should be excluded, should be excluded. Next one, in case of appeal, application for leave to appeal, revision, review of judgment, the day of the judgment, the time taken to take the copy of the judgment should be excluded. We have solved so many cases based on this. Remember, not the time you take, the time taken by whom? Court. To give the copy of the what? Judgment should be excluded while computing what period? Limitation period. For what? Time limit for appeal or leave to appeal or revision or review of judgment. Next one, application to set aside the what award? Arbitral award. What award? If you want to set aside the arbitral award, you want to go for an appeal. For the purpose of that, to calculate the time limit, you have to exclude the date of award and the time taken to get the copy of the what? Award. Same thing like appeal or application for leave to appeal or revision or review. Understood? Next one. In suit or appeal. Suit or what? Appeal. Listen everybody. In a suit or appeal, if a person has filed a petition, find a suit as pauper. You know what is pauper? Insolvent or indigent person. The time taken by the court should be what? Excluded. A person has applied to sue as a pauper. The application was made in what faith? Good faith. The application is what? Rejected. The time spent on the application shall be what? Excluded. Shall be what? Excluded. In what faith? And only if the application is rejected. If it is approved, then directly you can go for suit. And what are the conditions? Application was made to file a suit as what? Pauper. In what faith? Application is what? Rejected. The time spent on application shall be excluded. Next one, time taken by a court without what? Jurisdiction. You filed a suit in a court which is not having a jurisdiction in good faith with the proper diligence. What diligence? Proper diligence. In that situation, the time taken by the court should be what? Excluded. Should be what? Excluded. The plaintiff or the applicant must have been prosecuting the previous proceeding with a due diligence. Previous suit or the application must lead to the what matter? Same matter. The plaintiff or the applicant must have acted in what faith? Good faith. The previous court must have been unable to entertain the suit or the application due to the lack of jurisdiction or other similar causes. Similar what? Causes. Next one. What do we have next one? Exclusion of time in what cases? Certain other cases. What is the first one? Stay order. What order? If there is a stay order to file a suit or an appeal, the date on which the stay order was granted, the day on which it is vacated, should be the time period between these two should be excluded. Stay order. Next one, consent or notice required. If any consent of the government or sanction of the government is required, time taken by the government to provide the sanction should be excluded while computing the what period? Limitation period. What period? Next one, suit for execution of decree. By whom? Liquidator. How many months should exclude? 3 months. From the date of their appointment, should exclude how many months? 3 months. Because they need time to get acquainted with what? All the pending matters. What matters? All the pending matters. Next one, suit for possession by what? Purchaser at a sale in execution of what? Decree. This I have discussed in detail. Remember, the time during which the proceeding to set aside the sale has been prosecuted shall be excluded. See, simple says simple. I got a decree. I sold it to her. The one against whom the decree is passed, he filed a suit challenging this sale. Now she has the right to file a suit for recovery of possession. But already he has gone for a what? Appeal. Gone for a what? Challenging this sale. The time period during which the suit has been filed should be excluded while calculating her right to file a suit for recovery of the possession of the property. What of the property? Possession of the property. Next one, defendant residing where? Outside India. Where? If the defendant residing outside India, the time during which he was outside India shall be excluded. Next one. Death of the defendant. Death of the what? Defendant before the limitation period starts. What start? Limitation period starts. The limitation period shall be calculated from the time the legal representative is available to institute the what? Suit or make the application. Before limitation period start, if a person dies, you have to calculate the limitation period. What period? What period? Limitation period. Once there is a what representative? Legal representative. Exclusion of times. Are you guys clear with this? Tell me for an appeal. What you will exclude? Date of judgment, time taken to obtain the copy of the judgment. Pauper. Application to file a suit has pauper. Application has been rejected. It was made in good faith. Time you will exclude. Stay order. Date of stay. Eviction. Time period should be excluded. Clear with this? Yes or no? Next section number 16. 16, 16, 16. Important है. Limitation period in cases of what? Fraud or mistake. Fraud or what? If there is a fraud or a mistake or a concealment of what? Document, the limitation period will start when the person discovers the fraud or discovers the document or has a means of discovering the fraud or discovering the document. Right? Yes or no? You are doing some fraud. Unless until I discover the fraud, how will I have a right to file a suit? So limitation period starts only when I discover the what? Fraud. Yeah? Where the suit or an application is based upon the fraud or mistake of the what? Defendant or respondent or is what? Agent. Excuse me. Huh. In other cases, as mentioned in the what? Section 17 of Limitation Act, the period of limitation shall not begin to run until the plaintiff or the applicant has discovered the fraud or mistake or could with reasonable diligence have discovered it. With what diligence? Reasonable diligence have what? Discovered it. In the case of concealed document, what document? Until the plaintiff or the applicant first had the means of producing the concealed document or compelling its what? Production. Correct, right? You have done a fraud or you have concealed the document. For me, limitation period will start only when I discover the fraud or only when I discover the what document. Concealed document section number क्या है? 16. For execution of a decree, judgment deters fraud or a force. When the judgment deterred by fraud or a force prevents the execution of a decree or order within the period of limitation, may extend the period of what? Execution of the decree or order on the application of what creditor? Judgment creditor. What creditor? Who is judgment creditor? Decree holder. Who is judgment debtor? The person against whom what is passed? Decree is passed. Yes or no? Such application shall be made within how many year? 1 year from the date of discovery of the what? Fraud or cessation of the force. Cessation of what? Force. Last topic, guys. Concentrate, concentrate, concentrate. Section number 18. Effect of acknowledgement on the period of limitation. What is acknowledgement? Admission. Simple say, simple provision. Whenever there is an acknowledgement of liability, what will start? A fresh period of limitation period will start, provided the acknowledgement is made before the lapse of what period? Limitation period. What period? Limitation period should be in what form? Written form, signed by the person or his authorized agent. What agent? There must be an admission or acknowledgement. Such an acknowledgement must be in respect of property or a right. It must be made before the expiry of what period? Limitation period. It must be in writing, signed by the party against whom such property or a right is being. Understood? See, section number 18 is expressed acknowledgement. Section advisor. Section number 19 is what? Effect of payment of interest or account of what? A legacy means it is the implied acknowledgement. What acknowledgement? Implied acknowledgement. Correct, right? Means if you make any interest payment, what payment? Interest payment or a part payment or payment on account of what? Legacy. On account of if a person makes payment of interest or any payment on account of legacy before the expiration of what period? Limitation period. What will start? A fresh period of limitation start from the date of what? Payment. Date of what? Payment. Correct, right? Right or no? Any payment of interest, we give a fresh period of limitation. That next one, section number 20, acquisition of ownership of what? By possession. Easement rights, correct, right? If a person is enjoying the right to use right air, light, way, water course, use of water, or any other easement have been peaceably enjoyed without interruption for how many years? A person is having an access and using the right to light, air, way, water course, use of water, or any other easement have been feasibly enjoyed without interruption. Bolo, without any what? Interruption. For how many years? 20 years. And 30 years in case of property belongs to whom? Government. It should be absolute and indefeasible. At the time the suit is filed to claim the easement, the 20 or 30-year period must have ended within how many years? Last means you should file it within how many years? 2 years to claim that right. Next one, limitation and writ under the Constitution of India. Tell me, is the Limitation Act constitutionally valid or not valid? Valid because it deals with the future right of filing a suit. Tell me, can there be a limitation period for the enforcement of fundamental rights? No. And for filing a writ petition? No. But however, the Limitation Act does not apply directly to the what? Proceedings under Article 32 or 26 of the Constitution of India. However, the court may apply the what? Analogy of Limitation Act in such a cases and refuse the relief if the delay exceeds the period of what? Limitation prescribed for the similar ordinary suit. See, there can be a situation where a matter is subject of ordinary suit as well as writ petition. Example, contract with government. Contract with what? Either you can file a writ of mandamus to seek the payment, or you can file a civil suit. Civil suit within how many years? How many years? It is already time barred. Now, what people will do? They'll go for what petition? Writ petition. Because there is no what limit? Time limit. For writ of mandamus, is there any time limit? Is there any time limit? There is no time limit. There is no time limit. So what person can do? They can take the route of writ petition, right? In that situation, even though there is no time limit for writ petition, by applying the analogy of the normal suit, what court can do? They may not entertain the writ petition because it is already time barred as per the civil suit. Correct, right? I repeat, if a civil suit is time barred, court by applying the analogy of the limitation act may not allow the writ petition after the expiry of what period? Limitation period. But however, in general, for enforcement of fundamental rights or filing writ petition, can there be a limitation period? No, there is no what period? Limitation period. So with these, we are done with what? Limitation Act. Which Act? Limitation Act. Which year? 1963. So let's discuss the question and answer. Question and what? Okay, question and answers. Chapter 10, Law with respect to limitation. Is Section 3 of Limitation Act mandatory in nature? Yes. It imposes what? Obligation upon the court. Law of limitation bars the remedy in the court of law when the limitation period has expired. But it does not extinguish the right that it cannot be what? Enforced by judicial process. If there is any other alternative remedy available, you can claim that remedy. One of the section is section number 15, section number 61 of the Contract Act. Creation of payment. But of payment, even though it is time bound, if a person makes a payment voluntarily, you can apply that payment towards what debt? Time bound. What debt? Next one. Doctrine of doctrine of what cause? Sufficient cause. What cause? Explain the doctrine of sufficient cause for condolation of delay. The test of sufficient cause is purely what? Individualistic test. Correct, right? What is sufficient cause in one case not be sufficient cause in what case? Other case. Even both of them are similar cases. Correct, right? Yes or no? Next one. Person under legal disability. Can you answer this question? Person under legal disability. Yes or no? Provisions relating to the person under legal disability under which act? Limitation Act. Which act? Limitation Act. Can you write? Disability seizures can file a suit. Double disability, both seizures. Disability dies, legal heirs, same period of limitation. Before this, after disability ceases, dies legal representative within the remaining period of limitation. Correct, right? Darshak, yes or no? Yes. Next one. Under Limitation Act 1963, the limitation period for filing a particular suit is 3 years. When the limitation period commenced, Akash was minor of age how many years? Once he becomes a major, he would be having how many years of time? 3 years of time. Continuous running of time. Once time period starts, it will never stop except in case of letter of administration granted to the debtor to the assets of the creditor. Correct, right? Next one. Next one. Manoj died on 3rd of August 2016 before the right to institute a suit accrued, leaving behind a minor son of the age of how many years? When the limitation period starts? Once he becomes a major. Once he becomes what? Understood. Next one. Computation of period of limitation, exclusion of time period. Can I write the answer? Exclusion for filing a suit. Date on which cause of action arises should be excluded. Appeal or application, date of judgment, and time taken to obtain the copy of the award. Judgment to set aside the award, date of award, time taken to obtain the copy of the award. Next one, suit or appeal. Suit or what? Appeal, proper time taken by the court without what? Jurisdiction. Extension of time in what cases? Certain cases, stay order, consent is required, execution of decree, defendant deciding where? Outside India. Discuss किया था ना? Next one, death of a person before the right to sue. Then the legal heads limitation period will not start unless until there is a legally able person to file a suit. Darshan, next one, fraud. If there is a fraud, when the limitation period start? After discovery of fraud or when you have a reasonable cost to discover that fraud. In case of hiding the documents or concealment of document, the documents are discovered. Documents are what? Effect of acknowledgement, section number 18. Can write answer for acknowledgement of debt or liability. Next one, section number 19, part payment. What payment? Then what period will start? A fresh period of limitation will start. Writ and limitation. Writs and what? Limitation. Writ and what? Limitation. Writs and what? Limitation. There is no limitation period for writ. But however, if the suit subject of civil process is time part, would apply the analogy of limitation. may not entertain the writ or refuse the writ. Correct, right? But however, there is no limitation period for writs. Okay. Next one. Name the kind of suits for which limitation period is 30 years to 12 years. Maximum and minimum period of limitation. General question. And this question is important. When the date was not fixed by the parties for the performance of specific date, then how the court will complete the what period? Limitation period. And when does the limitation period starts for filing a suit? Decide with the help of the what? Case law. What cause? Case laws. See, I have not given the case laws because it is highly impossible for the human brain to remember all the case studies. We have so many subjects. We have Companies Act 470 sections. We have Constitution of India. Remember the gist of the case. What of the case? Gist of the case. It is highly humanly impossible. It should be a medical miracle to remember all the case names. When it is not possible for me, how can I expect my students to remember the case names? But you should understand what happened in the case. That is what called as knowledge. What you will do with the name of the case? Name is not important. Concept is important. If the concepts are clear, then you can write the answers in the examination. You can mention that in one of the decided cases. What case, sir? One of the decided cases. Yes or no? With these, we are done with what? Limitation Act. Which act? Which act? Limitation Act. 1963. Good morning. Welcome to day 3 marathon revision of jurisprudence, interpretations, and general laws. Let's start with lesson 11, the law with relating to the arbitration, mediation, and conciliations. So let's start. So what is arbitration? What is arbitration? It is the means by which parties to the dispute gets their dispute settled through the what? Intervention of the third person. What person? The third person is called as what? Called as the arbitrator. Called as what? Arbitrator. Without having a recourse to the court of law. Court of law? Court of laws. So parties try to get their dispute settled or resolved to the intervention of a third party called as the arbitrator without having a recourse to the ordinary process of law under the civil procedure code. That is called as what? Arbitration. Called as what? And arbitration is governed by which act? Arbitration Act. Which act? Arbitration Act. Types of arbitration. Are you guys clear with the definition of arbitration? Arbitration includes what? Whether it is administered by the arbitral institutions or not. It can be formal arbitration as well as the ad hoc arbitrations. Correct, right? So arbitration means where the parties to the dispute get their dispute resolved to the intervention of a third party called as an arbitrator without having a recourse to the course of law or a normal course of laws. Correct, right? There are types of arbitration. So what are the types of arbitration? What is the first one? Ad hoc arbitration. What arbitration? What do you mean by ad hoc arbitration? A arbitration which is not administered by what? Formal organizations. What organization? Formal organization. We have the Arbitration Council of India and Delhi Commercial Arbitration Council. So if those arbitral institution administers the arbitration or conduct the arbitration, that is called as what? Called as the formal arbitration. What arbitration? Formal arbitration or institutional arbitration. But when the parties they decide and agrees and appoint an arbitrator and they decide the procedure to be followed in the arbitration, it is called as what? Called as the ad hoc arbitration. What arbitration? So what is ad hoc arbitration? Arbitration which is not administered by whom? Formal organization. It is called as what? Arbitration? Ad hoc arbitration. Then we have domestic arbitration. What is domestic arbitration? Other than international commercial arbitration, it is called as what? Domestic arbitration. What arbitration? So to understand what is domestic arbitration, the one must refer to what arbitration? International commercial arbitration. What arbitration? International commercial arbitration. What is international commercial arbitration, sir? What is international commercial arbitration? If one of the party in a dispute, one of the what? Party in a dispute come under the any of these four category, then it is called as what? Called as the international commercial arbitration. Obviously, in a dispute, there should be minimum how many parties? Two parties, because one cannot have a dispute with himself. Correct, right. So out of these two parties in a dispute or in an arbitration, if one of the party come under any of these four categories, then it is called as what arbitration? International commercial arbitration. What arbitration? International commercial arbitration. What is the first category? If he is an individual, if he is a what? If one of the party is an individual, and if that individual, if he is a national or habitually resident in where country other than India, if he is a national of any other country other than India, or if he is habitually residing outside India, then it is called as what arbitration? International commercial arbitration. What arbitration? Second one, if one of the party is a body corporate, and if the body corporate is incorporated where? Outside India. Can we say foreign company? What company? So, for example, if there is an arbitration between Reliance company and Amazon, they have a dispute now. They are going for arbitration. This is called as what arbitration? International commercial arbitration. Why? Because Amazon is a what company? Foreign company, incorporated where? Incorporated where? Outside India. Incorporated where? Outside India. Are you guys clear with this, everybody? Yes or no? So third situation, if it is an association or body of individual or a partnership firm, in that scenario, if the management of an association or body of individual is controlled or exercised where? Country other than India, means outside India. Or if it is a government of what country? Foreign country. In these four situations, it is called as what arbitration? International commercial arbitration. I will give the example. You guys should tell me whether it is a international commercial arbitration or not. For example, there are two parties. Let's assume CSR is one party and the other party is from USA. What arbitration? International arbitration. He is from India, but he is habitually residing outside India. What arbitration? International commercial arbitration. Now I have a dispute with a company which is incorporated in UK. International commercial arbitration. There is a partnership firm in India, but the control is from USA. International commercial arbitration. Or I have a dispute with USA itself, the country. Or there are two countries who have a dispute. That is called as arbitration. International commercial arbitration. Are you guys clear with this? What is domestic arbitration? Other than international commercial arbitration, where the arbitration is between whom? Between the two individuals who are nationals of India. Nationality having nationality of what? India. Clear with this? Yes or no? So we're discussing what types of arbitration. Types of what? What is the first one? Ad hoc arbitration. Second one, domestic arbitration. Third one, international commercial arbitration. Fourth one, institutional arbitration. What is institutional arbitration? Arbitration administered by what? Arbitral institution. What institution? So we have the arbitral institutions like Arbitration Council of India, Indian Council of Arbitration, then Delhi International Arbitration Council, and Mumbai Council of International Arbitration. When these arbitral institutions administers the arbitration, it is called as what arbitration? Institutional arbitration. Bolo what arbitration? So any arbitration other than institutional arbitration, it is called as what? Ad hoc arbitration. What arbitration? Are you guys clear with this? If an arbitration is conducted or administered by the arbitral institution, it is called as what arbitration? Institutional arbitration. Other than that, rest everything is called as what? Ad hoc arbitration. And we have discussed domestic arbitration as well as the international commercial arbitration. So can you answer in the examination if they ask question about what is arbitration and types of arbitration? First of all, tell me what is arbitration? Arbitration means the arbitration, whether it is administered by the formal arbitral institutions are not. But in general, arbitration means where the parties to the dispute agrees to settle the same to the intervention of which party? Third party called as what? Arbitrator. Called as what? Clear with this? There are how many types of arbitration, everybody? Four types. What are the four types of arbitration? Ad hoc arbitration, domestic arbitration, international arbitration, institutional arbitration. What are the essentials of arbitral process? In an arbitration, what are the essential element? What element? Essential element. We're going to discuss all these things in detail, but at the starting, they are given in brief. What we're going to study under the arbitrations. First one, seat of arbitration. What of arbitration? Important is the seat of arbitration. What is seat of arbitration? Where the arbitration happens. What happens? Arbitration happens. See, the place of arbitration is important for the purpose of deciding the jurisdiction of the court. What of the court? If your parties have agreed that place of arbitration is Bengaluru, which court has jurisdiction over this arbitration? Bengaluru court has jurisdiction. Correct, right? For the purpose of deciding the jurisdiction, what is important? The place of arbitration or seat of arbitration is different, important. Correct, right? See, hearing may happen in different place. Seat of arbitration is different, hearing is different. If it is convenient for both the parties, even though seat of arbitration is Bengaluru, the arbitrator may meet at where? Chennai. But still, place of arbitration is what? Bengaluru. And which court has jurisdiction? Bengaluru court has jurisdiction. What is the first essential? Seat of what? Arbitration. Arre bolo, seat of what? Next one, venue of arbitration. What of arbitration? What is venue of arbitration? The physical location where hearing happens. What happens? So you decide the jurisdiction of the court based on the venue of arbitration or seat of arbitration? Seat of arbitration. Very good. What of arbitration? Seat of arbitration. Next one, arbitral institution. What institution? We have the formal arbitral institutions like what? Indian Council of Arbitration, Delhi International Arbitration Council, and Mumbai Commercial International Arbitrations. Clear with this? Next one, law. Parties are free to select the what law? Substantive law. What law? The law under which the dispute has to be resolved. For example, if it is a partnership dispute, which act is applicable? Partnership Act. Sale of goods act, sale of goods act. Companies Act. Clear with this? Next one, the language. Who are free to decide the language? Parties. If they don't decide, then who will decide? Arbitral tribunal will decide. Very good. Number of arbitrators. Bolo bolo. Should be what number? Odd number. What number? Should not be what number? Even number. Shall not be a even number. Should be odd number, and parties are free to decide. If there is no agreement, then it will be how many arbitrator? One arbitrator, a sole arbitrator. Very good. Cost. Who should bear the cost of arbitration? Who will decide? Arbitral tribunal will decide. Cost of arbitration includes the fees payable to the arbitral institutions as well as the legal expenses and various other expenses. Correct, right? So all these good things we're going to discuss in detail again. Clear with this? Yes or no? Next one, cases that do not fall under the purview of the arbitration. Important, following cases does not come within the ambit of what? Arbitration. What are those cases or what are those disputes which does not come within the ambit of arbitration, sir? First one is what? Criminal offenses. Well, what offenses? What offenses? Criminal offenses. Can we settle the criminal offenses through the arbitration? Possible or not possible? Not possible. First one is what offenses? Can criminal offenses be resolved to the arbitration? No. Second one, family matters. What matters? Divorce, adoption, inheritance rights, all these cannot be referred to where? Arbitration. Next one, matters with respect to insolvency and bankruptcy. Insolvency and what? Cannot be referred to the arbitration. Fourth one, validity of the will, a testamentary dispute. What is testamentary? Testamentary means what? Testamentary means which takes effect after death of a person. Will is a testamentary instrument. What instrument? What instrument? What is testamentary? Which takes effect after the death. After the what? Death of a person. Matters that affects the public policy. What policy? Which are of public importance or affect the public good. Next one, dispute with respect to rights of which parties? Third parties. Cannot be referred to where? Arbitration. Next one, taxation matters. What matters? Arre bolo, what matters? Taxation matters. Can taxation matters be referred to arbitration? No. Next one, dispute with respect to what? Enforcement of judgments or orders. Judgments are what? Orders. Consumer disputes. What disputes? Can you refer consumer disputes to arbitration? Allowed or not allowed? Not allowed. Next one, dispute with respect to what? Interest of state. What of states? The rights of the state. These disputes are outside the scope of what? Arbitration. They cannot be resolved through the arbitration. First of all, what is arbitration? It's getting a dispute settled through the intervention of a third party called as the arbitration. Definition of arbitration: whether it is administered by Formal arbitral institutions are not. That is called as what? Arbitration. Next one, definition of court important for the purpose of overseeing the mechanism of arbitration. What do you mean by court? Court means in case of other than international commercial arbitration, court means the principal civil court. Bolo? Principal civil court. What is the principal civil court of which one is the principal civil court? District court. What court? Principal civil court of what jurisdiction? Original jurisdiction in a district. Nothing but what court? District court. High court of what jurisdiction? Ordinary, original, civil jurisdiction. What jurisdiction? Ordinary, original, civil jurisdiction. Right. What is the first one? Principal civil court of what jurisdiction? Original jurisdiction in a what? District. Second one? High court having what? Ordinary, original, civil jurisdiction does not include any court inferior to which court? Principal civil court. Which court? Principal civil court or court of what causes? Small causes. What causes? Right. What do you mean by court for the purpose of other than international commercial arbitration? Principal civil court of having what jurisdiction? Original civil jurisdiction. High court ordinary original civil jurisdiction does not includes what? Any code inferior to which code? Principal civil code and the court of what causes? Small causes. What causes? Next one, in case of international commercial arbitration. What arbitration? International commercial arbitration. High court having what jurisdiction? Ordinary, original, civil jurisdiction. Clear with this? Other than international commercial arbitration, it is the principal civil court. What court? Principal civil court. And high court having the original civil jurisdiction but does not include any court inferior to which court? Principal civil court or court of what causes? Small causes. What causes? Small causes. Clear with this? So these are the definitions are the basic provisions of the arbitration, conciliation and mediation. अब हम discuss करेंगे arbitral proceedings. What proceedings? How the arbitration works, number of arbitrator, appointment of arbitrator, jurisdiction, and how to challenge the appointment of arbitrators. So all those things we'll discuss one by one. Concentrate, guys. Concentrate, concentrate, concentrate. Tell me, if one of the party is a habitually resident in outside India, and if there is arbitration between the Indian person and that particular person, is it called as an international commercial arbitration? Yes, it is called as what arbitration? International commercial arbitration. समझ में आ गया? Next one. Let's start with the arbitral proceedings. बोलो. Make some noise, guys. Who is that? Who fellow? Who fellow? Who nahi hai? Yes or no? Let's start. Arbitral proceeding. What is the first one? Section number 7. Arbitration agreement. What agreement? See, arbitration agreement is the starting point of arbitration. Without arbitration agreement, can there be a question of arbitration? No. No agreement, no arbitration. So, what is the essential requirement of an arbitration? Arbitration agreement. First of all, tell me what is an arbitration agreement? It's an agreement between the parties to refer the dispute to the arbitration which have arisen or which may arise in future out of a defined contractual relationship. What relationship? Defined contractual relationship. Yes or no? It can be contractual or it may not be contractual. For example, even if it's a tort, a civil wrong, we can still refer to the what? Arbitration. But we cannot refer the family matters to where? Arbitration. So there must be an agreement. Right? There must be what? Agreement. Without agreement, can there be a question of arbitration? No. So what is the essential requirement of an arbitration? Agreement. What agreement? Arbitration agreement. Bolo bolo what agreement? Let's start, guys. Let's start. What agreement? Arbitration agreements. What is the first one? An agreement by the parties. Agreement by whom? Parties submit to what? Arbitration. All are certain disputes. Bolo? All are certain disputes which have arisen. Which have what? Or which may arise between them. Which have already arisen. Or which may arise in what? Between them. In respect of what relationship? Defined relationship. It may be contractual or no, contractual or what? That is called as what? Arbitration agreement. What agreement? Is it required to be in written form? Yes or no? Can be in the form of an arbitration clause. What clause? In the joint venture agreement, you can put a one clause which has an arbitration, which where parties agrees to refer the dispute to where arbitration. Correct, right? So it can be in the form of an arbitration clause, or it can be a separate agreement. What agreement? Arey bolo, what agreement? Separate agreement. It should be in what form? Written form. What form? What should be in written form? Arbitration agreement should be in what form? Written form. What form? Next one. Agreement deemed to be in writing in the following cases. What cases? Following cases. इसको हम लोग ज़्यादा case laws discuss किया था. I have discussed so many case laws for this concepts. Correct, right? First one, a document signed by whom? Deemed to be in what form? Written form. What form? Second one, exchange of letters. Exchange of what? Letter. Exchange of letters by the parties. Or telecommunication mode is also considered as what? Called as what? Arbitration. Arbitration agreement. What agreement? Arbitration agreement. मैंने बोला we shall refer our arbitration dispute to arbitration. I have sent a one letter. Other person has sent one more letter agreeing to refer the dispute to where? Arbitration. Is it called as an arbitration agreement? Yes. Next one, exchange of statement of claim and statement of defense. Correct, right? There will be two parties. One submits statement of claim, other person submits what? Statement of defense. The claimant and the respondent. Claimant and the what? Next one, reference to an external document containing what clause? If there is a clear intention to make the arbitration clause of the original document a part of the subcontract, then that reference to the original document is deemed to be what contract? Written contract or arbitration agreement. What agreement? Arbitration agreement. For example, there is an arbitration agreement between X and Y. Now, Y is entering into a contract with whom? Z, where it is clearly agreed that all the clauses of the original agreement are deemed to be part of which agreement? This second agreement or subcontract. Now, in this case, if there is an arbitration clause, what clause? In the original agreement, it is deemed to be a arbitration agreement. In which contract also? Subcontract also. Clear with this? Can you guys write about arbitration agreement in the examination if they ask any question? First, write what is arbitration agreement. What will you write? What is arbitration agreement? When essentials of arbitration agreement should be in what form? Written form. What form? And when it is deemed to be in written form? When it is deemed to be in written form, when it is signed by the parties, exchange of letter, telecommunications, or claim under statement of defense are reference to an arbitration agreement, an agreement having an arbitration clause. Next comes power of the court to refer the parties to where? Arbitration. Simple say simple. You guys tell me if there is an arbitration, but one of the party, sorry, if there is a valid arbitration agreement, but one of the party goes to the court seeking one of the party files a case in the court. In that situation, who can seek the court to refer the parties to arbitration? Other party. Before filing what statement? First statement. What statement? That is first response to the case filed by the party. He has to claim that there is an arbitration agreement. Please refers to the where? Arbitration. Tell me, is it mandatory for the court to refer the parties to an arbitration if there is a valid arbitration agreement? Yes, mandatory, irrespective of any existing decisions of the High Court or the Supreme Court. And to claim this, the one who wants the order of the court to refer the parties to the arbitration should submit a what? Arbitration agreement. What if it doesn't have an arbitration agreement? You can give a what? Copy of the agreement. The court will direct the other person to produce the which agreement? Original agreement. What agreement? These are the provision with respect to power of the court to refer the parties to where? Arbitration. To where? Arbitration. Let's read everybody. A party to an agreement. Below. What agreement? Arbitration agreement. Files a suit in the court and the matter is covered by what? Arbitration agreement. The other party can apply to the what? Court to refer the dispute to where? Arbitration. Dispute to where? Arbitration. The application must be made before submitting what statement? First statement. मैंने एक case law discuss किया था इसके बारे में. Yes or no? And the substance of the dispute. What of the dispute? Substance of the dispute. Elru ಹೇಳಿ. Substance of the what? Dispute. Next one. The court must refer the parties to where? Arbitration, except in a situation where the court finds that arbitration agreement is invalid. Correct, right? The court shall refer the parties to the arbitration irrespective of any judgment or decree. Bolo, bolo. Irrespective of any what? Judgment or what? decree of any court. The application by the party seeking the order of the court to refer the parties to the arbitration shall be accompanied by what document? Following document. What document? Other documents to be accompanied. What is the first one? Our arbitration agreement. Bolo bolo what agreement? Original arbitration agreement. What agreement? Original arbitration agreement. Second one, if the original is not available, what is not available? Submit a copy of the what? Agreement with a request seeking the other party to produce the original agreement. What agreement? Clear with this? Section number क्या है? 8. Section number 6 is what? Sorry, 7 is what? Arbitration agreement. 8 is what? Power of the court to refer the parties to where? Arbitration. 9 is important because 9 and 17 both are similar. 9 deals with the power of the court to refer the parties to, sorry, 9 deals with the interim measures which court can pass, and section number 17 deals with the interim measures given by the arbitral tribunal. What tribunal? Arbitral tribunal. Concentrate everybody. Who can apply to the court for appointment of a guardian? Any person. So these are the interim measures who can seek parties to the arbitration can seek. Correct, right? From whom? From the court. And we have discussed the definition of a court. In case of other than international commercial arbitration, what do you mean by court? Principal civil court having what jurisdiction? Original jurisdiction. That is nothing but district court. What court? Or high court. Exercising what jurisdiction? Ordinary original civil jurisdiction. Correct, right? So a person can obtain the interim order of the court for the appointment of a guardian. Appointment of what? Guardian for whom? Minor or unsound mind. Keep this in mind. Any orders passed by any of the forums without appointing a guardian to protect the interest of a minor or unsound mind, valid or not valid? Not valid. Correct, right? So one of the parties can seek the court to appoint whom? Guardian. Appoint whom? Guardian for whom? Minor or person of what mind? Unsound mind. This is called as what measure? Interim measures. Bolo na what measure? Second one, for an interim measures for protection in respect of any of the following matters, namely, what is the first one? Preservation, interim custody, sale of any goods. Sale of what goods? Which are subject matter of the arbitration agreement. You can seek the interim order of the court either for preservation or interim custody or sale of any goods or to secure the amount. Secure the what? Which is involved in the arbitration. Just to make sure that the amount will be available. What if a person sells everything and he become insolvent? There will not be any appropriate remedy, right? So to make sure that the funds will be available. For example, I am claiming money from Mr. X. So the court should secure the payment from whom? Mr. X, if I win the case. Correct, right. So for that purpose, there can be what orders? Interim orders. What order? Interim orders from whom? From the court. What is the first one? Appointment of guardian. Second one, order for the preservation, interim custody, sale of any goods, securing the amount. And DPA, you know what is DPA? Detention, preservation, and inspection of any property or a thing which is subject matter of what? Dispute of arbitration. And for the purpose of detention, preservation, and inspection, remember the same thing was there in CPC also. And for this purpose, what court can do? Authorize a person to enter into any building or a premises and to carry out the search and take the samples, carry out the experiments, and also make the observations. Also make a what? And there can also be what injunction? Interim injunction. What injunction? Or the appointment of who? Receiver. If he is an insolvent person, then such other interim measures for the protection as may appear to the court to be just and convenient. Just and what? Below just and what? Convenient. The arbitration proceedings shall start within how many days? 90 days. Important, 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 important. Whenever a interim order has been obtained, if a person has obtained an interim order, in that scenario, the arbitration shall start within how many days of interim order? 90 days. Below how many days? Arey bolo how many days? If the arbitration is not initiated within 90 days of the interim order will be what? Vacated. Will be what? Vacated. Or it becomes invalid unless the court provides otherwise. Are you guys clear with this? Can you write about interim orders can be passed by the court under section number 9 of the Arbitration and Conciliation Act? Yes or no? And next one, section number 10 and 11 deals with what? Appointment of arbitrators and number of arbitrators. Bolo, bolo, जोर से bolo. Appointment of arbitrators and number of arbitrators. Tell me who can decide the number of arbitrators? Party. But should be what number? Odd number. Should not be what number? Even number. जोर से बोलो what number? Should be what number? Odd number. Should not be what number? Even number. If not mentioned in the agreement, there should be how many arbitrator? Sole arbitrator. He can be of what nationality? Any nationality. Can be a Pakistani? Yes. He can be a Englishstani? Can he be a Hindustani? Yes, he can be from any country, any country. Citizen of what country? Any country. Next one, who are free to agree the procedure for appointment? Parties are free to agree the procedure for appointment. What if it is not agreed? Now the appointment is done in the following manner. What manner? Following manner. First one, if there are how many arbitrator? Below how many arbitrator? Parties are free to agree the procedure for appointment. What if it is not agreed? In that case, law provides that each party will appoint one arbitrator. Below, each party will appoint whom? One arbitrator, and the two appointed arbitrators select whom? Presiding arbitrator. What arbitrator? Presiding arbitrator. Next, we have sole arbitrator. What arbitrator? What do you mean by sole arbitrator? Only one arbitrator. If the party cannot agree within how many days? How many days? The Supreme Court, High Court, or designated institution will make the what? Appointment. See, wherever there is no agreement, you just write Supreme Court, High Court, or arbitral institution. Simple as that. Either parties will agree. If they don't agree, then go to whom? High Court or Supreme Court or arbitral institution. They will do the appointment. Clear with this? Next one. Party fails to appoint whom? Arbitrator. Or two appointed arbitrator fails to agree on the which arbitrator? Third arbitrator. Then who will appoint? I can't hear you guys. Arbitral institution. Next one. Before the appointment, before the what? Appointment, the Supreme Court, High Court, or designated institution must seek the what? Disclosure in writing. What in writing? Yes. From the arbitrator regarding their qualification and also what? Impartiality. Correct, right? There should not be any bias, right? The arbitrator must be impartial. So you should take a declaration from him saying that he is impartial as well as he is qualified to be appointed as an arbitrator. The court shall dispose the application for appointment of an arbitrator within how many days? 60 days. How many days? High Court can frame the rules for determining the fees of whom? Arbitral tribunal. What tribunal? Tell me which section number provides the provision with respect to interim orders by the court? Interim orders. Section number 9. Within how many days the arbitration should start if there is interim order? 90 days. 90 days. Clear with this? Next one. Ground for challenge of appointment of arbitrator. See, if an arbitrator is appointed, you can challenge his appointment in the following cases. What cases? Following cases. There may be a question based on this. On what grounds an appointment of an arbitrator can be challenged? I have appointed her as an arbitrator. You have appointed her as an arbitrator. Now, can we challenge the appointment of the arbitrators? Yes. By in what? Before whom? Arbitral tribunal itself. What itself? Arbitral tribunal itself. Let's start. The person intended to be appointed as a what? Must be what? Independent and impartial. Keep this in mind. Any arbitrator, all the arbitrator must be what? Independent and impartial. Below what? Independent and impartial. When a person is approached in connection with this possible appointment. What appointment? Possible appointment as a what? Arbitrator. As a what? As a what? Arbitrator. He shall disclose in what? Writing. Disclose in what? Existence of either direct or indirect of any past or present relationship with or interest of any of the parties in relation to the what? Subject matter in dispute. What in dispute? Subject matter in dispute. That gives a justifiable doubt as to independence or impartiality. Because he should be independent and impartial. If there is any justifiable doubts about his independence or impartiality, is he required to disclose the same to the parties? Yes. Are the factors which will affect his ability to devote sufficient time to dispose the suit or dispose the dispute within how many months of arbitration? 12 months of starting of the arbitration. दोनों disclose करना पड़ेगा. He has to disclose both. In which? At the time of appointment as an arbitrator. Further, an arbitrator from the time of his appointment or throughout the arbitral proceedings shall without delay disclose any of the events which will affect his independence and impartiality. Bolo? Independence and impartiality. For example, if I'm proposing to appoint you as an arbitrator, are you supposed to give me a declaration in writing about your independence and impartiality? Yes or no? And the factor which might affect your ability to dispose the arbitration or decide the dispute within how many months of arbitration? 12 months. Are how many months? 12 months. Correct, right? An appointment of arbitrator may be challenged on what grounds? Following grounds. Keep this in mind. Keep this in mind. An appointment of an arbitrator can be challenged by both the parties on the following grounds. What is the first one? What is the first one? Circumstances given exist that gives a justifiable doubt as to his what? Independence or impartiality. The second one, it does not possess the qualification agreed by the parties. We have agreed that he should be a CS to be an arbitrator, but he's not a CA. Sorry, CS. Can we appoint him as an arbitrator? No. If we appoint him as an arbitrator, is that appointment valid or not valid? Not valid. Clear with this? Next one. Next one. What is the next one? What is the next one? Challenge of what? Arbitrator. Challenge of what? Arbitrator. Challenge procedure. What procedure? Below what procedure? Challenge procedure. What is challenge procedure? How to challenge the appointed arbitrator? What arbitrator? Appointed arbitrator. See, we appointed these two as an arbitrator. We don't. Now there is a justifiable doubt as to their independence and impartiality. I don't want them to continue as an arbitrator. Where can I challenge this? Before the arbitral tribunal. Bolo. What tribunal? Arbitral tribunal. Let's start. Challenge procedure. What procedure? What procedure? Challenge procedure. What procedure? Challenge procedure. The parties are free to agree. Who are free to agree? Parties are free to agree on the procedure for challenging the what? Arbitrator. Challenging of an arbitrator must be done within how many days? From the date of what? Occurrence of any of the following events. Within how many days? 15 days. Of what? Aware of the constitution of the arbitral tribunal or becoming aware of any circumstances that provides grounds for what? Challenge. Tell me, what are the grounds on which we can challenge? Justifiable doubt has to impartiality and independence are not possess the required qualification. Can we challenge the appointment of arbitrator within how many days? 15 days. Very good, very good. Awesome, guys. Awesome. Next one. Decision of the arbitral tribunal is not required. Is not required if the arbitrator what? Agrees to withdraw from the position. Means he himself withdraw from the position. We challenge the appointment of an arbitrator and he vacates his office. Isn't the requirement of decision here? No. When arbitrator whom we have challenged voluntarily vacates the office, there is a requirement of decision. Right, right. But what if he is contesting it? Then who will decide it? Arbitral tribunal. What tribunal? He is also part of what tribunal? Arbitral tribunal. Next one. If challenge is not successful, what is not successful? Challenge is not successful. The tribunal, what tribunal? Arbitral tribunal proceeding the what? Continues the proceedings. Continues the what? Proceedings. Yes or no? Next one. Where an arbitral award is made. What is made? Arbitral award is made. One more time. What is made? The party challenging the arbitrator make an application for setting aside such an arbitral award according to section number what? 34. See, after award is made, I challenge it before the arbitral tribunal, but you continue to decide that it is not correct and pass an award. I can challenge that award. Where? In the court. The section number what? 34. Clear with this? So these are the provision with respect to what? Challenge of arbitrator. Challenge of what? Challenge of what? Arbitrator. Are you guys clear with this? Then comes section number 14 and 15. Section number what? 14 and 15. What is 14 and 15? failure or impossibility to act as an arbitrator, and termination of mandate and substitution of what? Arbitrator. See, if a person fails to act as an arbitrator or it becomes impossible for him to act as an arbitrator, then the mandate of an arbitrator will terminate. What is mandate? The appointment will get terminated, and parties or the arbitral tribunal will substitute his position with which arbitrator? New arbitrator. What arbitrator? New arbitrator. Yes or no? They may ask this question in the examination. When the mandate of an arbitrator gets terminated. When it gets terminated, when he either by de facto or de jure becomes impossible to act as an arbitrator. For example, an arbitrator becomes, or he met with an accident and he goes to coma, or is in coma. Now he becomes what? De facto incapable of performing or acting as an arbitrator, then his mandate will comes to an end. And his position should be filled with what arbitrator? New arbitrator. What arbitrator? New arbitrator. What arbitrator? That's right. Let's read. The arbitrator's mandate. Bolo? Arbitrator's mandate will terminate if the arbitrator becomes either de jure or de facto unable to perform their what functions. Unable to perform their what functions. If the arbitrator fails to act without undue delay in carrying out their duties for any reason. What reason? If the arbitrator withdraw from the office voluntarily, obviously what happens? Mandate comes to an end. Appoint a what arbitrator? New arbitrator. If the parties agree to terminate the arbitrator's mandate, both of them agrees to remove him. Next one. If an arbitrator is replaced, any hearing previously held, valid or not valid? Valid, unless party decides to rehear it. Correct, right? Next one. Prior orders or rulings made by the arbitral tribunal before the arbitrator's replacement will not be invalid. Are you guys clear with this de jure and de facto? What is de jure by law? Arbitration Act says if you have any impartiality or if you don't have independence, you shall vacate your office. That is de jure by law. What is de facto? Because of physical incapabilities. For example, you have become unsound mind. Can you continue as an arbitrator? No, you cannot continue as what? Arbitrator. That is called as what? De facto. What factor? De facto disqualification. Yes or no? Next one, section number 16. Section number what? 16. What is section number 16? Competence of the arbitral tribunal. Now tell me, which document gives a jurisdiction to the arbitral tribunal? Arbitration agreement. What agreement? If agreement is invalid, do arbitration tribunal have a jurisdiction? No. Who will decide? Who will decide whether the agreement is valid or invalid? Arbitral tribunal itself will decide whether the agreement is valid or not valid. See, I get jurisdiction or a power out of what? Arbitration agreement. And I only will decide whether the agreement is valid or not. इसको बोलते हैं competence. क्या बोलते हैं इसको? Competence. Where I only decide whether I am competent or not. That is called as what? Competence. Generally, who will do? One will decide whether other person is competent or not. But in this case, arbitral tribunal itself will decide whether it has jurisdiction or not. And arbitral tribunal derives the power out of which agreement? Arbitral agreement. What agreement? Arbitral agreement. Clear with this? So arbitral tribunal has the authority to rule on its what jurisdiction? Own jurisdiction, including the objection regarding the existence or validity. Now what agreement? Arbitration agreement. What agreement? Arbitration agreement. A party must raise any objection. Raise any what? Objection. The tribunal does not have jurisdiction. Who does not have jurisdiction? Who does not have jurisdiction? Arbitral tribunal does not have jurisdiction before submitting its statement of what? Defense. Statement of what? Defense. That the tribunal is exceeding the authority as soon as the matter is raised during the what? Proceedings. Means the party should claim that tribunal does not have a jurisdiction within this particular time. So if a other party says this tribunal does not have a right to hear this dispute, he has to raise this in the where? In the statement of defense. Statement of what? I am going for arbitration. You come up and say, no, no, this matter cannot be referred to arbitration. Claim it where? Statement of defense. Statement of what? Defense. Then who will decide this? Arbitral tribunal will decide this. Is it within the scope of arbitration agreement or not? Clear? Next one. If the tribunal rejects the plea, it will continue with the proceedings and make a what? Award. Makes a what? Who can make an award? Arbitral tribunal. If the party agreed by the tribunal's order or arbitral award, they may seek to set aside under section number what? 34. Section number what? What is competence? Competence principle allows the arbitral tribunal to first decide on its jurisdiction, even if the party challenges the arbitration's agreement's validity. Who will decide this? Arbitral tribunal. Next one, section number 17. Have I discussed section number 17? Similar to section number 9. Interim measures by the arbitral tribunal. 17 is arbitral tribunal. Section number 9 is court. Clear with this? Next one. Next one. Arbitration proceedings. What proceedings? Simple say simple. Like how the arbitration happens. What happens? Arbitration happens. First one. Rules are procedure. Rules are what? How the arbitration should happen. Who will decide that? Parties are free to agree the procedure of arbitration. What of arbitration? Procedure of arbitration. Are they bound by CPC and law of evidence? No. Please, parties don't agree on the word, does not agree on the procedure. The tribunal shall have authority to determine the word procedure. Who will decide the procedure? Arbitral tribunal. What tribunal? Parties have the power to decide the arbitral procedure to be followed. If the parties fails to agree, who fails to agree? Then who will decide it? Arbitral tribunal. What tribunal? Next one, place of arbitration. Bolo bolo, what of arbitration? Place of arbitration. What is the place of arbitration? Who will agree place of arbitration? Party. Is it important?
Yes, sir.
Why it is so important?
Fine.
Jurisdiction of the court. Correct, right? Now, how to reach? If the party fails to reach an agreement, AT shall decide the place of what? Arbitration. My question is, can parties decide some place other than the place where the cause of action arises as the place of arbitration? Yes. Defendant is in Chennai. Cause of action is in Bengaluru. Party may agree the place of arbitration as Goa. Allowed or not allowed? Allowed. Only in case of arbitration. So if the parties have agreed that Goa is the place of arbitration, not Goa. Goa is the place of arbitration. Then what is the place of which court has jurisdiction? Goa has the jurisdiction. Which state court has jurisdiction? Goa state has the jurisdiction. Okay. Case laws are there. I have given the gist of case law. No need to read the entire case laws. Let's start. If the parties, bolo,
The past.
bolo na. If the parties have agreed the venue of arbitration, what of arbitration? Only the court of that venue will have what? Jurisdiction. Will have what? Next one. Parties can even choose a neutral seat. What seat? Which has no connection with the cause of action. Next one, if the parties have not agreed the place of arbitration, in that situation, arbitration tribunal cannot confer jurisdiction to a place where no part of cause of action arises or has no nexus to the what? Parties. It has to decide either the place of defendant or the place where the cause of action arises. Who can decide? Only this arbitral tribunal. But parties can confer the jurisdiction even to a place where there is no cause of action or where there is no connection. But if the party fails to agree, then who can fix? Arbitral tribunal. What tribunal? Which place? Cause of action or where defendant? Any connection with the parties to the dispute. Okay. Next, what will start? Commencement of what? Arbitral proceedings. What proceedings? Commence on the date on which request for the dispute to be referred to arbitration is received by whom? Respondent. Language, who are free to decide the language? Parties. If they don't decide, then who will decide? Arbitral tribunal. Awesome. Next one, statement of claim and defense. Bolo statement of claim and what? Defense. Who will submit the statement of claim? Claimant. Who submit the statement of defense? Respondent. Respondent must state the defense against what? These particulars. Correct, right? Both the parties can submit the what? Documents they consider relevant. Can the respondent claim set off? What is set off? Reciprocal acquittal of debt. What is the effect of set off? It extinguishes the claim of who? Plaintiff to the extent of claim made by whom? Defendant. So tell me, in case of set off, is it required to be legally recoverable? Should be what suit? Money recovery suit? What suit? Money recovery suit, legally recoverable, then ascertain sum of money. What sum of money? It should be within the what jurisdiction of the court? Pecuniary jurisdiction. What jurisdiction? Remember, set off, equitable set off, counterclaim. Yes or no? Next one. Either party can amend or supplement their claim or defense during the course of proceedings. Statement of claim and defense must be completed within how many months? 6 months. How many months? Next one. Hearings and written proceedings. Arbitral tribunal hear both the parties either by way of document or there can be oral hearing. What hearing? If there is a oral hearing, should be done day-to-day basis. What basis? Day-to-day basis. If anybody seeks adjournment, it can impose a cost upon the person who seeks adjournment. Correct, right? Just to avoid the delay. Just to avoid the delay. Who shall decide whether to hold the hearing or conduct the proceedings based on document and material? Arbitral tribunal. Oral hearing may be held at what stage? Appropriate stage. Are below what stage? Oral hearing to be held on what basis? Day to day basis. What basis? Day to day basis. If a party seeks adjournment, who seeks adjournment? Who may impose exemplary cost? Parties arbitral tribunal may impose what cost? Exemplary cost. What cost? Parties must given a sufficient advance notice of any hearing or meeting. Next one, default of party important. We have discussed this even in the CPC also. If a claimant fails to supply that statement of claim, what happens? Dismissed. Respondent fails to submit the statement of defense. Who can continue? Tribunal will continue. Who will continue? Tribunal has the discretion to forfeit the respondent right to what? File the defense. It can cancel the rights of the respondent to file the statement of defense. If the party fails to attend the oral hearing or submit a documentary evidence, the tribunal will decide based on the evidences available. What available? Evidence available. Can arbitral tribunal appoint an expert? Yes or no? Can under the specific relief act, can there be appointment of an expert? Expert for the purpose of seeking help or opinion with respect to various matters. Is the expert entitled for a fees? Obviously, otherwise, why will you work at free of cost? An arbitrator can appoint an expert to report on a specific issues or analyze the what? Document or evidence. Document or what? Expert must provide all documents, goods, or a property they use to prepare their report for examination by requesting party. What party? Expert must attend an oral hearing if requested by party or deemed necessary by whom? Tribunal. Expert must answer the question from the parties and may face what examination? Cross-exam. Obviously, supposed to appear before the tribunal for examination as well as what examination? Cross-examination. What examination? Now, let's say tribunal wants evidence or a witness to appear. Even after serving the summons, the person is not appearing. He is avoiding the appear and give evidences. In that situation, can tribunal take the assistance of a court to obtain the evidences? Either the tribunal or one of the party can apply to whom? Court, seeking the assistance of what? Court. To obtain the evidence. Obtain the what? Let's start. Arbitral tribunal or a party can apply to the court for the help in obtaining the what? Evidence. When you apply for an assistance of the court to obtain the evidence, you must provide following information. What is the first one? Names and address of what? Parties and arbitrators. A brief description of claim and relief sought. Specific details of the evidence to be obtained, like name, address of the witness, along with the subject matter. Description of the document to be produced or property to be inspected. Property to be what? Inspected. Court may execute the request by ordering that evidence be provided directly to whom? Arbitral tribunal. If anybody, even after the summons is served by the court, if he fails to comply with this, will he be punishable or not punishable? Punishable. Same like how it happens in case of CPC. Clear? Next one. Rules applicable to substance of the dispute means under what law it has to be decided. You have to apply which law? Substantive law. What law? Domestic arbitration. Bolo what arbitration? Everybody what arbitration? Domestic arbitration. What arbitration? Domestic arbitration. The arbitral tribunal must decide the dispute based on the what law? Indian substantive law. In case of international commercial arbitration, if the party designate as per that law, if the party does not designate, arbitral tribunal will decide. Who will decide? Arbitral tribunal will decide. Can a case be decided ex equo et bono based on the good faith? Only if parties have agreed. Only if the what? Parties have agreed. What is amiable compositor? As a friend. As a what friend? Good friend. What friend? Arey bolo what friend? Good friend. Can the case be decided as a good friend only if the parties agree? Otherwise, the tribunal shall decide it as per the what? Substantive law. What law? Decision making by whom? Panel of arbitrators. Panel of what? If there are five arbitrators, how many should agree? All should agree or majority should agree. Correct, right? Yes or no? In case of panel of arbitrator, decision must be made by whom? Majority of arbitrator unless the party agrees otherwise. The procedural issues can be decided by whom? Presiding arbitrator alone if the parties authorize it or all the arbitrators can on the tribunal agrees to it. Who agrees to it? Tribunal agrees to it. Who agrees to it? Tribunal agrees to it. Are you guys clear with this? Next we have arbitral award. What award? What award? Challenge procedure, interim orders of the court, interim orders of the tribunal, power to refer the parties to the tribunal, statement of claim and defense, substance applicable, law applicable to substance of a dispute. All these things we have discussed in detail. Right? Discuss what? In detail. Let's start with what? Arbitral award. What award? Arbitral award. What is arbitral award? The award passed by the arbitral tribunal. It also includes which award? Interim award. What award? Same like decree. Decree includes what? Preliminary decree as well as the final decree. So arbitral award means and includes which award? Interim award. What award? They may ask, what are the essentials of arbitral award? What award? Arbitral award. What are the essentials of arbitral award? What is the first one? Should be written and stamped. Award should be in what form? Written form and should be stamped. Should be what? Should be what? Stamped. Open your mouth and answer. Written and what? Stamped. Second one, the award is to be signed by whom? Members. Members of what? What tribunal? Arbitral tribunal. What tribunal? If there are panel of arbitrators, how many should sign? Majority. Next one. The award should contain reasons for arriving at the what? Decision. Arriving at the what? Decision. Exception, arbitration agreement provides that no reasons to be given. What to be given? No reasons to be given. What to be given? Where the award has been made based on the what? Settlement between the parties. Between the what? See, generally the arbitration award should provide the reason. Should provide the what? Vetal should provide the what? Reasons. But are there any exception? How many exceptions? Two exceptions where parties have agreed that there are no reasons to be given. There are no what? Reasons to be given. Or the second one where the award has been based on what? Compromise. Based on what? When you both compromise, I'm saying that okay, whatever you compromise is correct. Why will I give a reasons? Correct, right? Next one. Award should be bolo award should be dated. Place of arbitration has to be what? Specified. Clarity of value and what? Interest. Clarity of value and what? Tribunal may include interest in the award for the payment of what? Money. Payment of what? Bolo payment of money. Yes or no? There should be a clarity of value, and interest. What is the amount payable? Is the interest payable or not payable? With interest or without interest? You are claiming the interest of 10% on the date of default. Now the question is, is the tribunal is giving money as well as interest or not? It has to be clearly mentioned. In which award? Arbitral award. The rate of interest determined by the tribunal may apply to the whole or part of the award. Sum awarded. That who will decide? Tribunal will decide. You have claimed 1 lakh rupees from other party. Case goes on for 1 year. Now I may order the parties to pay the money with interest or without interest. With interest or what? That is whose discretion? Tribunal discretion. Yes or no? Clear? So once interest is awarded, is the interest payable? Yes, payable. Interest period can cover the time period between the what? Cause of action, date of award. What is cause of action? When the default happened, till the date of award. Till the date of what? Award. Then there is something called as interest after award. She was supposed to pay 1 lakh. Defaulted. You initiated arbitration. Arbitration goes on for 1 year. So I can say, oh, pay 1 lakh rupees along with the pay interest for how many year? 1 year. Award date is today. Today is the date on which award is made. Now, she took 1 year time to pay the money. Is she liable to pay interest for this period? Yes. By default, an award carries what? Interest. For delay in payment or obeying the award, you're supposed to pay what? Interest. Supposed to pay what? Sum awarded in the tribunal automatically carries the interest. Automatically carries the what? Interest. There can be practical question based on this. The interest rate will be 2% higher. How much? Then the current market interest rate at any time of the award, and it will apply from the date of award until the what is paid? Sum is paid. What is paid? How much higher than the current market rate of interest? Cost of arbitration, it includes decisions and directions of the arbitrator regarding the cost of arbitration. Deliver the copies to whom? Both the party for appropriate actions. These are the what? Essentials of arbitral award. They may ask in the examination. What is arbitral award? It includes interim award, or we can say decision given by the arbitral tribunal. What tribunal? Arbitral tribunal. It is called as what? Arbitral award. It should be what? Written and stamped. Below. Second one, signed by the members of arbitral tribunal. Third one, contain the reasons for arriving at what? Decision. Are there any exception? Yes, two exception should be dated, should be specify the place of arbitration, value and interest, interest after award, cost of arbitration, delivery of cause. Copy should be delivered to whom? Both the parties. Correct, right? Tell me, once the award is given, till the payment is made, does it carries any interest? Automatically it carries the interest. How much extra? 2% higher than the current market rate. Correct, right? Next one. Types of arbitral award. What about? What is the first one? What is interim award? During the pendency of the what? Suit. Any not suit, the dispute. If any award is made, it is called as what award? Interim award. What award? Next one is important. Additional award. Based on this, they may ask question in the examination. Now, for example, you sought something in the dispute. You have claimed something in your statement of claim, but the arbitral tribunal omitted to address it or provide a relief on that. It already passed an award. So after you have received the award, within 30 days of award, 30 days of what? Award, you may apply to the tribunal to consider the matter which has been omitted and give a one more award. It is called as what? Additional award. What award? Claim presented during the arbitration but omitted from the final award. Request shall be made within how many days for the receipt of arbitral award? 30 days. The requesting party must give notice to which party? Other party. If the request is justified, it must make the additional award within how many days from the date of receives the award? 60 days. Settlement award. Award made based on the terms agreed between whom? parties. It is called as what award? Settlement award. What award? Settlement award. Last one is what? Final award. What is final award? Determines all the issues in dispute. What in dispute? That is called as what award? Final award. Are you guys clear with types of award? Everybody. What is the first one? Second one, additional award. Third one, fourth one, final award. What award? अब हम शुरू करेंगे टाइम लिमिट फॉर आर्बिट्रल अवार्ड. व्हाट लिमिट फॉर आर्बिट्रल अवार्ड? टाइम लिमिट. विद इन व्हाट टाइम द आर्बिट्रल ट्रिब्यूनल शैल प्रोवाइड द आर्बिट्रल अवार्ड? विद इन हाउ मेनी मंथ्स? 12 months. Domestic arbitration, बोलो. Within how many months? From the date of completion of what? Pleadings. Pleadings means statement of claim, statement of defense. Once it is done, from that date, within how many months decision देना पड़ेगा? 12 months. How many months? Unnailed, single. 12 months. What did I say? Did I say anything wrong? We both are laughing. Oh, yesterday's effect. Next one. Parties by an agreement. Parties by what? Agreement can extend the what? Time period. What period? By how many months? 6 months. How many months? 6 months. Correct, right? Extra how many months? 6 months. How many months? 6 months. But within how many months the award should be made, Sinchana? Within 12 months. How many months? 12 months. Parties by an agreement can extend the time period for how many months? 6 months. Fast track arbitration with how many months? 6 months. International commercial arbitration, 12 months, but it is not mandatory. Parties by mutual agreement can extend. If the award is made within how many months? 6 months from the date of tribunal enters upon the reference, tribunal may receive what fees? Additional fees. What fees? If the award is not made within the specified time, the mandate of the arbitration shall terminate unless the court extends the what period. Extends the what period. If the delay is due to arbitrator's fault, the court may reduce their fees by how much? 5% per month of delay. While granting the extension, court may substitute what? One or more arbitrators. How much fees can be charged? Reduced? 5% per month of delay. Per month of what? Delay. Court shall dispose the application for execution extension of time as expeditiously as possible. As expeditiously as what? Possible. But within how many days? 60 days. How many days? Time limit. What is the time limit, Darshan? 12 months. Extension 6 months. Fast track 6 months. Foreign international commercial arbitration 12 months. Fast track procedure. It is an opt-in approach. Means only parties decide they can go for what arbitration? Fast track arbitration. Parties are free to agree for what? Sole arbitrator. AT shall decide the dispute on the basis of what pleadings? Written pleadings, documents, and submissions filed by the parties without any oral hearing. So, in case of fast track arbitration, there may not be any what hearing? Oral hearing. Tribunal will decide based on the submissions made. Okay? Award shall be made within how many months? 6 months. How many months? Parties by an agreement can extend extra how many months? 6 more months of time. Okay? Next, regime for the cost. Regime for the what? Nothing but cost of arbitration. Who should pay? What does it includes? All those things are called as regime for the cost. Cost of arbitration includes the following things. If they ask any question about regime for the cost, first write what is the cost of arbitration? What does it includes? Below what it includes. Cost includes fees and expenses of arbitrators, courts, and witnesses. Legal fees and expenses. What fees and expenses? Legal fees and expenses. Any administration fees of institution supervising the arbitration. Supervising the what? Arbitration. Any other expenses related to the arbitration or the court proceeding and the arbitral award. What award? Arbitral award. It includes all these things. What is the first one? Fees and expenses of the arbitrators like snacks, tea, coffee to the arbitrators. ಎಲ್ಲ ಕೊಡ್ಬೇಕಲ್ಲ देना पड़ेगा नहीं देना पड़ेगा ಕೊಡ್ಕಲ್ಲಾಮ కరెక్ట్ దా. ఎందుకంటే రిఫ్రెష్ అవ్వాలి కదా. అవును. సో స్నాక్స్ ఇవ్వాలి, ఇవ్వాలి, స్నాక్స్ ఇవ్వాలి, టీ ఇవ్వాలి, కాఫీ ఇవ్వాలి, బ్రేక్‌ఫాస్ట్ ఇవ్వాలి, డాక్యుమెంట్ సబ్మిట్ చేయాలి. ఎందుకంటే, ఎందుకంటే ఫాస్ట్‌గా వర్క్ చేయాలి కదా! అందుకే. రిఫ్రెష్ చేసుకోవాలి. అందుకే. ఫీజ్ కాదు బేటా. కాఫీ ఇవ్వాలి, స్నాక్స్ ఇవ్వాలి, రిఫ్రెష్‌మెంట్స్ ఇవ్వాలి. రిఫ్రెష్‌మెంట్ to give refresh. Cost incurred is called as what? Cost of arbitration. Cost of what? Arbitration. Understood? ಅರ್ಥ ಆಯ್ತಾ? Yes or no? Why is over there? Why is gone? Let's start. Surya, cost includes fees and expenses. Fees and what? Expenses. So the cost of arbitration includes fees and expenses of arbitrators, courts, and witnesses. Next one, it also includes what? Legal fees and expenses, any administration fees of the institution, if it is arbitral institution, or any other expenses. Who will decide who has to pay the cost of arbitration? Arbitral tribunal will decide whether the costs are payable by one party to the other party, amount of such cost, amount of what? Such cost, and also such cost are to be paid, when it has to be paid. And all these things who will decide? Tribunal will decide. As a general rule, the successful party will get the cost from which party? Unsuccessful party. Means unsuccessful party should incur the cost of arbitration. Cost of what? Is the general rule, but it is subject to modification by who? Arbitral tribunal. What tribunal? Arbitral tribunal. Unsuccessful party will be ordered to pay the cost of the successful party. The arbitral tribunal or the court can order a different arrangement with the reason recorded in writing. Factors for determining the cost. The conduct of all the parties, whether a party has succeeded partially in the case or whether the party made a frivolous counterclaim that caused a delay in the proceedings, whether any party made a reasonable settlement offer and that was refused by the other party. Means we will take, while ordering the cost of arbitration, that who should pay, tribunal will take into consideration all these facts. Who has made frivolous claims, means useless, baseless claims to delay the proceedings. Whether the one when one person offered a compromise, who rejected it, who was willing to go for litigations, all those factors will be taken into consideration while ordering who shall incur the cost of arbitration. Any agreement that requires a party to pay all or part of the arbitration cost, regardless of outcome, will be valid only if it is made what? After dispute has arisen. See, we have agreed that you should pay cost of arbitration irrespective of outcome. This condition is not valid if it was made before dispute has arisen. But after the dispute has arisen, if you make this agreement, is it valid or not valid? Valid. If it is agreed, then you only will pay all the amount of cost, the entire amount of the cost. Clear with this? If the parties have agreed that one of the parties should pay the cost of arbitration irrespective of the outcome. If it was made before dispute, not valid. After dispute, valid. Clear with this? Next one, termination of proceedings. Termination of what? Bolo, termination of what? Proceedings. Arbitration proceedings are terminated in the following scenario. What is the first one? By what award? Final award. Final arbitral award. An order of the arbitral tribunal. What tribunal? Arbitral tribunal. If the claimant withdraws the claim. Who withdraws the claim? Withdraws it means tribunal proceedings comes to an end. Second one, parties agrees to terminate the proceeding. Both the parties by mutual agreement terminates the proceeding. Last one, the tribunal finds that continuing the proceedings has become what? Unnecessary or impossible. For example, parties are claiming for a dog and dog is dead. What is the requirement of going for an arbitration? The tribunal may terminate the what? Arbitration. Terminate the what? Next one, important. Everybody concentrate. Darshan, concentrate. Chiran, concentrate, Chiran. Next one. Why I am repeating all your work? Next, correction and interpretation. Correction what? Interpretation. What is correction? In the award, if there are any mistakes on the face of the award, you can apply for the correction of those mistakes. What is interpretation? Understanding. Now, interpretation, remember, interpretation of statutes, casus omissus rule, primary rules of interpretation, no sister associates, no sister associates, and have it associated known by its associate. Then explicit express mentioning of one thing excludes the other things. Then we have discussed this uh, general word, this one specific word. There is enumeration of specific words followed by which word? General word, and you derive the meaning of the general word based on which word? Specific word. What is that rule called as? Adjective generis. What generis? Adjective generis. Yes or no? Yes. Next one, correction and interpretation. Correction and what? Interpretation. Let's start. What is correction? After issuing the arbitral award, if any party feels that there is a mistake, there is a what? Mistake in the award, or they require the interpretation on any matter, they may within how many days? 30 days. Same like additional award. Even for additional award, you apply within how many days? 30 days. How many days? From the receipt of the arbitral award, apply to the arbitral tribunal, correct any computation errors, clerical errors, or typographical errors, or any other errors of similar nature by giving notice to which party? Other party. Apply to the arbitral tribunal to give an interpretation of specific point or a part of the what? Award. What of the award? Part of the award. Correct, right? Next one. If the arbitral tribunal thinks to fit, it shall correct the award or give an interpretation within how many days? 30 days from the date of receipt of the request. Receipt of what? Request. Even same provisions we have discussed it for what? For the additional award. What award? Additional award. Section number 34, remember? Uh, Application for setting aside the arbitral award. You can go to the court, right? If you find that arbitral award is not correct. If you want to challenge the arbitral award, you can apply to the court to set aside the arbitral award. When the party making the application furnishes the proof to the court regarding the following circumstances, court may set aside the award. What are the following things? What is the first one? Party was under the award, some incapacity, and there was no appointment of whom? Guardian. Correct, right? If one of the party was incompetent, but still arbitration happened without appointment of guardian, can we challenge the arbitral award? Yes. Second one, an arbitration agreement is not valid under the law to which the parties have what? Subjected to. Agreement is invalid. Next one, the party making the application was not given what notice? Proper notice. What notice? Award is not in accordance with our terms of submission. Next one, arbitral tribunal was not properly constituted as per the agreement. Next one, what is the next ground? The arbitral procedure was not in accordance with what? Agreement of the parties. This is the one more ground on which what can be challenged? Arbitral award can be challenged. Next one, subject matter of the dispute is not capable of being settlement by what? Arbitration. हम लोग discuss किया था what subject matters are outside the family matters. Why only family matters? Even the criminal matters. What matters? First criminal matters, then family matters. What matters? Family matters. Next one, arbitral award is in conflict with what policy? Public policy. What policy? Time limit for making the arbitral award, time limit for making the application to set aside what award? Arbitral award. What award? What is the time limit? Within how many months? From receipt of what? Arbitral award. Could may further period extend it for how many days? For what cause? Sufficient cause. What cause? These appealable orders, generally orders are not appealable, but even in case of arbitration, there are few orders of tribunal and few orders of court which are appealable. Based on this, they may ask question in the examination. अभी तक question नहीं पूछा है. They have not asked the question based on this till now. They may ask questions in the upcoming examination. Let's start. Let's start. Let's start. Appeal against the order of the court. What of the court? Order of the court. Refusal to refer the parties to where? Arbitration. Refer the parties to where? Arbitration. If the court under section number 8 refuses to refer the parties to the arbitration, what court parties can do? Go for an appeal. Go for a what? Appeal. Second one, granting or refusing to grant any interim measure. What measure? Against that, you can go for an appeal. Setting aside or refusing to set aside what award? Arbitral award. Under section number 34. You can go for a what? Appeal. Next one, appeal against the order of whom? Arbitral tribunal. Accepting the plea of challenging the what? Jurisdiction of arbitral tribunal. If tribunal say we don't have jurisdiction, against that you can go to where? Court. Correct, right? Next one, granting or refusing to grant what measures? Interim measures. Under section number 17 of the Arbitration Act. Against that you can go to where? Court. Appeal to the court. No second appeal lies. Underline the word no second appeal lies. Because we already know this, right? Against the order, there is no what appeal? Second appeal. There is no what appeal? Second appeal. Aggrieved can appeal to which court? Supreme Court. Are bolo what court? One more time. What court? Supreme Court. What court? Supreme Court. Deposits. What do you mean by deposits? See, arbitral tribunal, to make sure that the cost of arbitration is paid, it may ask the parties to deposit the some amount of money towards the cost of arbitration. Cost of what? Correct. That is called as what? Deposits. Correct, right? What if I decide the case, at the end you come up and say I will not pay the fees. So to make sure that the cost of arbitration is paid by the parties, the tribunal may require the parties to deposit some amount of money as a cost of arbitration. Correct, right? Let's read who has the power to fix the amount of deposit. Tribunal. The deposit covers the cost, which includes the fees and expenses. Tribunal may fix separate cost for what claims? Counter claims. The deposit is to be paid in the equal share by which parties? Both the parties. If one party fails to pay the cost deposit share, can pay it, other party can pay it. If the parties fails to make the required deposit, who is not supposed to, who has the right to terminate the proceedings? Tribunal has a right to terminate the proceedings. Why will they continue? When you are not paid your deposit money, why will I continue? You can terminate it. Arbitral tribunal may not continue with the arbitration proceedings. What proceedings? Arbitration proceeding. Are you guys clear with this? Next one is important. Lien on arbitral award. What award? Lien. What is lien? Right to withhold. Tribunal may refuse us to deliver the copy of the award unless until the parties pay what? Cost of arbitration. Cost of what? Correct, right? Yes or no? Yes or no? Let's start. The arbitral tribunal. Bolo bolo what tribunal? Arbitral tribunal has a lien on the arbitral award to secure any unpaid cost of the arbitration. Bolo what cost of arbitration? Unpaid cost of the arbitration. The lien ensures that costs incurred during the arbitration process are paid before the award is handed over to the parties. Handed over to whom? Handed over to the whom? Parties, correct, right? That is the reason for which there is a concept of lien. You can exercise the lien, tribunals, when to secure the unpaid cost. What cost? Now, if the arbitral tribunal has exercised the lien and refuses to deliver the award unless the cost is paid, that situation the parties can approach who? Court. Approach who? Court. If the tribunal refuses to deliver the award, unless the cost it has demanded are paid, court has the authority to interfere. Who has the authority to interfere? Court has the authority to interfere. Anyone, any of the party can apply to the court. It feels demanded by the tribunal was agreed by the parties. The parties cannot apply to the what? Court. For what? Intervention. Court may order that award be delivered to the applicant if the applicant deposits the what? Demanded cost to the court. Court says you deposit the cost to me. I will do proper inquiry. I'll pay reasonable amount of cost to the arbitral tribunal. So if the parties deposit the amount required by the court, Then court will order whom? Tribunal to deliver the what? Award. After reasonable investigation or inquiry, what tribunal court will do? Make the payment of money to the arbitral tribunal. What tribunal? Arbitral tribunal. After deposit of the cost, the court may by inquiry decide the reasonable amount. What amount? Reasonable amount to be paid and refund the what? Balance to the applicant. What is the applicant? Balance to the applicant. Are you guys clear with this? Yes or no? Are you guys clear with this? Lean on the arbitral award. Death does not discharge the what? Arbitration. One of the party dies. Arbitration continues. Arbitral award binding upon whom? Legal heads. One of the arbitrator dies. It will continues. Correct, right? So arbitration agreement does not get discharged by death. By what? Death. Arbitration agreement continues to be enforceable against the legal representative. The mandate of arbitrator is not terminated by death of whom? Any party who had appointed the arbitrator. Enforceable insolvency. Enforceable if the receiver of the insolvent adopts the what agreement? Arbitration agreement. Limitation applicable to what proceedings? Arbitration proceedings. What proceedings? Arbitration. What is applicable? Limitation Act. So if there is a dispute, you have to go to the tribunal within how many years? 3 years. Cause of action, 3 years. Same thing is applicable. Okay. Next one, duties and functions of what Council of India? Arbitration Council of India. We have an Arbitration Council of India to oversee the proper mechanism of the arbitrations in India. Like how we have ICS, we have what? Arbitration Council of India. Everybody, what of India? What is the work of Arbitration Council of India? Identify and endorse the professional institute. Second one, periodically assess and grade the what? Arbitral institutions. Organize training session, workshops and course on what? Arbitration. Develop, revise and update the standards to ensure the satisfactory level of arbitration and conciliation. Provide a platform for discussions and sharing of techniques to strengthen the India as a hub for domestic and international arbitration and conciliation. Offer suggestion to the world government for measures that facilitate the resolution of the commercial disputes. Support the growth of the institutional arbitration by bolstering arbitral institution or establishing the arbitral institution. Administer the exams and training programs. Just keep ICSI in mind, how it regulates the CS profession when write the same thing with respect to Arbitration Council of India. Clear? Next one, we have general norms applicable to arbitrator. If you are acting as an arbitrator, what are the conditions to be satisfied by you as an arbitrator? What is the first one? Are bolo, you should be a person of what reputation? Strong reputation, fairness and integrity. Obviously, because you are deciding dispute between the people. Next one, arbitrator must avoid what relationship? Financial relationship as well as what? Conflict of interest. Are bolo, what of interest? The arbitrator should not be involved in any what proceeding? Legal proceedings. Bolo, bolo, proceeding? Legal proceeding. The arbitrator must not have been convicted of any offense involving what turpitude? Moral turpitude or any economic offenses. What offenses? Arbitrator must be well versed in the what range of principle? Legal principle. Arbitrator must have what? Comprehensive understanding of both domestic as well as the international legal system. He should be having an ability to draft a reasoned decision. What decision? Means you have to provide a reasons for a decision, right? Yes or no? These are the attributes of whom? Arbitrators. Attributes of whom? Arbitrators. Yes or no? Next one. Foreign award. What award? What is foreign award? Where one of the parties to the dispute is called as what? Where one of the party. Or in case of international commercial award, arbitration, award given by a tribunal, it is called as what? Foreign award. What award? Can foreign award be challenged? Can the enforcement of foreign award be challenged? Yes. And what grounds? The same grounds. What grounds? What is the first one? Incapacity. See, Award given by the one tribunal of a nation can be enforceable in the other nation based on the treaties. Based on what? Treaties. We have a Geneva Convention where the award given by one nation may be enforced in one nation, other nations. Correct, right? So a person has to apply to the court to enforce the award given by the foreign arbitral tribunal with necessary documents. And that application to enforce the arbitral award can be challenged on the what grounds? Following grounds. What grounds? What is the first one? अरे बोलो ना, incapacity of parties to the contract. Second one, agreement is invalid under the applicable law or the law of the country where the award was made. The party against whom the award is invoked was not properly notified of the appointment of the arbitrator or the proceedings. Next one, the award addresses issues not covered in the what agreement? Arbitration agreement. What agreement? Next one, composition of the arbitral tribunal or the procedure was not in accordance with the what agreement or the law of the country where the arbitration took place. The award has been set aside or suspended in the country when it was made. If the subject matter is not arbitrable under the Indian law, the award is contrary to the what policy? Public policy. What policy? Difference between domestic award and foreign award. What is the difference? Foreign award required to be enforced by separate application, but domestic award there is no requirement of separate execution of the award. A party seeking the enforce a foreign award has to make an application for the award. Same domestic award can be set aside, but a foreign award cannot be set aside. It can be either enforced, may not be enforced. That's it. Indian code does not have a right to set aside a foreign award. What award? Foreign award. Differences. Next, we have conciliation. What do we have? What is conciliation? Conciliation is the successfulness of conciliation depends upon how far the parties are ready to reconcile with their dispute. And conciliation is successful only when both the party agrees to it. An independent party will frame the solution and he will offer it to the party. If both agrees, it will successful. Otherwise, it will fail. So conciliation is what? It depends upon how far the parties are ready to reconcile. Parties are ready to what? Reconcile. Correct? That is called as what? Conciliation. Called as what? A independent party or impartial party, after hearing both the parties, draft a solution. And when that solution is accepted by both the party, conciliation is what? Successful. Okay, let's start. What is conciliation? Non-binding procedure where an impartial third party, known as the conciliator, assists the parties to the dispute in reaching a mutually agreed settlement of the dispute. Conciliation means settling of dispute without any what? Litigation. Conciliation proceedings initiated by which party? One party by sending invitation to whom? Other party. Conciliation proceedings are commenced when the other party accepts the what? Invitation. Accepts the what? What if it does not accept? No conciliation, or if it does not respond within how many days? 30 days. We can presume that he has rejected our invitation. We cannot presume acceptance, but we can presume what? Rejection. The time limit 30 days. There shall be one conciliator unless the parties agree. There shall be two or three conciliators. Conciliators can be what? Even it can be a even number. What number? Even number. Conciliator may invite whom? Parties to meet him. Parties to what? Meet him. Next one. After receiving the observations of the parties, the conciliator may reformulate the terms of the possible settlement in the light of what? Such observations. Settlement agreement signed by the parties is final and binding on the parties and person claiming under debt. Correct, right? Once it is signed by both the parties, the conciliation is binding on both the parties. Termination of conciliation. A conciliation comes to an end in the following cases. What cases? What is the first one? By the parties. Second one, that conciliation is no longer justified. If there is no, for example, subject matter is destroyed, then he can give a declaration that conciliation is no more justified. Next one, Written declaration of the parties to terminate the proceeding. Both are saying that will not go for conciliation. Last one, by written declaration by one party to whom another party that conciliation proceedings to be terminated on the date of what? Declaration. Date of what? Next, we have mediation. What is mediation? Where an independent party offers or try to mediate or facilitate communication between whom? Parties to the dispute. What are the dispute? Parties to the dispute. Mediation is a process by which mediator facilitate the resolution of dispute between the parties applying the mediation rules. What rules? Mediation rules. Features of mediation. Mediator facilitate discussion directly between the parties. Correct, right? Second one, the mediator communicates with the parties on their behalf to foster the what? Understanding. I will communicate uh, whatever one person says, I will communicate the same to whom? Other person. But I will facilitate direct communication or talk between both the parties. Next one, mediator assists the parties in what? Identifying the issue at hand, reducing the what? Misunderstandings, clarifying the priorities, exploring the areas of compromise, generating the options to resolve the dispute. Mediation is voluntary, party centered, and structured negotiation. For negotiation, structured negotiation. Types of mediation, court referred mediation. There are few cases where court can refer the parties to where? Mediation. Second one, law itself mandates that mediation is compulsory. For example, divorce cases. What is compulsory? Mediation is compulsory. Next one, private mediation. What mediation? Where a private person mediate between the parties. What is online mediation? Which happens through online. It is called as what mediation? Online mediation. Next one, merits of mediation. They may ask this question in the examination. What are the merits of mediation? Quick and responsive. Second one, economical. Third one, there is no extra cost. Fourth one, harmonious settlement. Fifth one, creating solutions and remedies. Sixth one, confidential and informal. It is informal, right? Last one, parties controlling the proceedings, controlling the war proceedings. Difference between mediation and arbitration. Mediation and what? Neutral party aims to assist the parties. It is called as what? Mediation. Correct, right? Mediation is, sorry, arbitration is like what? Litigation. But mediation, a third party or independent party assist parties to reconcile their dispute. Mediation is more of what nature? Collaborative in nature. What nature? Collaborative in nature. Arbitration is what? Adversarial. Means one party will win, one party will lose. But in case of mediation, win-win situation. Both will lose or both sides. Both will win. Which one is more informal? Which one is more formal? The outcome in a mediation is controlled by what? Parties. But arbitration is controlled by whom? Arbitrator. In mediation, the dispute may or may not be resolved. But arbitration, it is always resolved. Clear with this? Understood? Next, gist of case studies. What studies? I have given the gist of case studies are the important principles of the case study. What is the first one? Dispute about the fees could not serve as a valid ground for terminating the what? Tribunal's mandate. Arbitral tribunal is claiming 1 lakh, but parties are saying no, will not pay 1 lakh. Because of this dispute, can the mandate of arbitrator be terminated? No. We discussed that when the termination of mandate happens, either if he is de jure or de facto disqualified, then only there will be a termination of mandate of an arbitrator. Next one, a general reference to the terms and conditions of another contract does not automatically incorporate the what clause? Arbitration clause. You have to mention specifically that the arbitration clause shall be part of which clause? The subcontract. What contract? Subcontract. Correct, right? Third one, the doctrine of competence is intended to minimize the what? Judicial intervention. What intervention? You cannot go out to the court directly to decide that the tribunal has jurisdiction or not. You first apply to whom? Tribunal itself. Otherwise, for everything, if you go to court, it is same like litigation only now. So to minimize the intervention of the court, there is a concept called as what? Competence, where tribunal itself will decide whether it is competent or incompetent. Competent or what? Incompetent. Next one, the involvement of non-signatory party must be substantial. Must be what? Substantial, direct, and not just incidental for it to be considered bound by the what clause? Arbitration clause. What clause? Arbitration clause. Next one. Some directed by the award must carry a interest in the date of what? Award until the realization regardless of the contract. How much extra? 2% extra than the current market rate. Clear? So these are the provisions with respect to what? Arbitration, conciliation, and mediations. Are we clear with this? Tell me which section number provides the interim measures? Section number 9 and 17. Which section number provides that the court shall refer the parties to arbitration? Section number 8. Can we challenge that award given by the arbitral tribunal if the parties are incompetent, against the public policy, invalid arbitration agreement outside the jurisdiction of the arbitral tribunal? Correct, right? Clear with this? That does cost includes expenses of the arbitration? Yes or no? Regime for the cost. Tell me within how many months the tribunal shall give the award? 12 months. Fast track arbitration? Is it extendable? Yes, 6 months. Clear? Let's solve the questions asked in the previous examination. Focus everybody. Let's solve. First one. चैप्टर नंबर क्या है? चैप्टर नंबर 11. हाँ. Define the terms arbitration and conciliation. The code. Can you define what is code? International commercial arbitration. Four categories of persons, international commercial arbitration. Yes or no? Direct question. What question? Direct question. Most of the question they ask in arbitrations are direct questions only. Suit cannot be submitted to where? Arbitration. Ram and Sham. Read no. Ram and Sham. Can you can you refer the dispute of will to the arbitration? No. Will is outside the scope of what? Arbitration. Testamentary instrument discuss किया था ना हम लोग. Next one, types of arbitration. What is the first one? No arbitration, not administered by the arbitral institution. Correct. Arbitration agreement. Can you write about arbitration agreement? Should be written from exchange of letters, telegrams, all those things. Power to refer the parties to the arbitration. In spite of arbitration agreement, if one of the party refuses the case to judicial authority, then can such judicial authority have the power to refer back parties to the arbitration? Read the question. There is an arbitration agreement, but party has gone to the court. Can court send him to the arbitration? Yes. On the request of which party? Other party. Next one. Ajay and Vijay make an agreement in writing to refer a dispute between them to an arbitrator for determination. In spite of this agreement, Ajay files a suit against Vijay relating to the dispute in a court. Advise Vijay. Can you write the provision? Next one. Interim measures by whom? Explain the provisions for obtaining the interim relief from the court when there exists an arbitration agreement among the parties. Within how many days you have to initiate the arbitration proceedings? 90 days. How many days? Number of arbitrators? Can you read this question, practical question? A and B enters into an arbitration agreement under which sole arbitrator is to be appointed by consent of both the parties. When B refuses to concur in the appointment of the arbitrator, what courts is available to A? Apply to whom? Arbitral tribunal, not arbitral tribunal. High Court, Supreme Court, or designated institution. They will do appointment within how many days? 60 days. Grounds of challenge of an arbitrator, impartiality and independence, and does not possess the what? Qualification. अरे हाँ है ना challenge procedure how it is to be done within how many days you have to challenge it within 15 days of coming to the knowledge of any disqualifications or incompetence of the party. Failure or impossibility to act when a person is impossible to act as an arbitrator, de jure or de facto disqualification. Place of arbitration. Read this case study, everybody. Important. Read. In this case, the parties have agreed. This is based on case study, okay? But the question is not clear. The case is clear. What happened in this case was parties have clearly agreed that the place of arbitration should be what? Orissa. So if the parties have agreed the place of arbitration as Orissa, which court has jurisdiction? Orissa court has jurisdiction, not which court? Madras High Court. Correct, right? Uh-huh. Uh-huh. That is what. There is no that point. But for that you have to refer the case study. This question is there in your ICSM material. However, the fact that it is agreed that Orissa is not there, that is there in the case study. But what is the question says? Decide whether the Madras High Court is justified appointing. This is based on a one case called as fertilizers case. There is one case in your material. Triveni something case is there. Based on that only this question has been asked. Default of the party. What happens if there is a default of the party in submitting the statement of claim and statement of डिफेंस स्टेटमेंट ऑफ व्हाट डिफेंस डिस्कस किया था ना हम लोग एक्सपर्ट अपॉइंटमेंट ऑफ एन एक्सपर्ट fees and all those things decision by panel of arbitrators majority time limit for award fast track procedure termination of proceedings how termination happens correction of an interpretation of award and including the additional award setting aside what arbitral award enforcement of which award foreign award on what grounds you can challenge the enforcement of the foreign award conciliation short note on what conciliation proceedings ADR alternate dispute resolution process clear with this yes or no so with these we are done with what arbitration mediation and conciliation most of the questions asked were simple question direct questions clear understood अब हम शुरू करेंगे next chapter which one lesson 12 the Indian stamp law what law Indian stamp law this Indian stamp law deals with what Levy of stamp duty. Levy of what? Stamp duty. Important chapter. Stamp duty is a revenue for the government. What for the government? Revenue for the government. Revenue for which government? State government. What government? Let's discuss type of stamp paper. Types of what? Stamp paper. Stamp paper is the paper or the document which is used for the purpose of what? Executing a contract. Executing a what? Contract. So that is the way in which what duty is paid? Stamp duty is paid. So we can classify the stamp papers into how many categories? Three categories. How many categories? Three categories. See, we have the provisions with respect to law making power. What making power? Law making power. With respect to stamp duty, we have a union list, state list, concurrent list that I will discuss with the help of the question bank. With the help of what? Question bank. Let us directly jump into what? Types of stamp paper. Types of what paper? What paper? Stamp paper. What paper? Stamp paper. What are types of stamp paper? What is the first one? Judicial stamp paper. You know what stamp paper? Judicial stamp papers are used to pay what fees? Court fees or the legal fees. Then we have non-judicial stamp paper. Have you seen if you have been to the court, when you submit a document, they give this affix thing, like they give us this adhesive stamps. What stamps? Adhesive stamps, which are used to pay the stamp duty to the court. What duty to the court? Stamp duty to the court. That is called as what paper? Judicial stamp paper. Then we have non-judicial stamp paper. What is non-judicial stamp paper? It's a legal and business purpose outside the court proceedings, outside of the court proceedings, outside of the what proceedings? Court proceedings. Correct, right? Types of non-judicial stamp paper. What are the types of non-judicial stamp paper? Adhesive stamps. What stamps? These are the convenient labels which are can be affixed in a document to indicate that what is paid, stamp duty is paid. For example, when you write a letter, you use what stamps? Adhesive stamps. What stamps? Next one is what stamps? Impressed stamps. What stamps are? What is impressed stamps? The stamps which are embossed or engraved on the paper. It is called as what? Impressed stamps. We used to call them as chapa kagam. Correct, right? We used to write in the stamp banks, right? Correct, right? Printed papers. What papers? Printed papers. Next one is franking of stamp duty. What of stamp duty? Franking. What is franking, sir? In the sub-register office, there is a franking machine. What machine? So if you want a document to be stamped, you can go with the stamp paper. What sub-registrar will do after he collects the stamp duty, he will frank by using what machine? Franking machine, stating that the stamp duty has been paid. What has been paid? Stamp duty has been paid. That is called as what? Franking of what duty? Stamp duty. Next one is e-stamp paper. What stamp paper? What are e-stamp paper? The stamp paper which are used pay what duty? Stamp duty. This is the electronic stamp paper. Nowadays, we have the Stock Holding Corporation of India. What Corporation of India? Stock Holding Corporation of India, which is entrusted with the work of issuing the what? E-stamp paper. It is the convenient one. We can prevent the frauds because they are serially numbered. There is no chances of what? Creating a fake stamp papers. Correct, right? Yes or no? These are the non-judicial stamp papers. What is the first one? Adhesive stamp. Second one, impressed stamp. Third one, franking of stamp duty. Fourth one, e-stamp paper. Follow what stamp paper? General principles governing the what duty? Stamp duty. What duty? Stamp duty. Important. What is the first general principle? Stamp duty is levied on the what? Instrument itself. What itself? That is the document itself, not on the based on the what? Transaction covered. What covered? Next one, the substance or real nature of the transaction dictate the stamp duty, not the title. Not the what? Title. You may give any title, even though it is a mortgage. You may call it as lease. But what is the stamp duty payable at us? Mortgage. You may give any description you want. We take into consideration substance of the contract for the purpose of payment of what duty? Stamp duty. What duty? Do you take into consideration the description or substance? Description of the substance, substance of the what? Contract. Substance of the what? Contract. The valuation for stamp duty. Valuation for what duty? Stamp duty is based on the what? Document itself. What itself? And the content stated therein, not any external evidence. What evidence? External evidence. Law presumes whatever mentioned in the instrument is correct, unless the contrary is proved. Fourth one, stamp duty is determined based on the what? Law enforced at the time of execution of what? Instrument. The rate of stamp duty will keeps on varying. Recently, state of Karnataka increased the rate of stamp duties. Rate of what? Stamp duty. Stamp duty is payable on MOA, AOA, partnership rate. So agreements come under whose jurisdiction? State government jurisdiction. State is the one who prescribes the rate of stamp duty. Rate of what duty? Stamp duty. And the partnership agreement may stamp duty to whom? State government. What government? Clear with this? Yes or no? Next one. The schedule specifies the stamp duty rates are what? Integral part of what act? Stamp Act. Which act? Stamp Act. This is one is important. Instrument chargeable with what? Duty. Section number 3 is the charging section. What section? Charging section. Listen everybody. Which instruments are payable with stamp duty? First one. Every instrument. What instrument? Mentioned in which schedule? Schedule 1 of the Act, which is executed where? In India. Stamp duty is payable or not payable? Payable. Next one, every bill of exchange. Below, every bill of exchange, promissory note, drawn or made out of India, but accepted or paid or presented for negotiated where? In India. Negotiated where? In India. What is payable? Stamp duty is payable. Correct, right? It is the first one. Every instrument mentioned in Schedule 1. Mentioned in where? Schedule 1 and executed where? In India. Next one, every bill of exchange or a promissory note drawn or made out of India. Made where? Out of India, but accepted or paid or presented for negotiation where? In India. What is payable? Stamp duty is payable. Even though it is made outside India, but it is accepted, presented, or negotiated in India. What is payable? Stamp duty is payable. Next one, any instrument. What instrument? Any instrument other than a bill of exchange, promissory note, executed outside India. Executed where? But relating to a property or services situated or rendered in where? India will be subject to what duty? Stamp duty. Correct? Right? It is executed where? Outside India, but it relates to the property where? In India. Stamp duty payable or not payable? Payable. However, there are certain instruments on which stamp duty is not payable. What is the first one? The instrument which involves the sale, transfer, or disposition of what? Ships or vessels. Second one, instrument in favor of whom? Government or by the government on behalf of the government. Next one, any instrument executed by or on behalf of developer of what check? What zones? Special economic zones. What zones? Special economic zones. Important day based on this, they may ask questions in the examinations. Are you guys clear with this? Which instruments are chargeable with stamp duty? Which instruments are not chargeable with what duty? Stamp duty. Clear with this? Next one, substance and description. What should be considered? You tell me what should be considered. Substance of the instrument should be considered over the what? Description. Anybody may come and say anything. Ultimately, what prevails? The substance. Correct, right? Yes or no? Content prevails. What prevails? Content prevails. Correct, right? When it comes to stamp duty, you will look into the what? Substance of the instrument. What of the instrument? Substance of the instrument, not the description for the purpose of payment of what duty? Stamp duty. Courts have held the principle of substance of the transaction over the form. Over the what? Form. In the matters of deciding the nature of the what? Instrument. The substance of the transaction contained in the document may not necessarily embody the description given in the what? Head thereof. Correct, right? Substance may be different, heading may be different. You will consider what? Heading or substance? Substance. Heading or substance? Substance. In determining whether the document comes within the description of a document upon which a stamp duty required by the Indian Stamp Act, one has to look at the what? Entire document to find out whether it falls within the description. Where a single instrument contains several purposes, the instrument as a whole should be read to find out the one dominant purpose. What purpose? To determine whether a document is sufficiently stamped, the court must look at the what? Document itself as it stands. Next one is important. I will only discuss the brief provision. In the class, we already discussed the various examples. What example? Various example. Now, exams are near. In the class, we have discussed all the examples, but now this is not the right time to study all the examples. I will tell which examples are important from the examination point of view, and those examples are already there in the question bank. Which one? Question bank. Understand the concept, read those examples, ready for the examination. Section number क्या है? Next one. Single transaction. What transaction? Affected by what instrument? Several instrument. Single transaction, several instrument, principal instrument, charged with what duty? Stamp duty. What duty? Other instruments are charged with what? Nominal duty of how much? 1 rupee. Clear with this? Let's read the provision. In case of sale, mortgage or settlement, you have to read this word. Sale, mortgage, settlement. SMS. What is that? SMS. What is SMS? Sale, mortgage, settlement. If there are what instrument? Several instrument. For what transaction? Stamp duty is payable on what? Only one instrument, and the other instrument, what duty is payable? Nominal stamp duty of 1 rupee is payable. How much is payable? 1 rupee is payable. Clear with this? Yes or no? Next one. Instrument relating to what matter? Several distinct matter. One instrument, several distinct matter. In that situation, you're supposed to pay stamp duty on the aggregate of what? All the transaction. What transaction? All the transaction. Correct, right? Section number 5 of the Indian Stamp Act provides that if one instrument relates to several distinct matter, stamp duty payable is the aggregate amount. What amount? Aggregate amount of the stamp duty payable on a what? Separate instrument. One instrument? For example, it's a mortgage as well as sale. You will calculate the stamp duty on the sale as well as the mortgage, and you'll pay what duty? Aggregate stamp duty. What's duty? Aggregate stamp duty. Yes or no? When several matters are covered in a single document, it is called as what? Multifarious instrument. What instrument? Multifarious instruments. Clear with this? And we have some definition in the ICSI material. Those definitions, whatever I find it important, I have given in the question bank. Which bank? Question bank. Refer to that. Are you guys clear with this? Next one. Next one. Instrument coming with what? Several description. What description? If same instrument is ambiguous, it can be treated as promissory note or a bill of exchange. In that situation, you will stamp it as what? Bill of exchange or promissory note. Yes, whichever for whichever there is a what duty? Highest stamp rate. Correct, right? If a single instrument come under the several description, then the stamp duty payable is the highest of the stamp duty payable for the any of the instrument. Correct, right? The rate will be highest one. Correct, right? Let's read. Instrument can be categorized under more than one item. In Schedule 1, the instrument is only chargeable with the what highest stamp duty that would apply. That would what? Apply. Are you guys clear with this, everybody? Next one, section number 9A. Important, 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 important. The ICA must ask the question based on this concept. Why? Because these are very much practical. Once you become company secretary, you're gonna pay stamp duty on the share side. Yes or no? Yes. Let's start section number here. 9A deals with what? Transaction through what market exchange? Stock exchange and depositories. First of all, sale of securities, sale of through what? Stock exchange and depositories. If you sell shares in the stock exchange, are you liable to pay stamp duty? Yes. Stamp duty on sale transaction collected by whom? Stock exchange or clearing corporation. What corporation? And paid to whom? State government. Paid to whom? Stamp duty is levied on the market value. What value? Payable by seller or buyer? Buyer. Buyer or seller? Buyer. Clear with this? Sale of sales or securities in the stock exchange. Who collect the stamp duty? Stock exchange and the clearing corporation, and payable by who? Buyer. And what value? Market value. What value? Second one. Securities transferred off market. What market? The depositories collects the stamp duty from whom? Transferor. From whom? If your shares are not listed, shares are what? Not listed. But they are dematerialized. They're what? If depository is there, then what you can do? Who will collect the stamp duty? Depository collects the stamp duty from buyer or seller? Seller. Share market? Off the market? Seller. Who collects it? Depository. The stamp duty is calculated on the consideration amount. What amount? Consideration amount. Next one, issue of securities, private placement, EIPOs. Who makes the payment of stamp duty? Company. Who makes the stamp duty? Company. Stamp duty is collected by the depository and the market value of securities. The issuer of the company is responsible to pay what duty? Stamp duty. Yes or no? Exemptions and additional provisions बहुत ही important है बहुत ही important है Have you heard about IFSC? What is IFSC company? International Financial Service Center. What are IFSC companies? What are IFSC companies? IFSC companies are the companies which are established in the IFSC center. There is only one IFSC center, Gift City. इसमें बहुत सारा companies है. For example, we have Zerodha. Even Zerodha has a branch in Gift City. So companies which are established in IFSC center are called as IFSC company. IFSC is different. IFSC means what? International Financial Service Center. That is a center. It's a hub. It's a SCZ location like RMZ. We have RMZ, right? We have this Manatha Tech Park. What park? Manatha Tech Park. Manatha Tech Park is also a company, but in that there are so many companies. Those are called as Tech Park companies. The companies which we established in IFSC center are called as what companies? IFSC company, IFSC private company, IFSC public company. होता है ना IFSC private company, IFSC public company. ऐसा no. But in India we have only how many IFSC? One IFSC. Gift City, Gujarat International FinTech City, which has the robust. It's for financial companies. One who provides the finance, the loans to the various global financial institutions. Okay, the advantage of establishing a branch or company in IFSC center is, see, IFSC center means you're not registered in the IFSC. You will have registered office in IFSC. You are called as IFSC company. If you have a place of business where IFSC, you must have a place of business in IFSC. Your registered office, if you are IFSC company, what company? You must have registered office where? In IFSC center. That is Gujarat FinTech City. Are you guys clear with this? And any IFSC, the transaction occurring in the what? Stock exchange. We have Gift Nifty. Have you heard the word Gift Nifty? If you do transaction in Gift Nifty, there is no stamp duty payable. There is no what duty payable? Stamp duty is payable. Correct, right? International Financial Service Center under the Special Economic Zone Act 2005 are exempt from what duty? Stamp duty. Bonus shares, obviously, who will pay stamp duty on bonus shares because they are issued at what? Free of cost. There is no consideration. Yes or no? Next one, transaction otherwise then through what exchange? Stock exchange. What exchange? Means if the shares are not dematerialized. In that situation, the stamp duty is payable by whom? Issuer. Payable by whom? Issuer. The stamp duty is payable at a place where the issuer has what? Registered office is located. What is located? Registered office is located. Follow what is located? Registered office is located. Yes or no? Stamp duty is payable. What is payable? Stamp duty. Issuer or buyer? Issuer. Stamp duty is payable. What is payable? Stamp duty is payable at the place where has one registered office. What office? What if I have a registered office in Gift City? Am I supposed to pay stamp duty? No, because I am exempted from payment of what duty? Stamp duty. IFSC company must be limited by shares. Limited by what? Shares. It can't be a guarantee company. What company? Guarantee company. Next, in case of transfer of securities, below what of security? Stamp duty is payable by whom? Seller. Payable by whom? Seller. The duty is calculated on the consideration amount specified in the what? Instrument. Specified in the what? Instrument. Yes or no? Clear with this? This is with respect to payment of stamp duty. Payment of what? Stamp duty. Next, we have valuation of stamp duty. Valuation of what? How the stamp duty is valued. The money is expressed in the currency other than Indian currency. Other than what currency? Indian currency. Converted to what currency? Indian currency. Next one, if it is in the stock market, taken to what value? Market value. What value? Market value. If the price or value mentioned in the instrument, it is presumed to be what? Correct. Interest mentioned in the instrument, you have to calculate the stamp duty as if interest is not mentioned. You should not include the interest amount. What amount? Interest amount. For the purpose of calculation of what duty? Stamp duty. I promise to pay you 1 lakh rupees, the interest of 10%. On what value stamp duty is payable? 1 lakh. Not on the interest amount of 10%. Correct, right? Next one. Next one. Transfer of property for what you? Debt due. What you? I am liable to pay you 1 lakh rupees. I am giving a property worth of 2 lakh rupees to you, and you are paying only 1 lakh rupees to me. But what is the consideration for the sale of property here? 2 lakh rupees. setting off of the debt plus 1 lakh rupees extra consideration. That is what is the value of the property now? 2 lakh. And that I'm supposed to pay what duty? Stamp duty. What duty? The debt is considered as a part of what? Consideration for the transfer of property. Stamp duty in case of what? Annuity. What is annuity? Payable every year. Payable what? Every year. Payment is a definite period. What period? Calculation on the what? Total value. If the payment is perpetuity, only for how many years? 20 years. How many years? Mining lease. What lease? Is calculated on the estimated value of what? Royalty. What value of royalty? Estimated value of the royalty. Yes or no? Next one, use of what stamps? Adhesive stamps. What stamps? Adhesive stamps. Following instrument may be stamped by with what stamps? Adhesive stamps. What are they? Instrument on which stamp duty payable is less than how much? 10 paisa. And bill of exchange and promissory notes made where? Out of India but accepted in India, are endorsed in India, are payable in India. Next one, entry as a what? Advocate in the role of advocate. Next one, notarial acts. Next one, transfer by way of what? Endorsement. Endorsement. Next one. Cancellation of what stamps? Adhesive stamp. Otherwise, somebody will stick and remove and use it in other stamp paper, right? इसको cancel करना पड़ेगा. कैसे cancel करना पड़ेगा? ऐसे cancel करना पड़ेगा. Either by drawing a what? Cross lines or by putting a signature or putting a what? Signature. Purpose of the cancellation is that stamp duty shall not be used again. Shall not be what? Used again. If a person fails to cancel the stamp duty, is he punishable? Yes. Valid modes of cancellation, writing his name or initials, drawing a lines across it, drawing a diagonal lines, or cross mark. What mark? Cross mark. Yes or no? Invalid modes of cancellation, possible to use a stamp in what time? Second time. It is called as what? Invalid modes of cancellation. Next one, denoting duty. What duty? Officially recording or acknowledging the stamp duty has been paid on what? Document. It is called as what? Denoting duty. What duty? Where several instruments are used for executing a single transaction, party can produce all the instrument, and what collector will do? He will certify or he will denote on the instrument that what is paid, stamp duty is paid. What is paid? That is called as what? Denoting duty. What duty? Denoting duty. What duty? To avoid this, the concerned party must submit a written application to the collector stating that the duty has already been paid on the what instrument? Primary instrument. The collector will then endorse the duty paid or exemptions on the what instrument? Primary instrument. What instrument? Primary instrument. Time of stamping of instrument important. If an instrument is executed in India before or at the time of what? Execution. If the instrument is outside India, within how many months of arrival in India? 3 months. Or how many months? For delay due to accident. Bolo. Delay due to accident or a mistake or urgent necessity, collector may extend the what? Time up to how many years? 1 year. How many year? 1 year. If the document is presented after 1 year, after how many year? 1 year. From the date of execution, it should be what? Impounded. Maximum how many year? Only for what instrument? Foreign instrument means instrument executed outside India. There's a time limit of 3 months. Indian instrument should be on or before execution of instrument. Execution of what? Instrument. Next one, examination and testing of instrument. See, stamp duty is the revenue for the government. So, whenever an instrument comes before any public authority, it is the duty of the public authority to examine that instrument to check whether the proper stamp duty has been paid or not. If not paid, they have to what? Impound the instrument. The purpose of collection of what? Stamp duty. Collection of what duty? Stamp duty. Seizing the document that has not been properly stamped but does not comply with what requirement? Legal requirement. It is the duty of the court or the public officer to examine every document produced to ascertain whether it has been duly stamped. The main object is to protect the what? Revenue. The government. Proceeding after impounding of instrument not duly stamped, if it is admitted as a evidence, court admitting the self sent to collector what? Authenticated copy of the document, certificate stating that amount of duty and penalty has been collected and the amount recovered. All these things to be sent to collector. If not admitted as an evidence, the original document shall be sent to the collector for levy of what duty? Stamp duty. What duty? Stamp duty. Are you guys Clear with this. Next one, admissibility of instrument, not duly stamped, correct? Not duly admissible, not admissible, not admissible. However, after it is stamped, it is admissible. If an instrument is not duly stamped, shall not be admissible as evidence. An instrument is not valid. It's not an invalid document. It can be admitted in the evidence on payment of what? Penalty. What is the penalty? 10 times the difference amount. How much? 10 times the difference amount. The following cases, important cases where instrument is admissible as what? Evidence. Admissible as what? Evidence. What is the first one? Criminal. Second one, receipt on payment of penalty. How many times? 10 times the difference amount. Next one, instrument executed by or on behalf of whom? Government. Document certified by whom? Collector. Unduly stamped by accident. Unduly stamped by what? Accident. These instrument, all these what? Instrument admissible as evidence. Recovery of stamp duty not levied or short levied. If it is not levied by mistake, within 5 years can be recovered. If it is because of fraud, collector will have how many years of time? 20 years of time. E-stamping, you know what is e-stamping, right? Collection of stamp in the electronic way. Benefits of e-stamping, less time consuming, easily accessible, cost saving, stamp certificate generated is tamper proof, e-stamp certificate generated as a unique identification number, easy accessibility, security, cost saving, and user friendly. Correct, right? Last one, adjudication of what duty? Stamp duty. I have an instrument. I'm not sure about how much stamp duty is payable. What I can do? Go to the collector. He will decide. I will pay stamp duty. Stamp duty is paid. No headaches. Correct, right? That is called as what? Adjudication of what duty? Stamp duty. Adjudication of what duty? Okay. And for adjudication, you must present to the collector within how many months? 1 month. Outside India, 3 months. Instrument is a promissory note, bill of exchange, instrument subject to a duty of 10 naya paisa or less cannot be endorsed by adjudication. If it is 10 naya paisa, do you think collector has so much of time to adjudicate on a matter on which 10 naya paisa is payable? This paisa is no more invalid. The law should be changed. It is 1999. We are in which era? 2025. This law has to be changed. Correct, right? At least the syllabus has to be changed. Just to include only those provisions which are relevant for the current trend. 10 naya paisa. Anyway, I'm recording so बच्चों क्वेश्चन सॉल्व करेंगे ओके देयर आर फ्यू थिंग्स व्हिच आर नॉट कवर्ड इन द व्हिच चैप्टर चैप्टर नंबर क्या है 12 अमूल्य क्या हो गया बेटा आपको अब ठीक है I will not read okay you guys solve it yeah read doesn't mean I'll leave you guys read first question define the expression of bond Darshan a bond का question important है they may ask you to define the bond it is there in the ICSM material. So can you and this question either they may ask theory question or they may ask practical question based on bond based on what bond in bond there is a promise to pay what to pay promise to pay so what is bond includes any instrument whereby a person obliges himself to pay the money to whom another on a condition that obligation shall be void if a specified act is performed. If I perform that, then I will not pay. Otherwise, I'm supposed to pay. It is called as what? Bond. Same like bail bond. What bond? If I clear then this void, otherwise I will pay the agreed amount of money. Bond hai. Next one. An instrument attested by the witness not payable to order or bearer, whereby a person obliges himself to pay the money to whom? Another person attested by the witness not payable to order or bearer. Order or what? Bearer. An instrument so attested whereby person obliges himself to deliver a grain, food. Food grain होता है ना? Ragi wheat. That is also what? Bond. That is also what? Bond. It does not include what? Debentures. Does not include what? Debentures. Are you guys clear with this bond? Can you guys read the practical example, please? Read example. He executes an agreement in favor of what? C, by which he promises to repay a loan taken by him from whom? C. Discuss whether this is an agreement, a promise to a bond. It's a bond because it is given under the bond. Definition of keep this example. Based on this, they may ask question in the exam. Important, important, important. Question number one, पढ़ाई करना ही पड़ेगा हमको. हाँ? Example, be executed. If you read two or three more times, it will be there in the subconscious memory. It will come. It automatically relates. Our brain is to see. I am giving so many examples. I am giving evidence, Constitution of India. Do you think I'll remember everything? I'll be teaching CA Foundation now, Contract Act, Sale of Goods Act, Partnership Act. There I have to give a different examples. Then I have come to the IPC, CPC, not IPC, BNS, BNSS, BSA. Once you read, one or two times you read, it will be there in subconscious memory, and you can interpret and you can give the exam. Right, right. That's your brain. Define the word. Some bill of lading. Bill of what? Lading. Bill of lading. हम पढ़ाई किया bill of lading. अरे इस that comes in taxation ना. Bill of lading. Customs. When you load the goods to the ship, the captain of the ship gives a bill of lading, appraising that you have received the goods and deliver at the destination. That is called as what? That is what I said. Did I say anything wrong? I said customs only. You skipped it. Keep skipping it. Skip that. Okay, very good. Bill of lading. Next one, lease. Lease includes patta, kabuliyat, instrument of by which tolls of any descriptions are let. Distinguish between executed and execution. Executed means signed, execution means at the time of execution. Means it is still in the process of execution. Conveyance A important, important, important. Question number 6 is important. I expect them to ask question based on this. Is an agreement for the sale of goods is a conveyance? Yes. See, conveyance means transfer of ownership. It can be both movable as well as what? Immovable. So, sale of goods is a what? Conveyance. They may ask this question in the exam. ठीक है नेक्स्ट वन लेजिस्लेटिव पावर मैंने बोला था ना दिस कॉन्सेप्ट आई कवर इन द क्वेश्चन बैंक व्हाट वाज क्वेश्चन बैंक दे कैन आस्क दिस क्वेश्चन कैन अ पार्लियामेंट इंक्रीज और डिक्रीज द स्टैम्प ड्यूटी ऑन द एग्रीमेंट नो so increasing or decreasing the stamp duty and agreement is a what subject state subject only who can do it state government can do it however parliament can make a law bring a uniformity in all the instruments. For example, commercial instrument like promissory note, bills of exchange, sale certificate, and that who can make law? Parliament can make law. But agreements, adoption deed, sale agreement, partnership agreement, LLP agreement, MOA, AOM, prescribes the rate of stamp duty. State government is the one who prescribes the stamp duty. Clear with this? Yes or no? Next one. Substance. What do you prefer? Substance or title? Substance. For the purpose of can you elucidate the transaction? Next one. Instruments chargeable with what? Duty. Chargeable with what? Duty. Instruments which are chargeable with duty under which act? In Indian Stamp Act. Section number 3 लिख सकता है क्या? Which instruments are chargeable with stamp duty? Which instruments are not chargeable with stamp duty? Next one. This one. Question number 2. Excuse me. Question number 2. Awais agricultural land was purchased by the government for the purpose. Are Darshan purchased by government. Stamp duty is payable, not payable, not payable, exempted. Okay. Next one. Single transaction affected by what? Several instrument. What instrument? Principal instrument, full amount. Other instrument, 1 rupee. Next one. Ram executed a gift deed of certain immovable properties in favor of his brother Sham. By another deed, Sham made a provisions for living expenses of what? Ram and created a charge in favor on some properties, including the above mentioned gift deed, in the order to secure the payment of living expenses. The government authority insists that deed executed by Sham is liable to full duty. Decide the reason. Are you supposed to pay full duty? No, right? Same transaction, but see, same transaction, single instrument. What instrument? Several instruments, but single transaction. What transaction? Single transaction. What transaction? And the second document is nominal stamp duty is payable at what price? 1 rupee. Correct, right? Yes or no? Yes or no? Next one. Examine with reasons whether the following transactions are exempted under the what? Indian Stamp Act. Read. Payable or not payable? Payable. Second one. Payable or not payable? Payable. Instrument executed by the developer or unit. Example. Scheme of corporation or demutualization are both recognized stock exchanges? No, exempted. Transfer of benefit of ownership of securities dealt with the depository? Yes. Who is liable to pay stamp duty? Seller or buyer? Seller. Issue company. Arre, from depository to depository. Dematerialization, you will not pay stamp duty. Only for transfer, you will pay what duty? Stamp duty. Several distinct matter, you will pay what duty? Aggregate of the stamp duty. Aggregate of what duty? Stamp duty. Example number two, question number two. A government create a lease of property X and also grants a what? Gift of property Y. How is the stamp duty is payable? Aggregate. From both the papers you're supposed to pay stamp duty. Reduction, remission, and compound of what duties? Compound of what? Duties. How is reduction? Who can reduce it? Government can reduce it. A be important. Hmm? Empowers us government to reduce or remit or all or part of duties payable. Who can do this? Government can do this. Types of stamping. Which instrument can be stamped with the what's duty? Adhesive stamp duty. Discuss किए थे ना हम लोग 10 पैसा. Collection of adhesive stamps. Cancellation of adhesive stamps. Cancellation. How it is to be done. Denoting duty discuss किया था. Instrument executed out in India. Within how many months is supposed to pay stamp duty? Array. On or before. On or what? Before. Foreign executed outside India within how many months? 3 months. How many months? 3 months. Of arrival in India. How transfer in consideration of debt are subject of future payment except to be charged. ಇದು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ನ if an instrument is sold as a part consideration of a debt should pay stamp duty and the aggregate value. What value? Aggregate value. Duties by whom payable? Mortgage deed who will pay? Mortgagee will pay or mortgager will pay? Mortgagee will pay. Correct, right? Raise on sorry, the person who execute the instrument. Policy insurance, person who takes the policy. Sale of security to stock exchange, buyer will pay stamp duty. Exchange, stamp duty is payable. Yes, both will pay in what basis? Proportionate basis. What basis? Proportionate basis. Joint owners dividing the property, they should pay the stamp duty in what ratio? Same ratio. What ratio? Joint owners dividing the property. Are we supposed to pay stamp duty? Yes. In what ratio? Same ratio. 1:1:2 ratio. Adjudication to proper stamp. Confused, applying to whom? Collector. He will decide the stamp duty. Examination and impounding of what? Instrument. What happens if it is admitted as an evidence? What happens if it is not admitted as what? Evidence. Next one, instrument not duly stamped, inadmissible in the what? Evidence, inadmissible in the what? Evidence. Next one is evidence. Next one is what? Evidence. Admission of improperly stamped what? Instrument. Can it be admissible? Yes. Next one, e-stamping. What stamping? E-stamping. Payment of stamp duty. How it is done? Process of payment of stamp duty. First, identify the type of document, determine the applicable stamp duty, make the payment of other electronic e-stamp or receive stamps or impressed stamp or this one, franking, execution of document, registration of document. एक पूरा क्वेश्चन सॉल्व करने का ठीक है सो विद दिस वी आर डन विद व्हाट Indian stamp law. What law? Indian stamp law. Important is simple period. Students trying to skip this, but don't skip this. Some have some idea so that you should be in a position to answer all the questions they ask in the examinations. 100 marks pura questions लिखना पड़ेगा. ठीक है. See if you can solve all the previous year question. Worst case scenario. Irrespective of however difficult the examination is, you would be in a position to answer at least 80 to 90 marks questions, if not 100 marks question, if they make difficult. Because we are solving all previous year questions at the same time, you are solving what? Some extra question which are there in the ICSM. Clear with this? Understood? So with these, we are done with what? Indian Stamp Act. Let's start with